morning, good morning, good morning, good morning. Amazing Law Nerd. Look, we have been through trial, and it feels like it has just been the most roller coaster of a trial, even though it's been relatively short. The court said 3 weeks. They had 4 days of jury instruction and started opening statements 2 Fridays ago. It's Thursday, it's September 4th. It's trial day 9. Replay crew, as always, love you. Timestamps are down below. We try not to put spoilers in the timestamps, but spoiler. Today's the day for closing arguments. You know what we don't know? When they'll finish their closing arguments, how long the jury may be out, what themes we're going to see. I mean, from the prosecution, I'm pretty sure we're going to see this train car analogy that they used in opening statement again, where the prosecution is saying, look, Donna to Charlie, Charlie to Katie, Katie to Sigfredo Garcia, and then Sigfredo Garcia to Rivera. They're going to remind the jury of some of the testimony they heard early on in trial. And they're going to highlight the things that I think the defense found the most challenging. The jailhouse informants, the evidence of flight, and the I know I'm next text. And that's what we're going to see the defense argue in closing, I suspect. We're going to see the defense saying there's no evidence that she intended to kill Dan Markel. There's no evidence that she helped plan the first-degree murder. And maybe they'll try to go towards the conspiracy. And yeah, she went over to Charlie's house, but nobody knows why she was there. Who can believe Catherine McBanois anyway? And I think we'll see the defense really focusing on first-degree murder. We heard them at the charging conference talk about the jury instructions yesterday. And so they were going over all of the different jury instructions for the 3 charges and any lesser includeds. Murder in the first degree, conspiracy to commit that murder in the first degree, solicitation so somebody else will commit that murder in the first degree. That's what we're going to see today. The court goes on the record, and then I saw the court give the attorneys a break. So right now they were just at break. So we're going to go to court this morning, see what they put on the record. Remember, this morning, closing arguments. The judge is going to give the jury instructions. I will highlight the elements of the crime as the judge says them, what the jury has to decide. The jury will have those written out for them when they start to deliberate today. The court has allowed each side 2 hours. Jury instructions, prosecutor, defense, prosecutor, rebuttal. I'm sure there will be breaks in between there. Someone will need to do something with technology. And then we know, or at least I suspect, that Georgia Kappelman will be doing the closing for the prosecution. Sarah Dugan did the opening. Which of the defense attorneys is going to do the closing? I'll probably put up a poll as we get into jury instructions and see who you think will be doing the closing. Will they do the same as the prosecution where they switch defense attorneys? One did the opening, one does the closing. Because Mr. Zellman's position of the case seems to be maybe a little different than Ms. Fulford, because she did her opening about what a great person Dan Markel was, and that's not really what we saw in the questioning from Mr. Zellman yesterday. So it's time for closing. Let's just go to court. I'm ready. You're ready. We're ready. Law nerds, let me know where you're coming in from, what you're drinking. I have a cappuccino. Dr. B is also bringing me some coffee. Did my cappuccino spill? Why is my coffee leaking? Oh, that's not good. I'm gonna figure that out. We're gonna roll the intro. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Hey, law nerds, we're going to court. I'm going to mute myself real quick because Dr. B just walked in, and I am going to try to figure out why my coffee mug is leaking from the bottom. So let's hit play on this and hope that the court gives us audio. Because, you know, they've been doing this day by day where the judge is on the record and we see his face facing, but they just haven't turned on the audio yet, and it is incredibly frustrating. Are we gonna have audio, or? There we go.
Principal instruction is proposed as it applies to intent. 777.011 intent to commit the crime, it's in the plain language. Let me start over. So in other words, in order to be a principal, Ms. Adelson had to have a conscious intent that the criminal act be done, and that she did some act or said something intended to and did incite, cause, encourage, assist, or advise the other person to commit the crime.
Dr. B has confessed that he broke my cup yesterday and thought it was fine. Clearly not. It doesn't matter. My favorite cup is still broken. I'm distraught. I am backing up. I know. I am so sad. Well, that explains why it was leaking. Dr. B is coming in here. I'm going to rewind this, but Dr. B is coming in here straight with the not intentionally. Okay. The dragon mug. He didn't put it in the dishwasher. All right, we'll talk about it later. I have to investigate more, but that explains why all of the liquid is leaking through my mug. All right. The defense wants something from the court.
In which the principal instruction is proposed.
Oh, they're talking about the principal instruction. Hold on. This sound is BS this morning. Let me gain this up a little bit because I need this to be gained up a little bit. Thanks, Dr. B. All right, we're gaining up the sound. Let's go to court.
777.011 requires that the intent to commit the crime.
All right, the defense, it came in like literally in the middle of things. And we came in the middle of the defense asking about the principal instruction. Again, this is an instruction that goes at the end of the instruction for the crime. And the lesser includeds.
It's in the plain language. Let me start over. So in other words, in order to be a principal, Ms. Adelson had to have a conscious
Ticky in the
intent that the criminal
chat
act
says
be done,
your
and that
Thursday
she
is
did
Monday.
some
I need to be
act or
it
something
really is.
intended to and did incite, cause, encourage, assist, or advise the other person to commit the crime. Sorry. Removing the intent to commit murder, we believe.
Counsel, I am still mourning my favorite mug. Why in the world do you still have the box fort on your table? I think if I was the prosecution, I would ask that they put them on the ground along the wall. I think I would say they have to take those down. Why are the boxes still there? Ugh.
In the proposed instructions runs counter to that. So specifically,
well, as it relates to the intent to commit the crime, but there does not have to be an intent that a death occurred with either second-degree murder or manslaughter.
I think the way it's
Those are the
written,
lesser
Your Honor,
includeds.
That's my concern with the jury.
Mr. Evans, Ms. Ketterland.
Your Honor, I don't believe that it is. Second-degree murder, it's, I think, because this is from standard instructions, as I recall.
This is.
And so I think it's sufficiently covered because it is not saying that the state doesn't have to prove that the person intended the act. It's simply not necessary the state prove that they intended the death to result from the act. And so I don't think anybody's going to be arguing that. I think the instruction is clear, the standard is clear on it.
I think specifically as to that portion of this matter.
The additional prosecutor came in yesterday to argue jury instructions and is still arguing jury instructions. Yep.
Mr. Zellman, that does crystallize the issue. The state must argue there was intent that the crime be committed, but as far as there being an intent that the victim of the crime actually died, that is not required by second-degree murder.
Just ask Sarah Boone. She spent her whole trial going, but it wasn't intentional. And the court's like, it doesn't have to be. The second-degree murder and the manslaughter were added yesterday as lesser included. The defense said at the end of the day yesterday that they wanted more time to research the principal instruction. That's why we are here talking about this.
As a standalone crime or as a principal matter, the same would apply to manslaughter as well. As to any objection that you wish to raise, I'll allow you to make it now.
Just a moment, Your Honor.
God, there's coffee all over my desk.
Ms. Fulfer is explaining what I'm about to make, what I'm about to request to make sure that our client agrees with that. Your Honor, given the court's ruling on that, we would ask that second degree and manslaughter not be given.
On what basis?
Your Honor.
On the basis that it's bad?
Charging document briefly.
The defense asked yesterday for the lesser included. The defense is now saying, I don't want the lesser included of second degree and manslaughter after the court said, well, intent's not required for those crimes. Like, that is known. That's not a surprise.
As I indicated previously, Your Honor, it's our position that the two sentences at the end of the principal instruction, specifically for second degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. As I indicated, it's a question of intent, and the principal instruction.
The difference between first degree and second degree is intent, counsel. Oh my God, what are we arguing about? This is not new.
Main portion, the defendant intended the crime to occur. I just think it's confusing. I understand the state's position, but under the circumstances, we would request that the court not give those two lessers.
What?
Moment.
As I'm understanding, they're requesting just for count one simply to be guilty of first degree murder or not guilty?
No. Mr. Evans, to omit the lines pertaining to second degree murder and manslaughter and the 3.5 sub A instruction.
No, I don't think that's what they're asking.
Mr. Evans' understanding of our request is accurate. We're asking that the two lessers for count one not be given, and that would eliminate the necessity for those two sentences in the principal instruction.
What is the state's position?
They agreed to the lesser included and asked for one yesterday. So the defense is like, we don't want the lesser included. We agreed to the lesser included yesterday. They wrote the verdict form yesterday. They went over all the jury instructions for the lesser included yesterday, and now he's like, oh no, I don't want those lesser included.
You're talking at the moment, Judge.
Uh-huh.
We're fine with doing away with the lessers.
What?
On this matter, I will need to take a call away from the defendant.
So the prosecution's like, cool, fine, lessers, no lessers, whatever. And now they're gonna ask the defendant. So, Salty Spittoon said the defense, they didn't agree to them. They did. They asked for the manslaughter lesser. They asked to not have the second lesser. The prosecution then asked for the second lesser. And because the lessers are to be given unless both sides don't want them, they asked for the manslaughter one. The prosecution didn't ask for any of the lessers, I think, until the defense asked for the manslaughter one. It doesn't matter now. They're asking for them to be taken out. So there we go. Okay. And they're going to swear in the defendant and ask her about it.
Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first-degree murder?
Yes, that's correct, Your Honor.
Yeah,
In
we know
consulting
it's
with your
correct.
attorneys, you understand the strategy of waiving all lesser-included crimes.
I do, Your Honor.
Is there anything that you need to consult with them further
Okay.
about concerning this matter?
No, there is, Your Honor.
Then you may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
Okay.
Given that, Your Honor, I believe moving.
They're just
to
letting it
principal
ride.
Instructions directly after count one would also be appropriate.
I will remove any reference from second-degree murder and manslaughter in the principal instruction as well.
Mark asked a great question in the chat, and the judge is going to zoom past this and said, how can you just add charges at the last minute? They're technically not adding charges at the last minute, though I realize that me being like, well, actually, that's technically is not super helpful. They are adding lesser included, which means the entirety of that lesser included crime has to be included in the main crime. So in the crime of murder, you have all these other things that can still happen. Second degree, because it's based on your intent, manslaughter, assault, depending on the case. So all of those lesser includeds are naturally included in the primary charge. So the jury can't convict you of all of the things. It is one of the lesser includeds. It's either murder one, murder two, manslaughter, and goes kind of down the road. It can cause some confusions for jurors. We definitely saw that in the Karen Reed case. But they've all been removed now, so away we go. And the court has to edit the jury instructions and the verdict form.
Us to change that thing that I'd like you to consider on principal instructions, the last line.
Give me one moment.
All right, it sounds like the court is editing those. I'm going to zoom while the court
Judge, before moving the
edits.
principal instructions after count one, Mr. Evans raised a good point.
Give me one moment.
The court is like, we are editing.
The last line is both.
All right, now the prosecution has something.
Right, concerning the principal
add.
instructions, Mr. Evans.
Your Honor, the last line is both principal instructions where it says this instruction, currently says this instruction does not apply to count.
The prosecution.
We would suggest that it be changed. This instruction applies only to count 1 and 3. It does not apply to count 2 in both areas.
Defense would concur.
Make the requested change. Let me repeat it once again, so this is
Clear.
reflects what is requested. This instruction only applies to counts 1 and 3 and does not apply to count 2.
That's on principle.
Yes, Your Honor, and given that principle applies to count 3,
Count 1 and 3 are the murder one and the solicitation, not the conspiracy.
I'll withdraw the request to move principle after count 1. So it seems more, it would be more consistent with the fact that principle applies to count 3.
The positioning of the instructions will be after, it will be introduction to homicide, count 1, count 2, count 3, principle 3.5 sub A, principles 3.5 sub B, intent, and then moving on to plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir, and I see you have added 10, the language that was agreed to by both sides.
Yes. Right, as to the defense's request to move in certain portions of the 2023 and 2024.
This is following up on the issue from yesterday where the defense said, hey, can we introduce all of Donna's planner, please, as to 2022 and 2023? However, no, 2014 and 2023. The 2014 planner doesn't have foundation laid. 2023, yes. They're arguing both under rule of completeness. We'll see.
Or calendars under the rule of completeness. After reviewing this matter, the rule and cases associated with it last night, at this time, that is going to be denied, specifically as to the 2014 and 2023 calendars.
He just said denied so fast.
Under the rule of completeness. After reviewing this matter, the rule and cases associated with it last night, at this time, that is going to be denied, specifically as to the 2014 and 2023 calendars. These are not what the court would deem as a unified recording or writing. The calendars
from the case law.
specifically are broken into separate documents by date. The 2014 calendar, any discussion of planning a party in no way connects with the license plate information that has been entered into evidence, which was done by a witness who authenticated that page, the handwriting,
That makes
and
sense.
other matters to reach the admissibility threshold. As that would go to hearsay without an exception or a witness testifying on the matter that will not be admitted. As to the 2023 calendar, these are not united by time or would otherwise lend context between the entries themselves. Again, if there is a witness who would testify to these matters, that would change the analysis. However, that has not occurred. As to those two items, they will be made court exhibits if necessary for any future review.
May I be heard on the 2014, Your Honor?
Go ahead.
There's no
One
foundation.
of the pages that the state included in, I believe it's 59A, the first page actually refers to the party. And in the state's demonstrative that was used through Sergeant Corbett, they actually highlighted that language. If I can approach...
Demonstrative, though, is not evidence.
No, in the presentation that they had with Corbett after the document was admitted into evidence, so the document itself is admitted. During his presentation, they highlighted language about the party. So I think that changed the analysis. If I can approach and grab the exhibit, Your Honor.
Please do.
This isn't going to go very far. For all of you asking about the added prosecutor, he showed up for the charging conference yesterday and was working with the jury instructions. I don't know what all the ASMR opening a bag is about, but the defense is still arguing over Donna's planners. As to the 2014 planner, I don't think there is a lot of an argument to be made about the foundation. With regard to the 2023 planner, the court said this is not rule of completeness. These are individual documents. So the prosecution showing one page doesn't remove the context from the other pages. The defense is looking for something.
The one with the two calendar.
I zoomed.
One was the one with the tag number. I don't see that here.
May I show?
The reference is on the Friday, June 13th.
All right, the defense has found what they're looking for.
As to this particular page, are you making any arguments as to what's been admitted is certainly permitted. How are the other separate pages, which are separate writings, in any way
Completeness.
connected to this as completeness?
Your Honor, it's all about the birthday party.
It's not about the pasta.
That using admission of that page alone creates a misleading impression.
Again, the court's ruling remains the same for the
Counsel's like, I'm trying, Your Honor. How are those rule of completeness? They're separate writings. Same topic? Yeah? Same topic?
item that has been admitted. You can make all arguments that can be reasonably inferred from this admitted item concerning the birthday party. Beyond that, the writings are not connected. This is not an issue of completeness as the court finds.
May we use the calendars as demonstratives during our closing?
You certainly may.
Thank you, Your Honor.
Are there any other issues that we need to raise at this time by either party?
Oh, yes. The verdict form, Your Honor.
Yes.
Mr. Evans and I discussed on count 2 to conform to the indictment.
That's the conspiracy count.
We would ask that the count 2, we, the jury, find as follows as count 2 of the indictment: conspiracy to commit first-degree murder. And additionally, the conforming word in A.
You've removed all of the lesser includeds. Therefore, I do not think it is confusing.
Let me bring up the indictment.
So the court is looking at the indictment. The attorneys
Do you
came.
wish for it to read conspiracy to commit first degree
Yep.
murder?
Yes, please.
The lawyers came in a little ahead of the jury today to deal with some of this. There are things that are going to come up overnight with jury instructions. And as to the issue of principle, which the defense argued yesterday, the defense asked for overnight to think about it and argue that instruction to the court. I'm not surprised it came up this morning. The court ruled about the planners. The defense didn't want to let that go, but
As to the solicitation,
fine.
do you wish for that to read
They're
the same
running-
as well?
a day ahead. So it's okay to take a minute in the morning and make sure everything's right. And you want to get those verdict forms right. And the court said, fine, we'll add the language first degree murder instead of just murder. All right, the court's editing those. I'm going to zoom while he's... I love the keyboard, but while the court's clacking.
Instructions that need to be.
All right.
Any further issues concerning the jury instructions that need to be addressed?
Your Honor, I just want to make sure you under subsection where it says the defendant is guilty of conspiracy to commit, you did add first degree murder there.
The verdicts will read count 1. We, the jury, find as follows as to count 1 of the indictment. First degree murder. The defendant is guilty of first degree murder. The defendant is not guilty as to count 1. Count 2. We, the jury, find as follows as to count 2 of the indictment.
These are the verdict forms.
Conspiracy to commit first degree murder. The defendant is guilty of conspiracy to commit first degree murder. The defendant is not guilty as to count 2. Count 3, we the jury find as follows as to count 3 of the, change that to indictment, not information. Count 3 of the indictment. The defendant is guilty of solicitation to commit first degree murder. The defendant is not guilty as to count 3.
Yes, sir.
Any further issues to raise concerning the jury instructions?
No, sir.
None on that, Your Honor.
Any other issues to raise?
I'd like to renew our motion for judgment of acquittal, same arguments, as well as all previous motions and objections.
No.
Well, as to the renewed motion for judgment,
That is just the defense protecting the record for appeal. There's nothing. It is just, we'd like to renew our motion. Same arguments. Can please? And the court's going to say, no.
of acquittal.
Immediately
the
no.
court has the same ruling in taking the evidence introduced throughout the trial in the light most favorable to the state. The state has met its burden to present all three counts to the jury. As to any review on this matter, the issue is preserved.
Thank you. And the last issue, Your Honor, we had discussions yesterday concerning a corrections officer at the Leon County Detention Center. We were able to get her served. Our investigator was able to, an investigator was able to track her down.
What?
Ms. Kessler, my paralegal, spoke with her afterwards. The information that she provided is our position that anything Officer Franklin would have to offer is not admissible, and that is why we did not seek to call her prior to arresting.
Well,
There's a little bit of defense CYA. There's the defense CYA. There it is. Oh, Donna, what are you doing to your lawyers, ma'am? They're just like that. That's the lawyers 100% covering their ass. For those of you who are like, CYA, cover your ass. That is 100% the lawyers saying, Your Honor, this is the subtext. Our client wanted us to call this witness. I am making a record that we found this witness, we served this witness, we spoke to this witness. This witness has no admissible testimony, which is why we didn't call this witness. That is the defense attorney making a record if there is an appeal. So that's the defense covering themselves and making a record, because somewhere down the road, appellate counsel is going to look at this case if Donna is convicted. Given that Charlie was convicted, given the evidence in this case, the defense has to look at that as a very, very real possibility. And they are covering for when appellate counsel looks at this case and says, those defense attorneys didn't call that one witness. They didn't push for more. Your Honor, we did it. We are making the record. And that was someone from the correctional facility. Just note it for the record, Your Honor. Your rights are preserved. Continue.
parties can briefly approach.
Well, I didn't have to pause it then. So that was regarding the in-custody witness. That was a full, we're making a record because we need to make a record. All right, the parties have approached. I'm going to zoom. They are at sidebar, which is literally at the side of the bar of the bench. It looks like the court is, or at least Donna is talking back to the judge, because she's nodding. It looked like she was saying something, not back talking, but speaking with, just so I'm clear. All right. Whatever conversation they are having at sidebar, they are having an extended sidebar conversation. And Chad, a lot of you are like, this new witness thing was 100% a client thing. That is my speculation, but based on the way the defense handled it, it's 100% Donna saying, no, there's this other witness. And the defense is like, we talked to the other witness, it's not admissible.
Before we bring the jurors in, we will have a brief break to allow the parties to get set any demonstratives and presentations that they will need for closing arguments. Please inform the jurors that we will bring them out about 9:25. Until then, the parties may do what they need to do to set up to get ready.
All right.
Print the copies of the instructions. If anyone needs to stretch their legs, use the bathroom, please do so. As to all observers for the closing arguments today, and this is very important,
Mind your
Once
face.
again, you are not to make any gestures. You're not to make any facial movements. You're not to any way indicate to the jurors that you agree or disagree with what is being argued or what is being said. Phones need to be put away and placed on silent. or
Mind your
turned off.
faces,
Does
people.
anyone have any questions? Given what was brought up yesterday, that there was either murmuring or some sort of
Thing.
improper influencing or attempt to
a
improperly
moment.
influence the jury, that is not going to be permitted. You will be removed and also subject to contempt. Please raise your hands now if you have any questions. Otherwise, I expect you to conduct yourselves accordingly.
Fucketh around, findeth
We'll
out.
resume at 9:25. The parties are to prepare for the closings at this point, or all presentations and demonstrations.
Get your shit together, everybody. To the invariable one person who's going to be like, why is Emily talking about that? To everyone who has asked about the lippy, I have linked it in the video. It's the lip stain / gloss that I have been wearing off and on. This is the one in the color fig. It's the Colfie, but I just went and tagged it in the video so you guys can just find it below the video. All right. Somebody's going to be like, nobody asks. Go read the chat. To the one person, to everyone else, that is what it is. That is an extended break. That was an extended break. All right, law nerds. We are gathered here today. Hold on. We are gathered here today for closing arguments. Let's talk about what happened this morning. They did a lot of work on the record before they officially
Bring the jury.
Before that, the court denied the defense motions with regard to Donna's planners. I mean, I'm just curious, if I was a juror, I would want to read through them all too. They're not evidence. They're not in evidence. Some of them, or the 2014, didn't even have foundation except for one page. Not evidence, not coming in. The defense addressed the instruction regarding who is a principal of a crime. And with regard to who is a principal of the crime, that was discussed amongst the lawyers. That instruction kind of, it doesn't amend. That instruction informs count 1 and count 3, but it was amended to include the proper instruction as to the lesser includeds. At the end of that discussion, the defense said, well, can we remove the lesser includeds then? And I was like, what are we doing? And then the prosecution's like, yeah, sure. And I'm like, well, all right then. So the lesser includeds that they all discussed yesterday and added to the verdict form yesterday have all been removed. And the case goes forward to closing argument and to the jury as charged. Count 1, 2, 3, no lesser includeds. Which means the prosecution probably had to go pull a few things out of their PowerPoint and they had to make sure they don't address it and explain it. With that, they're going to go on the record. The judge is going to read the jury instructions. When we get to those jury instructions, I will highlight the instructions of the crime. Those are going to be the elements that the court tells the jury that they need to find. Element 1, element 2, element 3. You will hear in these instructions, the way they are written in Florida, is that one of the things the state must prove is that Dan Markel is dead. That is exactly the way it is in the jury instructions. The jury instructions in Florida, I find to be a bit more plain language than in other jurisdictions, which I very much like. I find that the more we can take the jury instructions to the way that we speak every day, the easier it is for the jury to understand. So we need to go to jury instructions. You know what we didn't do yet? I mean, other than I forgot to put my live court bumper on because every day. We didn't go to Tallahassee yet. Let's go to Tallahassee. And then let's get to closing argument. Well, let's get to instruction. For all of you that are like, Emily, I don't want to hear the judge's instructions. They're going to take like 45 minutes. You're right. Get the Law Nerd app. Once they're probably going to do instructions and then possibly a break. Then I will ping you when they start closing. But for the rest of you who are like, we're here, girl, something's going to happen. Let's go. Time to go to court, everybody. It's time to bring the jury.
Bring the jury.
All right. The jury's coming in. I expect, let me put up my poll about who's doing closing for the defense. I expect we will see some of the same themes we saw in opening, right? All right. We know it's going to be Georgia for the prosecution. That's my clicky-clacky. If I spell anyone's name wrong, it's not disrespect. It's just I don't have it in front of me to look at.
All right, jury entering courtroom.
I love the, like, scepter banging. Jury in! It's so great. And just as a reminder for new law nerds, I do not poll as to guilt or innocence. Y'all have seen the evidence in this case. Y'all have opinions. We're not going to fight about what you think the jury should find. The jury gets to decide that. We can talk about it later. I do not poll as to guilt, and we generally start just pulling that out of the chat because people will start to fight this, that. Here's what I'm curious about. How does the prosecution argue the first-degree murder? How will the defense argue it? Is the case easier to find on the conspiracy and on the solicitation? It is, I think, a more difficult case to convince the jury, based on this evidence, that she is a principal to that first. It's going to depend on how the prosecution argues it. I think the conspiracy is their easiest count to prove to the jury based on this evidence. So I'm interested to see how they argue all of that. All right, let's continue.
Everyone can be seated. Good morning, members of the jury. Good morning. Before we get started
they sounded
with
like
the
an
instructions
energized
on the law
group.
and closing arguments by
Good
the attorneys,
morning.
I will have a stipulation to read to you.
This was agreed upon yesterday.
When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that Patricia Byrd was not listed by the current or previous defense counsel as a potential witness in this case. Does each juror have a copy of the jury instructions in their seats? Please raise your hands.
I love it when
Record,
courts
each
do
juror
that.
has been provided with a copy of
I
the
hate it when
instructions.
courts don't.
I'm going
If I am listening to 40 minutes of you reading something to me and I can't look at it, I'm going to either fall asleep like you are reading me a calm sleep story, or I'm going to be frantically trying to write everything down. I like that they just give them to them. You guys, you can listen, you can look at this. I like it better when they let them take notes on it.
to read these instructions out loud to you. You may follow along by reading as I read them out loud, or you may listen. The important thing is that you pay careful attention to the instruction on the law. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give
Sassy
you.
Italian, it's under the video,
Donna
so if you
Adelson,
close the chat, you'll
defendant
see
in
it
this
under the
case,
video.
has been accused of first-degree
mobile.
murder, conspiracy to commit first-degree murder,
So the charges?
and solicitation to commit first-degree murder. Donna Adelson is accused of first-degree murder in count 1 of the indictment. If you find
talk about
Daniel
that.
Markel was killed by Donna Adelson, you must then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder. I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder. Count 1. To prove the crime.
I love the way Florida lines out their jury instructions. Instead of giving all of the exposition, these are the crime instructions. If you tune out for everything after this, these are the crime instructions. What needs to be proved for count 1, count 2, count 3, and they're going to give those elements. So if you want to know what does the jury have to decide, this is the key part of those instructions.
Degree murder. Count 1. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel. An act includes a series of related actions arising from and performed pursuant to a single design, or purpose.
These are the definitions to that instruction.
Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you
By the jury.
from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2.
Count 2.
To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt.
Only 2.
Element 1. The intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2. In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson or Catherine McBanois or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators.
And then he's going to
It is not necessary
define
that the
those
defendant
here.
do any act in furtherance of the offense conspired. Count 3. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a
This is
reasonable
count
doubt.
3.
Element 1. Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder. Element 2. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions.
All right, that's the solicitation.
To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. If the defendant helped
Nightbot,
another
not you.
person or persons commit a crime, the defendant is a principal and must be treated as if she had done all the things the other person or persons did if the state proved beyond a
Sorry,
reasonable
Danita.
doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise
more
the other
definitions.
person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. Or
The principal instruction is key to this. So he's defining, it's an easier case to explain when the person shows up and does the thing. It's a harder case to explain when the person is on the other end of the state, but caused the thing to be done. And so the court is explaining the principal instruction. Principal goes to count 1 and count 3. Count 2 is the agreement crime, the conspiracy. And on screen, a lot of you have asked that is the victim's mother.
attempted.
If I were her, I'd wear
For
sunglasses in court
first-degree
too.
premeditated murder, the
I get my
state
grade.
must prove the defendant intended that the killing of Daniel Markel occur. This instruction only applies to count 1 and 3 and does not apply to count 2.
I like his cadence.
If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all of the things the person who was promised or received the money did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur.
Paid or promised to pay.
And 2, she made or promised the payment in exchange for the commission or promise to commit the crime or to help commit the crime. And 3, the crime was committed by the other person. To be a principal, the defendant does not have to be present when the crime is committed. This instruction only applies to count 1 and 3 and does not apply to count 2.
Because count 2 is the agreement's part of the count.
The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It
This goes
may
to
be
state of mind.
established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof
defines-
beyond a reasonable doubt
defines reasonable
does not
doubt.
mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon.
So he's going to tell them all the different
verdict.
how to
You may find
decide.
some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided?
And we're
Does
looking at
the witness's
you.
testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
That goes to the informants.
Had any
more.
pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty?
Or a bunch of them.
Was the witness present in the courtroom during the testimony of another witness or other witnesses?
That goes to that expert.
Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness.
That's a standard jury instruction. That's not specific.
Check on what's happening in the hallway. Expert witnesses are like other witnesses.
There was noise outside the courtroom. I'm not surprised the court is like, find out what is going on out there. Members, remind me to tell you a story. I have a few hallway stories. They're not for now, though.
With one exception. The
We'll save
law
them for members
permits
only.
an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony.
That didn't come up much in this
You may rely
case.
upon your own conclusion
come up more
about
in
the
others.
credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness.
Thank you, Lauder.
The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness
This
in
goes
this
to
case.
the
You
defendant's
must not
Fifth
view
Amendment
this
right.
as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred
That's
one
a standard
verdict
instruction
over another.
in every jurisdiction.
A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows.
And they're going to read the verdict forms, and then we're going
There
to
is
get to
only
closings.
one verdict form, which I am in possession of right now, but I will read to you all of the options that are available.
Ladies and gentlemen,
on
the others
verdict
are being
form.
edited because everyone changed their mind this morning. Sorry.
State of Florida versus Donna Adelson, defendant, case number 2023 CF 3226. Verdict, count one. We, the jury, find as follows as to count one of the indictment, first-degree murder.
Explaining the verdict
Check
forms.
only one letter choice as to this count.
It's very much check yes or no.
Letter option A. The defendant is guilty of first-degree murder. Letter option B. The defendant is not guilty as to count one. Count
I mean,
two.
she's controlled her face much better
We, the
today.
jury, find as follows as to count two of the indictment, conspiracy to commit first-degree murder. Check only one letter choice as to this count. Letter option A.
To everyone now
The
singing George
defendant is
Strait.
guilty of conspiracy to commit
No
first-degree
apologies.
murder.
It's a great song.
Letter option B. The defendant is not guilty as to count two. Count three. We, the jury, find as follows as the count three of the indictment. Solicitation to commit first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of solicitation to commit first-degree murder. Letter option B. The defendant is not guilty as to count three. And then the verdict form is to be signed and dated by the individual who will serve as the foreperson.
Okay.
Both the state and the defendant have now rested their case. The attorneys now will
It is
present their
time.
final arguments. Please remember that what the attorneys say is not
evidence
or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to proceed with its closing argument?
Yes, Your Honor. May it please the court.
And now closing arguments for the prosecution begin. Red suit on a closing argument day is a strong play, counsel. Oh, wait, hold on. Can we just get a second for the court reporters, Bob? They have had different court reporters every day. Emily, you're distracted. I love a long bob. I love it. Look at that. Just great. Just a great haircut. Okay. Closing arguments, Emily. Red suit is a strong play for closing argument day. A lot of people associate Red with guilty. I had a defendant actually appeal, and well, I had lots of defendants appeal, none of them granted, but I had a defendant appeal that I used Red to write things in my PowerPoint because it was unduly prejudicial.
This is Dan Markel.
It was not.
He's the victim in this case. A son, a brother, a colleague, a mentor, a professor.
You heard a lot about him from
friend,
the defense. A father.
but most of all, a father,
Yeah.
an Abba, a dad. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his time with those little boys in the wake of a bitter divorce from their mother. Defense called witnesses to come in here and give you an expert opinion that his divorce and the subsequent litigation was
started
not
there.
contentious. Not contentious to whom?
Oh,
It was
boy.
contentious to Dan Markel. It was contentious to Wendy Adelson. And it was contentious to this defendant. And then after telling you what a great guy Dan Markel was in opening statements, they called witnesses to tell you what a pain in the butt he was.
Wow, counsel.
And he was a pain in the butt to those people, those awful lawyers that can't even admit that divorces are emotionally charged.
Just
He was a pain in their butts.
all of it.
He was a pain in Wendy's butt, and he was a pain in Donna's butt. Why? Because this was his life we were talking about. Dan Markel was not a file on some lawyer's desk.
I love that she's
He
addressing
was
that
a
first.
real person who cared passionately about every scrap of paper in that divorce file. He wasn't some bumbling idiot. He was a Harvard-educated law professor. And yeah, he was making it as difficult as possible for this defendant to get her non-negotiable, which just also happened to be Dan Markel's non-negotiable, those two little boys. You have learned about this conspiracy and how it has unraveled over the last 11 years since Dan Markel's death. The defendants in this case have all attempted to point fingers at each other.
She used the Spider-Man meme. For all of you that are listening in the background, she used the Spider-Man's all pointing at each other meme. She absolutely just did. She absolutely just did. She absolutely just did. Also, ma'am, accurate. Accurate. They chat, I'm backing it up. It goes fast. Come on back. Eyes up. Let's go.
The defendants in this case have all attempted to
100%.
point fingers at each other. They have argued that the state's theory is right. It's right. You got it right. With everybody except for me. I didn't do it. Garcia's defense was that Charlie went directly to Rivera to arrange the hit on Dan Markel. Catherine Magbanua testified in her trial and said she had no knowledge of this murder.
I love
Charlie
this
must
visual.
have gone around her directly to Garcia.
Everybody excludes themselves.
In Charlie's trial, he said Magbanua, Garcia, and Rivera all got together to kill Dan Markel without any direction from any Adelson family member. Each defendant characterized himself or herself as another victim in this case. A victim in this situation, a victim of their co-defendants, setting them up, or the appearance of evidence that seemed to implicate them but wasn't what it appeared to be. But despite their efforts to insulate themselves and to distance themselves from their co-conspirators, they made enough mistakes to get themselves caught and held accountable for their respective roles in this conspiracy. And today is Donna Adelson's turn. Despite their efforts to play victims, Dan Markel is still the only victim in this case. And the only thing he was guilty of was fighting like hell for those little boys. And he lost. He lost everything.
And then he lost his
This
life.
is what he looked like before This defendant conspired to hire a hitman to have him killed, and this is what he looked like after. The evidence has shown that on July 18th, 2014, this brilliant,
autopsy
accomplished,
photos there.
beloved man was gunned down in cold blood in his own garage. And this horrific death ultimately set the police down two separate paths, following the two most promising leads that they had. The first lead was to chase down that Prius that, thank God, Mr. Geiger caught a glimpse of pulling out of the driveway that morning.
Absolutely.
And the second path was to ask, as we would with any murder investigation, who had a motive to want him dead? And within 1 hour of the shooting, well before Professor Markel had even been pronounced dead, this path was already pointing to the defendant when Wendy Adelson revealed to officers that her parents had more reason to dislike her ex than anyone else. And what offense had Mr. Markel committed against Donna Adelson and her family, refusing to let his children be taken away from him? Objecting to her telling his kids that he's stupid? The evidence has shown that Donna Adelson was all about psychological warfare, and when all else failed, she was willing to do whatever it took to accomplish her non-negotiable, to get a win. In order for you to render a verdict of guilty, the state must prove to you beyond a reasonable doubt that these crimes were committed and that this defendant is the person who committed the crimes, or in this case, one of the persons who committed the crimes. It is undisputed that these crimes were committed. This was a first-degree murder. No doubt about that. But who did it? The only issue left is identification, or what we call ID. The defense told you in openings, motive doesn't really matter. Don't pay attention to all the motive. Don't pay attention to all the emails. But motive can be compelling proof of who done it. Identification. And thus, critical to your determination of the defendant as one of the persons that committed this crime. Despite some of the testimony that you heard, it is clear that the divorce between Wendy and Dan was contentious. Except the person who cared most about Wendy's divorce, and relocation specifically, wasn't Wendy. It was her mother. Charlie Adelson solicited Catherine McBanoa to kill Dan Markel, but why? Who solicited Charlie? Because Charlie didn't care about the Adelson family getting a win against Dan Markel. He didn't care about relocation. He didn't care about Wendy's divorce. He cared about go-karts and jet skis and pretty girls.
Boobs.
But he also cared about getting things done for the number one woman in his life, and that was his mother. She managed Charlie's life for him, and in return, he solved problems for her. That pattern is seen throughout this case. He talks to Wendy on the defendant's behalf to get her to pull the plug on the Tallahassee house, to date Dave and invite him to Mother's Day, to pursue a medical malpractice job, even though that's not even her area of the law, and on and on.
I don't think that's an evidence.
She micromanaged Wendy's life.
That's an evidence.
Charlie knows how to manage Wendy in a way that Donna can't, or knows how to talk to her in a way that Donna can't. And Wendy needs their help, right? Because according to them, she doesn't even have enough of a brain in her head to run her own life without their help.
That's an evidence.
Donna decides what's best for everyone, and if she runs into any problems making that happen, Charlie is her go-to guy to get it done. He is the problem solver. And what was the biggest problem that Donna Adelson had in 2014? Dan Markel. Wendy filed her petition for divorce on September 10th of 2012, and the defendant was right in the middle of it. In the fall of 2012, the defendant told her son, Rob Adelson, that she had been in Tallahassee for several months, renting a new place for Wendy. She used her own maiden name to do that, to disguise the identity of who was renting it, arranging for movers, moving money around, and getting things set up for Wendy to leave Dan. Then Wendy calls Dan Markel and delivers the news that she's leaving him. How does she do it?
Well, he's out of town.
She tells him she and the boys are moving out of the marital home, and the defendant gleefully, that was Rob's word, reported to Rob, her son, that she and Wendy strategically planned to deliver that news to Mr. Markel so that he would get this bomb dropped on him right as he's about to take the stage to deliver this lecture.
Yep.
According to Mr. Markel in one of his filings, quote, while the husband was away on a short business trip, the wife left the husband in the marital home, taking with her the children's furniture, clothing, toys, and whatever assets, both marital and non-marital, she desired. The evidence has shown that from the start, this defendant was very involved in managing Wendy's divorce. In October of 2012, defendant writes an email entitled, Things to Discuss at Your Mediation to Make Sure You Have in Writing for a Settlement, in which she refers to Wendy as a hostage and a prisoner in Tallahassee. That's what she believed. The email also includes the suggestion that Wendy pursue a restraining order against Dan Markel, that Wendy should go for 100% full custody of those two kids and relocation, and the threat of this conversion to Christianity. Quote, if he leaves you in Tallahassee,
among other
the children
things,
will not be attending Hebrew day school. That's not a threat, just a warning.
Very Real Housewives.
A warning that her friend, Miss Cunningham, on the stand dismissed.
Her friend.
Oh, that was just a foolish thing to say, right?
10 out of 10, this prosecutor's bringing up stupid fool in that script. She used the word foolish so intentionally because the friend used it, because that is Donna's word. Oh, the fool is going to come back.
But the characterization of these threats as, just something that was a one-off heat of passion thing has been completely destroyed by the evidence in this case because she repeats it. She plans it with a lot of specificity. Wendy even admitted that her mom was serious about planning a baptism for these kids to change their religion as a ruse to try to strong-arm Dan Markel into giving up those kids.
Would you say they were losing their religion?
This is an example of the defendant operating with the emotional subterfuge as described by her daughter, Wendy Adelson. Also remember how her son, Rob, described her. She has rigid and fixed ideas of what she wants. And as long as you comply, things are fine. But when you don't comply, things are not fine.
Oh.
Wendy even admitted that if Dan had relented and moved to South Florida,
Counsel, can we get you a
or at
water
least
bottle?
allowed her to move there, they might have co-parented happily ever after. But Dan did not comply, so things were definitely not fine. The defendant ends this email with, quote, we will help you in any way possible for you to come here. In October, this defendant drafted language for Wendy's petition to relocate, including allegations that Wendy had been upset about having to live in Tallahassee since 2005, and a mention of putting the boys in a Christian school and on a non-kosher diet. Again, that's not a threat, just a reality. And the suggestion that the boys live in South Florida with Wendy and Dan just fly back and forth to see his kids.
Right, just commute across the
just
state.
Come see him every other weekend by airplane. Doesn't that sound like an amicable, equal time sharing that the lawyers for the defense described was going on here? Wendy's lawyer says she had no knowledge of Wendy's mom being involved in her divorce, but the evidence shows she absolutely was. Wendy sends the proposed petition for relocation from her lawyer to the defendant with a note that says, here it is, let's edit. And the defendant responds the next day with detailed feedback, including an argument that Dan Markel is incapable of taking care of his own children and that Wendy should seek 100% custody. Arguments which Wendy forwarded to her lawyer as her own. And upon receiving the lawyer's answer, she sends the lawyer's answer back to the defendant. That's in evidence. Defendant's thoughts about Wendy's earning potential and her work environment in Tallahassee. Arguments about she'd be better off with this other job that's higher paying in Miami. And defendant says she's been living in Tallahassee, that she, the defendant, has been living in Tallahassee since the petition was filed to help Wendy with the boys. In January of 2013, the defendant advises Wendy on her amended petition to relocate. And this is where the argument is raised about the job as a major bargaining chip in the divorce. The defendant writes here that Dan needs to know that there's no way in hell Wendy is going to stay at FSU.
Dan needs to know.
On January 14th, Wendy files an amended petition with request to relocate, which you can read and see. The petition contains many of the defendant's arguments. She couches this relocation in terms of not only important, but like a matter of life and death. Look at these quotes. It will
Yep.
create a major negative change in our lives. It will ruin your entire life,
The
the rest
prosecution's
of all our lives.
media presentation
Mine,
was great.
Dad's, and even Charlie's will be affected by how well she can perform and act before July 31st to try to get this relocation
of your
thing turned
life.
around. Donna has even started pre-screening men for Wendy to date in the Miami area. In February, Dan files his response to Wendy's motion to relocate, alleging Wendy took his stuff when she left. The sole reason for relocation is to be close to her mother and family in South Florida, and that contrary to what Wendy put in her pleading, he was not seeking to leave FSU. He wasn't trying to move. Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense experts ever seen, but pretty nasty. Dan Markel requests sole decision-making authority for these kids regarding education, medical, and religious matters. The defense lawyer witnesses said, oh, that was never going to work. Maybe that's true. But these were concerns that Dan Markel took seriously. There's tons of discussions in evidence in these binders before you, in the pleadings and in the emails about Dan Markel's desire to raise these boys in accordance with his faith and his concerns that his wishes were going to go right out the window as soon as the boys went over to be with Wendy or her mother.
Which we saw.
And
in the
defendant
evidence.
took this matter seriously too. She made it crystal clear in these emails that she had no respect for these boys' fathers' wishes for them regarding religious practices. In this email, defendant says she's sitting at Wendy's kitchen table working on Wendy's response to the filing we just talked about that Dan
You said
Markel
that.
made. So much for her having no involvement in her daughter's divorce. She says in this email to a friend, all Wendy wants out of this is to relocate to South Florida where she has us and Charlie. Danny is making it very difficult. On March 5th, 2013, defendant sends a long email in response to every paragraph of Dan Markel's arguments against relocation, including that Dan's religious practices are fanatical and dangerous to the boys, and that Dan Markel is psychologically unfit to have custody of his children. It's not sounding very amicable, is it? In opening statements, the defendant's attorney acknowledged that Dan Markel was an intelligent, accomplished professor and a dedicated father, and the state could not agree more. But the evidence
those
has shown
openings
that
would
her
come back,
client
right?
didn't agree with that. Donna Adelson repeatedly paints Dan Markel as a self-important idiot who's not fit to care for his own children. On March 6, 2013, Dan Markel sends Wendy an email threatening to take her to court over her failure to cooperate with the Skype thing. That comes up repeatedly. Here he says, you've made zero efforts to facilitate that when you or your mother could have easily done so. I don't want conflict or tension. I desperately want peace and joy. Please let that happen, but do not mistake my politeness or desire for cooperation as a lack of firmness. I will not tolerate failures on your part to keep our agreements. They did have a Skype agreement, and she was violating it, and he was furious about it. This email was forwarded by Wendy to this defendant, so she knows about all this stuff. Dan Markel sent Wendy an email in December, which was pretty personal, and in which he is kind of a mea culpa. He apologizes for things that went wrong in the marriage and takes some accountability for what he views as his mistakes in the marriage. And Wendy forwards this email to her mother. Then Donna responds to this personal email.
Oh my God, that's a lot of
and
email when
goes
they lay it
through
out.
Dan Markel.
I mean, look at how they laid it out. You really get a sense for how fulsomely involved, and you can just see the peak of the header. Really nicely done, Mom. This is great. From Wendy to Donna.
Markel's writings, paragraph by paragraph, suggesting how Wendy can manipulate his words against him. Oh, look, he's admitting this here. This will help you in the divorce. And she does it in Wendy's voice. It's weird. Look at it. So although sometimes Wendy seems to be complaining about her mom overstepping, you know, she's trampling my autonomy, it's like she's also inviting her mother into her business and wants her help, but also don't trample my autonomy. In fact, Wendy thanked her mom for the thoughts that she gave on this letter Dan Markel wrote. She also wrote that she never would have left Dan Markel
Right.
without her mom's support. In May of 2013, the defendant refers to one of Dan Markel's responses as a, quote, 23-page rant. Then she doubles down on relocation as the most important and non-negotiable part of Wendy's divorce. I mean, how many times does she have to tell y'all it's important, but somehow the defense is still, it wasn't important, or it was over. It didn't matter. She notes here that Dan Markel threatened Wendy with federal kidnapping charges. He threatened her daughter with federal kidnapping charges for taking those kids without telling him where she was going when she left. The defendant signs off, "I'm too angry to write anymore." And the evidence has shown that this nice, normal, sweet little grandma certainly was angry. To support the argument that Wendy
Oh, no.
should be able to relocate.
I'm blocking my favorite word. I apologize, chat. The bottom highlight on that says major fucker. We've heard that quite a lot in this trial.
Because Dan was always traveling on work trips. The defendant sends Wendy this email, and it contains every date, like the date ranges that Dan Markel has been out of town traveling for work since the birth of their first child. That's 4 years. She is able to go back and send to Wendy, he was out of town this date to this date, this date to this date.
Because she had it all in her planner.
It's
I mean, I'm
little
a planner
shocking that
girl.
she recorded that information, but we know she is a very detailed person. She keeps these extremely detailed day planners. But Dan Markel's travel schedule is of particular interest. In fact, in light of the fact that the hitmen knew that Dan Markel had to be killed on July 18th
Yep.
because he was going out of town the next day. The question is how'd they get that information? Who had that information?
I like how they tied that back with the planner.
Then the next day, Dan Markel files a memo of law asking for the attorney's fees and saying that, quote, if costs are not awarded, then the wife and her affluent parents who are bankrolling the wife's litigation so they can enjoy closer access to the grandchildren will persist in vexatious and groundless litigation. Dan Markel knew that Wendy's parents and their considerable resources were a big part of why this divorce litigation was dragging on. They thought he was filing frivolous stuff to drag out the divorce and the proceedings, and he thought the same thing about them. On June 21st, the court issued the order denying relocation. When Wendy was on the stand, the defense made a big deal out of, oh, you didn't tell mom it was final, did you? You stipulated to it, didn't you? Which we later learned was because the judge had already ruled at sidebar that it wasn't going to happen. But basically, you know, you kept your poor mom in the dark and she thought this was still something that was viable and you didn't tell her it wasn't. But on redirect, it was proven that that was not true. Defendant did know that the order was final and she expressed this in an email to her friends. Poor mom wasn't kept in the dark on anything in this family. In fact, the defendant recognized perfectly well that this order meant she wasn't going to get relocation through the courts. She wasn't going to get what she wanted through the legal system, but that wasn't the only way to skin a cat, was it? She wasn't deterred by a loss in court. Instead, she started looking into other options to get a win for the Adelson family. There was testimony offered that everyone knew that there was a slim chance of Wendy winning relocation. Maybe everyone knew that on the lawyer's side, but the defendant didn't know that. She was not happy about this loss in court.
Right.
Here she laments, unfortunately, after paying a lawyer $600 an hour for 10 months of case preparation, the judge listened to Wendy for 1 hour and made up her mind. Outrageous. So at the moment, we will not be allowed to relocate. Note the phrase, at the moment. Gibbers had not beaten the Adelson family yet.
At
Defendant concludes this email anyway.
The moment's
If
a
I
good
sound
point.
angry, it's because I am. We're all very upset and cannot believe the outcome.
but it's not
Couldn't
contentious,
believe
right?
relocation was denied. When Wendy expresses defeat over the court's order, the defendant isn't having it. She encourages Wendy to never, never, never give up, to take control, to not let Gibbers think he's won anything by having you remain in Tallahassee, and to show this fucker what will make him absolutely miserable.
You know his weak
How
points.
amicable. Then defendant solicits Wendy to put on the performance of her life because Gibbers hadn't beaten the Adelson.
If you are listening in the background, the prosecution is scrolling through this email, highlighting portions of it, highlighting portions of, fine, you want me in Tallahassee? You got me in Tallahassee. But now I'm going to convert the kids. Without saying it, she is using all the documentary evidence to add to her closing, which I appreciate.
Family yet. And this is where defendant reveals her plan of action, including having her Jewish grandsons baptized and offering $1 million to Dan Markel to facilitate this relocation. Control is a theme that's featured prominently throughout this email and throughout this case. There is evidence that the defendant controlled Wendy, she controlled Harvey, and she controlled Charlie. But she could not control Dan Markel. He wasn't going to give her a win. As long as you went along with her rigid, fixed ideas, things were fine. But if you didn't, things were not fine. Defendant continues to react to relocation being denied and Wendy's inclination to give up on the matter, including, everyone has a price. Now is the time to start. You said this divorce is not about winning and losing, and it's not a competition. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family, teaching in Tallahassee. Life is tough. If you don't stand up and take a chance, you don't stand a chance. Please,
Highlighting
Wendy,
Tallahassee to this jury
do your
again.
part and stand up to him. Make an effort to do this so that our group offer will stand a better chance of being accepted. Don't let this temporary move to Tallahassee ruin your entire life.
Temporary move to Tallahassee.
Fight for yourself, Wendy. We'll be there to help you. Just don't tell us that what you need to do is move forward with a sense of peace. Can't have that, can we?
Wow,
That's giving
I'd
up.
forgotten about that.
Giving up on relocation was not an option for Donna Adelson. Neither was losing. Throughout the trial, the defense tried to distance themselves from these emails. One of the ways they did that was by trying to put them off on Harvey. They pointed out, hey, this is a joint email account. One of these is signed Mom and Dad. And there's a few that are signed Mom and Dad, but it's clear that the defendant is the author of these emails and that she's the one driving the bus on this relocation effort. And during the presentation, we highlight all the dad and I language, all the indications in there that Donna is the author as opposed to Harvey being the author. According to her own daughter, Wendy, she's the dominant force in that household. And according to her son, Rob, she is a controlling person as opposed to the more passive, go with the flow type of personality that the dad, Harvey, has. In opening, the defense attorney told you that this defendant was a normal person, and you don't have to decide she's not a normal person. You're the judge of the facts, right? Was a crime committed? Is this the person that committed the crime?
Right.
But in this email, she suggests that dressing her Jewish
Oh, here it
grandchildren up in
is.
Hitler youth uniforms would be
horrible.
acceptable. That would accomplish her goals. The ends justify the means for her, people. That is illustrated here, and it sums up this entire case. The defendant wanted this done because that was the only way left to get a win. If he had submitted, if he'd
And while the defense attorneys are looking straight ahead, Donna is looking right at the jury as the prosecution is pointing out some of the most abhorrent parts of these emails. For those of you that are like, how did I miss this? It came up in trial quite a bit that Donna suggested to Wendy. There's no evidence that Wendy did this to her children, but that she suggested that her children should dress up that way to go after and cause pain and leverage for their father. But when Donna is looking right at the jury as they are talking about that. Also, chat, thank you. I know closings are a hard day. Thank you for staying on topic with this defendant and this case. I know there are strong feelings about Harvey and Wendy. Today is not their day. Today is Donna's day. And during questions, we can talk about them more. But thank you for focusing on the closings here and staying within our chat boundaries, because the law nerds know closing days are busy days. So it's a good use of presentation, I think. Let's keep going.
let her take those kids, he'd be alive.
Wendy's not presently in court, for all of you asking.
If he'd moved to town.
I stepped right on the prosecutor's point. I'm going to let that roll.
Here, and it sums up this entire case. The defendant wanted this done because that was the only way left to get a win. If he had submitted, if he'd let her take those kids, he'd be alive. If he'd moved to South Florida himself, he'd be alive. But he would not submit. She could not get that win. He was a huge problem, and she made it Charlie's problem. To Charlie, who liked the idea of being a tough guy, who had connections to people on the wrong side of the tracks, the price of Dan Markel's life was worth the reward of pleasing his mother and easing her diarrhea and getting her to finally shut up about Wendy's divorce.
Oh, shit.
In the mind of this defendant, all their lives depended on the success of this relocation effort. She tells you as much herself in these emails. Listen to her. And as such, any and all means were justified. Because not everything one has to do in life is comfortable or easy. Sometimes it's ridiculously hard. This is what passes for normal in this
Great use of
family.
quote.
I said the defendant made Wendy's divorce Charlie's problem, and the evidence shows that the defendant did keep Charlie in the loop every step of the way. Here's a July 10th email that states, just to catch you up on what's happening with Wendy, and discusses who should be involved in the bribe that the family wants to offer to Dan Markel. On July 19th, the defendant requests, and Wendy sends her copies of the motions, responses, orders, and transcripts from her divorce so far. That same day, Dan Markel makes a settlement offer that this defendant encourages Wendy to reject, saying the answer is no to all of this. Please, Wendy, we've been with you from day one. Do not accept or sign anything without the two of us reviewing and discussing all of this with you. Screwing him financially is what will aggravate him. But ultimately, a settlement is reached. Y'all have heard about this date, July 31st, 2013. But contrary to what the defense has told you, the fighting did continue. On October 12th of 2013, 3 months after the divorce was final, the defendant forwards an email to Charlie Adelson, which Dan Markel had sent Wendy.
Right of
And the
first
defendant
refusal.
adds the note,
Impossible.
this is what this fucker is sending your sister on a regular basis. He is absolutely crazy. Impossible. Does it sound like everything was over?
Donna was looking at the monitor in front of them. There are monitors at counsel table that she can see. A number of you have asked, is Wendy in the courtroom? No, she is not. I will not speculate about her whereabouts while she is watching this, because I asked everyone to focus, so I must focus too. But the prosecution has gone back to all of the emails that we saw it feels so long ago with all of those wiretaps. I wonder if they'll play any of the audio from the wiretaps.
This was the amicable divorce over? Not contentious at all, right?
They're really going to make the defense eat
This is
that.
fall of 2013, the same time frame in which Wendy starts dating Jeff Lacoste and Charlie starts dating Catherine Magbanua.
I'm
On
glad they
October
blurred the
13th,
kids.
2013, the defendant texts Charlie Adelson, quote, "Horrible evening for your sister." The pattern of this defendant getting worked up about Wendy's divorce and then forwarding it on to Charlie is seen over and over again. Which brings us to Halloween 2013. Several important events in the case occur on Halloween 2013. One, Wendy officially takes Dan Markel back to court, filing her motion to enforce the marital settlement agreement. So she's alleging he violated it, and she's asking to hold him in contempt of court, alleging that he's not paid the.
Notice that the prosecution is still going through a timeline, though subtle. At the top of the slides,
pad.
it has the dates, and the prosecution is walking through everything leading up to the murder, focusing it back on Donna, the court filings, and how Charlie's being looped in. It's, I think, a really helpful walkthrough of, oh yeah, remember the defense said this is not contentious, right? This is amicable. But look at what's going on. I bet we're going to get to the house very soon.
Fees that he was supposed to pay by a certain deadline. Wendy backs out of the contract that she had signed to buy a house in Tallahassee on Halloween 2013.
Oh, there it is immediately.
Charlie later brags to the defendant that he talked Wendy out of buying the house, and the defendant calls him a miracle worker for having convinced Wendy not to buy the house in Tallahassee.
It's
Also,
really
Charlie meets
telling
up
timing.
with Catherine Magbanua on Lincoln Road on Halloween 2013, the same day Wendy pulled the plug on the house, and broaches the subject with her for the first time of, hey, do you know anybody that I could hire to harm someone? And she did. Charlie sends this picture of himself and Catherine Magbanua together to Wendy that night, October 31st, 2013. First night, he solicited Catherine Magbanua to be a part of a murder, or a part of what would become a murder. Mid-November, Jeff Lacoste meets the defendant for the first time. Remember Jeff? He was Wendy's boyfriend that testified.
Oh, we remember Jeff.
He said he would meet her 6 to 7 other times in addition to that first time during the course of his relationship with Wendy. Sometimes just in passing, picking Wendy up for a date. Other times more substantially, including taking the boys to the circus. And that becomes maybe important later. Meanwhile, the fighting continues into December. We're in December of 2013 by now. On December 16th, Dan Markel emails Wendy and the parenting coordinator that was assigned to help them try to navigate these issues about the defendant, Donna Adelson, disparaging him to his kids. In this email, he introduces what he calls a major issue. The headline on this concern is not buried, guys. Like he says, I'm introducing a serious, a major issue. He very plainly gives a preview of the grandma motion, which will ultimately be filed in March of the next year. And here he says that on November 8th, one of the boys announced at a Markel family dinner that grandma, referring to this defendant, says you're stupid. Grandma says you're stupid. Then the following Monday, on November 11th, when Dan Markel was buckling the boys in at the park, they both tell him that grandma says you're stupid. When asked why, they say because you're trying to take her sunshines away from her. When asked who are her sunshines, the boys answer they are her sunshines. Then again on November 30th, while playing with the older child, that child repeated the statements to Dan Markel, grandma says you're stupid. And again when asked why, the child repeated that the defendant said that Dan Markel was stupid because he was trying to take grandma's sunshines away from her. Markel implores Wendy to address the situation as he would like to avoid a hearing in which his kids are going to be primary witnesses against their grandmother. He assures her That he will, though, if necessary, seek judicial relief that prevents contact between the children and their grandmother. This lawyer that testified said, oh, that wasn't going to work. Well, he didn't think so. Oh, well, that's no big deal. I've seen much worse than that in my career. Well, yeah, Dan Markel hadn't seen much worse than that. Dan Markel had a big problem with Grandma saying he was stupid, and he wanted to take it up and address it with the judge if necessary.
As he should.
Dan Markel emphasizes that this is a matter he takes very seriously and says that the defendant's actions could lead to the termination of Wendy's parental rights. Is that true or not? Doesn't matter. He thought it was true. He threatened it. And those are fighting words. Going to terminate your parental rights? Wendy forwards the email to the defendant the next day, December 17th. And what's the response? Wow. That's a response we see from the defendant quite a bit. She's usually more verbose. That's true. But why is the defense working so hard to say that their client didn't see this email and didn't know about these allegations? I mean, isn't it clear that Wendy is sharing all the issues relating to her divorce with her mother? Wendy communicated with her mother on all these filings, and this one pertained directly to her mother. Of course they discussed it. Are you really to conclude that nobody was fighting anymore prior to Dan Markel's murder when the evidence leads you to conclude the exact opposite? This was a pressure cooker, and it was being turned up hotter and hotter with each passing day. Not only is this a situation that's escalating between the actual parties to the litigation, but now the defendant has moved from working behind the scenes, helping Wendy with the divorce, to actually being the subject of the pleadings that are before the court. There was supposed to be a hearing on that issue.
Yep.
One thing Dan Markel wrote in this email is, quote, I fear that the children's best interests are not being pursued so much as what Grandma wants. If he only knew how legitimate that fear really was. Those weren't just some ugly, foul words thrown around in the heat of the moment, folks. They continued well past the finalization of the divorce. Here on January 10th, 2014, so now we're into the year where Dan Markel is killed. 6 months after the divorce is final, defendant says of Dan Markel, wow, is he on drugs? Is he also going to pay $70K plus the legal fees and interest that bastard owes you? So the bad blood is going strong here 6 months before the murder, and the divorce wasn't really final anyway, in the sense that we're continuing to have pleadings get filed back and forth. In February of 2014, Dan Markel emails Wendy threatening to file motions, exposing her for what he said was hiding assets, $200,000 worth of assets from the court, and giving false testimony under oath. And also to accuse her attorney of misconduct. Her lawyer witnesses say none of that's a big deal, none of that was going to be successful, but he thought it was going to be successful. To him, it's a lot of money. To him, it's a big deal.
He probably just
the
wanted
next
to
day,
be heard.
on February 15th, 2014, we see a text from the defendant to Charlie. Wendy's totally stressed out. Yesterday was a rough one. She will probably have to go through another depot. Outrageous. Rob Adelson testified that his mother told him they were, quote, depoting Wendy to death. But
Wendy
then their
had never done
expert
a
witness
depot.
got up there and said Wendy was never deposed.
Never once.
I guess they didn't provide her with that information or any of these emails or text messages post July 31st,
a
because
good
this
call
thing was
out.
not over on July 31st. In this text, defendant accuses Dan Markel of stalking Wendy, and Charlie agrees. The defendant tells Charlie to keep the conversation with Wendy light and don't bring up the divorce drama, which kind of implies there was divorce drama
And
going on.
contention.
There's a sense in this email and elsewhere in the evidence that defendant and Charlie have to tiptoe around Wendy, like she's this damsel in distress that needs the two of them to step in and help her handle her business.
Jeff used those words
On February 17th, 2024, defendant again reports to Charlie how Wendy's hearing went, talks about how there are plans to seek to have Dan Markel forced to submit to psychological testing. Here, defendant is 7 months after the divorce and just 5 months before the murder, responding to Dan Markel's filing a request to produce, and she says it's time to give it to him. Let's aggravate him the way he's trying to aggravate you. And what can your attorney do to be proactive to give him some grief? Can't you meet with her and work out a plan of attack? Something has to be done with this asshole.
These were the emails not
This is
provided
5
to the
months before the
expert,
murder.
which the
Here,
expert
defendant texts Charlie
said yesterday.
about Wendy yet again. If you speak to Wendy today, tread lightly. Don't ask questions about the depot, her lawyer, etc. Tough time, and she's really stressed out. The asshole showed up at soccer yesterday, and she goes into a story about, he showed up at soccer and they got into it. And then she ends with such a fucker. Super amicable. Then we have this text on March 4th.
At least counsel's
switching
sarcasm is
gears.
clear.
This is about the birthday gift.
This is
Defendant
March 4th,
texts Charlie
2014.
that she's going to call him from the bathroom in Gainesville where she can have some privacy. Please pick up
Birthday
because I will have very limited alone time today. Erase this text after you read it. Then the defendant says, we'll speak privately about Dad's birthday gift. So erase after reading.
Burn after reading.
You might think, well, maybe she was just trying to keep the birthday gift a surprise. But why
what did
does
Rob
Charlie
say?
need to erase it? Harvey's not with Charlie. Harvey's with Donna. And according to Rob, there were no birthday gifts for Harvey unless the murder was supposed to be the birthday gift. Plus, in the text, Donna wants Charlie to delete after reading the text that doesn't mention the birthday. She doesn't say anything about deleting the one that does mention the birthday. Rob Adelson was present at the birthday party, which did take place between the 2 trips that the hitmen took to Tallahassee. And there were no birthday gifts, according to him. The defense suggests that the friends coming to the party was part of the surprise, but then they also suggest that Harvey sent the evite, so I don't think they can have it both ways. He can't send the invitations and be surprised by the friends. The next week, Jeff Lacoste, Wendy Adelson, Catherine Magbano, and Charlie Adelson all go out to dinner. That's the first meeting between Wendy and Jeff and Catherine Magbano. At dinner, Magbanoa mentions her ex having several run-ins with law enforcement. That stuck out to Mr. Lacoste.
It's unusual
After dinner in the hot
conversation.
tub, Charlie bragged about having connections to people on the wrong side of the tracks. Notable in the same time frame, March 21st, 2014, the defendant signs a lease on a condo in South Beach, a condo where Wendy, after Dan's killed, would move in with her kids. They say, oh, that was a weekend place, so it's pretty convenient timing. You just happen to get this other house and have it set up for Wendy to move into after
I didn't realize the timing of that
murdered, and she's
until she
able to
pointed it out.
relocate. 3/26/14, this is when Dan Markel officially files the grandma motion, which takes aim at the defendant raising more allegations about failure to comply with the Skype thing, Wendy leaving the boys with her parents rather than giving him the right of first refusal. And he says by flouting the right of first refusal, the former wife creates conditions for Mr. Markel to be disparaged in the presence of the children by their maternal grandmother. Dan Markel then alleges all the same allegations about the defendant disparaging him to the kids that he outlined in that previous email in December. Contrary to what the defense said in court, in his prayer for relief, the remedy Markel was seeking was to have the court order this defendant to have no contact with those boys unless she was supervised, because he didn't want her disparaging him to the boys, and because it was a violation of the right of first refusal, in his opinion, for Wendy to leave the boys all the time with her mom and not give him a chance to have them if Wendy wasn't going to keep them. How do you think Donna took this information? She refers to those kids as hers. She was the one sacrificing her time at the office to be up here in Tallahassee doing for those boys. She had invested so much of her own time in this fight against Dan Markel to try to get a win for the family. And after all that investment in those kids and all the money spent on the attorneys and all that time spent at the kitchen table working on those divorce filings, Donna Adelson was losing. The boys and Wendy were stuck in Tallahassee. Wendy wasn't working at the law firm in South Florida, raking in a bunch of money and dating some new guy that she pre-screened for her. And Grandma's Sunshines weren't in South Florida. That's where they belonged. That's what was best for them. They had lost in court. Wendy wouldn't comply with Donna's plan of action, and Dan Markel apparently wouldn't take a bribe or be strong-armed to allow his kids to come to South Florida. But as it turns out, Jibbers still had not beaten the Adelson family because there was still another option, the option of hiring the hitman. Charlie joked about hiring a hitman, but he had also been actively pursuing that option at least since Halloween of 2013. Over the last several months, Charlie had several conversations with Catherine Magbanowa about this job, which started as a request to harm and then eventually revealed itself as a murder for hire. Recall that Magbanowa said that often when she and Charlie would discuss the murder and the pressing need to get it done, he would emphasize to her that the toll that Wendy's situation was taking on his parents emotionally and physically as they were stressed to the point of being physically ill. So he would often tell her that's the motive. That's why we need to get this done. It's like stressing out my mom. On May 16th, 2014, 2 months before the murder, Wendy was added as a resident to that condo in South Florida. On May 30th, 2014, Donna sends Charlie the text, quote, "Horrible morning with Danny. Tough conversation with her." This text was sent less than 2 months before the murder. The drama is continuing. Everyone's still fighting. It's contentious. Prior to the June trip, Charlie had prepared an envelope containing the murder instructions. He told Catherine Magbanowa that he used gloves when handling the paperwork inside, that he printed it not on any printer that can be connected to him.
Yeah, it's somebody else's
and that she
dental
was not
office.
to touch the contents of what was inside. She was to deliver the envelope to Sigfredo Garcia.
Yeah, don't touch it.
She followed these
We don't
instructions.
want to wash it.
In early June, she came back to Charlie asking for travel expenses for the hitman. She got a couple $100 to give them to rent a car to come up here. They came. Well, let's back up just a little bit. They rented the car June 2nd, 2014. Magbanowa drops Garcia off at the rental car place, and then Magbanowa calls Charlie on the way home from the rental car place. And you saw the evidence of this in Sergeant Corbett's presentation.
Yeah, these
Charlie
slides were really
immediately
helpful
calls
in Corbett's
Donna
presentation.
on the landline after hanging up with Magbanowa. How do we know that he talked to his mother and not his dad since it was the landline? Well, because a few minutes after that call, he talks to Dad on his cell. So probably didn't talk to Dad on the landline, and then a few minutes later talked to him on the cell. Garcia and Rivera traveled to Tallahassee. This is June 4th, 2014. Rivera notes that Garcia is in possession of a piece of paper. Paper has a photo on it and some information. This information allowed them to locate and follow Dan Markel's vehicle, a black Honda Accord with the tag number 534YBM. Information that the defendant had written in her 2014 planner. Wendy and Jeff Lacoste have their coffee date,
In the planner.
at which she cancels their planned trip to California on July 11th through the 17th. She offers no real explanation for why she's canceling, except to say that she's real worried about being able to pick up the boys on the 18th. The 18th, of course, ends up being the day that Dan Markel is killed. Later that night, Jeff Lacoste goes to Wendy's, and she's a nervous wreck. She won't tell him what's wrong, but her stomach's upset, and he goes and gets her Pepto-Bismol. The killers are in town when that happens. The hitmen spend a day and a half following Dan Markel around Tallahassee. Here they are near the park there by his residence. scope out his residence. And although Rivera had already purchased the murder weapon, a revolver that he got on the streets for the express purpose of killing Dan Markel, they lost him, or he was with the kids, or for whatever reason, they did not get the job completed on the June trip. After the hitmen failed to get the job done, Charlie tells Donna on June 7th of 2014 that he's still working on Dad's birthday present. And she says, I know you'll come through.
It's a tough birthday.
Sometime around June 11th, Jeff Lacoste went over to Wendy's residence and observed her living room TV to have some impact damage. This was the same TV that Charlie got Wendy as a divorce present because it was cheaper than hiring a hitman. The location and damage to the set did not appear consistent with something the kids could have caused, at least to Jeff. Note that this is over a month before the murder that Jeff observes this damage, so it was hung out there for a while.
And he was annoyed. He had
June
to sit and
13th,
watch
the
it.
defendant has a note in her calendar to consider canceling Harvey's birthday party if that's what he wants to do. Now, this is between the June and July trips, that there's a note to herself to talk to Harvey about whether or not he wants to cancel the party. Rob Adelson testified that there was no illness or anything going on in the family that he knew of that would potentially result in the canceling of Dad's party. This note may be contemplating that if the murder had happened on the June trip, that Harvey might decide it's not appropriate to go through with the party and we need to cancel these invitations. Wendy took a photo with Catherine Magbanowa on the beach 2 days after that note to self in the planner. Here she is in front of the South Beach condo, pictured with Catherine Magbanowa. That photo was taken June 15th of 2014. Wendy sends Rob a text with a picture of her and Jeff Lacoste. This is June 28th of 2014. She includes a request to her brother Rob not to tell her parents about her relationship with Jeff. This suggestion of a secret boyfriend later prompted Rob to suggest Jeff as a potential suspect to the FBI, a secret boyfriend. This was also a little odd that she sent this because Wendy
Rob's
never talked to
testimony was
Rob
really
about her
helpful.
boyfriends, and also because Jeff had already met her parents several times.
But Rob didn't know
June
that 'cause
30th
Rob
of
didn't talk to them much,
2014,
right?
the defendant comes and gets Wendy and the boys from Tallahassee to take them down to Miami. Remember how she doesn't let Wendy drive with the boys to Miami. She rents a car and comes here and picks them up and drives them to Miami herself. And I think Harvey comes with her. And Wendy was to be in South Florida for 2 weeks. In the time between the June and the July trip, Charlie begins to put more pressure on Catherine Magbanowa to get the murder done. On several occasions when he and Magbanowa were discussing the murder, Charlie would step out of the room to call his mother and then return and advise her that the murder needed to get done as soon as possible because his parents were so stressed and worried about Wendy's situation. Charlie painted Dan Markel as an awful person to Catherine Magbanowa. He was making Wendy's life hell. He was stressing out her parents. Katie knew somebody who could get this thing done, and he wanted it done. Magbanowa understood that the murder was needed urgently to relieve the stress on Charlie's mother. July 1st, 2014, we have a single call from Garcia to Harvey Adelson. This call did not connect. Appears like it went to voicemail. And we would later learn from Magbanowa that this was after an incident in which her two love interests.
This call was so fascinating to me in this case because I didn't realize how much this one call connected this entire case. So as the prosecution's going through the timeline, that July 1st call that went to Harvey's voicemail is what pieced this all together in the early investigation and let them get the rest of the search warrants. 1:37-second call. So she's going to talk about that right now. I forgot that was July 1st. I'd forgotten the date of that call.
This call did not connect. Appears
I'm going
like
to back
it
that
went
up
to
and let her
voicemail.
talk about it. because I interrupted.
Murder was needed urgently to relieve the stress on Charlie's mother. July 1st, 2014, we have a single call from Garcia to Harvey Adelson. This call did not connect. Appears like it went to voicemail. And we would later learn from Magbanawa that this was after an incident in which her two love interests, Charlie Adelson and Sigfredo Garcia, had a little bit of a run-in. Garcia was angry and jealous about Magbanawa dating Charlie and tried to confront Charlie. After this attempted confrontation, it's believed that Garcia was trying to call Charlie, but ended up getting Harvey. And that was that one hang-up call, but it ended up being important because it showed up on the tower dump, Garcia's number, and then when we cross-referenced it with all the Adelson numbers, that was the first match that gave us Sigfredo Garcia's name. We would later learn that the real connection between the Adelsons and the killers was Catherine Magbanawa and her relationship with Charlie Adelson. The text messages found in Charlie's iCloud corroborate what Magbanawa says about the interactions and the call made the day before. So here she's saying basically Garcia's being ridiculous and childish. Harvey's birthday Evite goes out on July 3rd of 2014. The Evite addresses the boys by the last name Adelson. Their name was Markel. This is 2 weeks before the murder of Dan Markel. Even though the Evite says hosted by Donna and the party was for Harvey, the defense has suggested that it was Harvey and not Donna that sent the Evites.
Oh,
the
the
evidence
secret
showed
birthday.
otherwise, and Corbett told you there was some follow-up from Donna with the Evite people.
He's
She
inviting
sent
everyone
that
to his
email.
surprise.
A text is sent from Wendy's phone to Dan Markel on July 6th
your
of 2014. At the time this text was sent, the phone was present at the South Beach condo where the defendant lived. Dan Markel confirms, yes, I'm going to be in town to get murdered, not specifically, but he's asked, are you going to be in town
What's your
July 14th
schedule?
through the 18th? Those are the dates the killers were here. And this, despite the fact that the schedule for that week had already been decided way before this text. And Wendy was already scheduled to have the boys on that Wednesday, which is what she's asking about. She doesn't ask about the whole week that he's got the kids. She only asks about the 14th through the 18th. And I think the killers ended up coming to Tallahassee on the 15th through the 18th. Obviously, Dan Markel was killed on the 18th. July 11th, 2014, the defendant comes back to Tallahassee to bring Wendy and the boys home. Okay, so bringing her home from the Harvey birthday party. That same day, both Harvey Adelson and the defendant separately, 8 minutes apart, email Wendy Adelson about her TV repair appointment that's going to happen on the day of the murder. July 13th, Wendy and Lacasse meet at Wendy's house, and she's an emotional wreck again for no
I'd
apparent
forgotten
reason.
some of these dates.
Lacasse impeached her regarding some statements that she made during a discussion of their relationship that evening in the context of, you know, you got to get past this moving to Miami thing. I mean, you're not going to be able to move to Miami. And she
What
says,
does she say?
you know, yeah, it's not an issue unless something happens to Dan. And she says, can I tell you something in confidence? And she makes the chilling statement at that time that her brother, besides joking about hiring a hitman because it was buying a TV because it was cheaper than hiring a hitman, he also, in fact, had looked into hiring a hitman to kill Dan Markel. This conversation occurred just 5 days before the murder. July 15th, the Prius is rented. July 16th, Rivera and Garcia traveled to Tallahassee. July 17th, Rivera and Garcia followed Dan Markel around Tallahassee. July 18th, murder day. You guys okay? Anybody need a break?
Just checking in with the
July
jury.
18th, 8:11 a.m., the defendant texts Wendy about the TV repair appointment. The TV repair appointment was planned for between 8 a.m. and noon that day.
When was
And she
Jeff supposed to be
says
leaving? 11
They are
a.m.?
on their way over now to help you with the TV sets in your living room. case she didn't know which TV set it was. This is the TV that Charlie bought as a divorce present because it's cheaper than hiring a hitman. Could it be a coincidence that this TV is also the alibi for Wendy on the day of the murder? While he's being murdered by a hitman?
Weird coincidence.
And then, as we know, the defendant later uses TV as code when she's speaking on those wiretap calls.
TV's about 5.
8:20 a.m., Wendy texts Charlie, "This is so sweet." We don't know what it means, but she's texted him that, and then she deleted it. Sometime between the time it was sent, 8:20 a.m., and the time that her phone was cell-brighted or downloaded at the police station later that day. 9:04 a.m., Dan Markel leaves a voicemail for Wendy telling her he's headed to the gym and wants to know if it's okay for him to pick up the boys early and take them swimming that afternoon. Wendy says no, he cannot take the boys swimming after school that day. Meanwhile, what's going on across town? The Prius is following Dan Markel into the gym parking lot. There it is at 9:16 a.m. 9:19 a.m. to 9:37 a.m., Charlie and Wendy talk for 18 minutes. Wendy and Dan argue back and forth a bit about him wanting to take the boys swimming, but after getting off the phone with Charlie, Wendy concedes the argument with Dan and says, "Okay, you can pick them up and bring them back to me."
She
when
talks
you're done
to Charlie
swimming."
and
But
is
of course,
like,
the swimming
"It's
plan
fine."
didn't happen because Dan Markel was killed. 10:38 a.m., the Prius follows Mr. Markel out of the gym parking lot. 10:45 a.m., Mr. Markel is shot twice in the head, in his vehicle, in his garage. 10:51, the Prius is captured fleeing the scene on a city bus camera. 11:01, Mr. Geiger calls 911.
I hate the way they're switching back and forth
11:15, law
on the
enforcement arrives at the scene
presentation.
and sets up a perimeter. Dan Markel is rushed to the hospital. He's treated, but the damage is catastrophic. It's not survivable. And he passes away about 14 hours later. 12:30, the hitmen, now headed back south, turn their phones on. They had turned them off for the homicide. They turn them back on. The first phone call that either one of them makes is Sigfredo Garcia to Catherine Magbanoa. They want their money. Where is Magbanoa getting the money? From Charlie. 12:45, so while the killers are calling Magbanoa and heading south, Wendy goes out of her way to visit the crime scene, encounters a roadblock and crime scene tape.
Is the least curious person ever.
Per the
Turns
officer at the
around.
roadblock, she would have been able to clearly see the police activity at her former residence. The residence where her children currently lived half the time and where they woke up that morning. Yet she abruptly turns around and leaves. She does not make contact with the officer to ask what's going on. She does not call the police to inquire. She does not call Dan Markel to say, "Are you okay? There's a bunch of cops at the house." She does not call the daycare to make sure her children arrive that morning and are okay. Instead, she proceeds to the ABC Liquors, purchases her Bullet Bourbon at 12:49. She's later approached by law enforcement at lunch and gives a law enforcement interview in which she says, "My parents have more reason to dislike Danny than almost anyone else." This echoes Rob Adelson's testimony that his mother hated Dan Markel at the time of his murder. And even from the periphery, it was known to Ryan Fitzpatrick as Charlie's friend that his mother did not like Dan Markel. In her law enforcement interview, Wendy suggests her mother is someone who is very angry at Dan Markel. She suggests Charlie when asked if someone might do this on her behalf. She calls her mom, and the defense has put that call into evidence. 7:04 p.m., she tells her mom that there's been a shooting And afterwards, Wendy expresses relief that they sounded surprised. 8:59, defendant arrives at Charlie's with the murder money. How do we know she went there and that they aren't just old people that drive really slow?
That's what the defense
There's
asked.
a text message outside your house. I guess we're going to find out what that means, but I guess it's not going to be outside your house. And he says 10 men. Guess we're going to find out what that means, but apparently it doesn't mean I'll be there in 10 minutes and meet you there and get the money.
Oh, I don't think they're going to have an explanation
About 10
for
o'clock,
that.
Catherine Magbanua joins Charlie at the house. Here they are making plans for that meeting. Next slide, please. Charlie answers the door with a gun in his hand. He's extremely amped up. He tells Magbanua, my parents just left. They both end up taking Xanax and sleeping over there for the night. The next morning, July 19th, 2014. So this is early morning hours, 1:25 a.m. I think we need the next slide. Yeah, 1:25 a.m., Donna and Harvey arrive at their Orlando hotel. In the morning, Charlie puts the money in Catherine Magbanua's trunk. She's seen at 9:33 a.m. approximately, heading south toward Rivera's house,
We're on
where
the
she's going to
19th.
meet up ultimately with Rivera and Garcia and give them the money. Garcia takes the money out of the trunk where Charlie Adelson put it and divides it up between the three of them. Magbanua says she did not count her cut, but we know she put some of it in the bank, creating the largest monthly cash spike of any of the records we examined for her bank. This cash spike also occurs at a time when Magbanua was not employed. Rivera says his understanding was the job paid $100,000 total to be split between the three, and that the cut that he received was roughly a third of that at $35,000. We don't know the amount of Garcia's cut, but we know he got at least enough to buy a car and a motorcycle. All right, so July 20th, the defendant and Harvey Adelson take Wendy and the boys back to South Florida. 2 days after, not even 48 hours after Dan Markel is shot. They're gone. Relocation granted. On the way, Wendy receives a call from Detective Isom. She tells him the call's breaking up, and she hangs up, afterwards referring him to her
They're
lawyer.
breaking up.
Catherine Magbanua that day, or thereabouts, opens her Ziploc
dramatic
bag of money
interpretation.
and finds her cut to be $100 bills stapled together in $1,000 stacks. How
Why is
we
the
know
money
Charlie
wet?
keeps his money. She also notes that her cut is damp and moldy. She mentions this to Charlie, and he tells her that his mother washed the money.
Damp
Like
dollars.
laundered, like washed. Rob Adelson gets a call from Donna Adelson advising him not to talk
Not
to the
laundered,
FBI.
washed.
What? Rob Adelson gets a call from this defendant advising him not to talk to the FBI, just in case they call.
The FBI!
He
I had
says,
to.
Well, I already did. She says, well, you don't know anything anyway, and hangs up.
Right.
July 24th, 2014, Dan Markel was laid to rest in Canada. His children were not in attendance. August of 2014, the defendant registers the older child for flag football under the last name Adelson. His name is Markel. This is 1 month after their father was killed,
And they're
and
changing
already
the
he's
kid's
being
name.
erased from their lives. Within 1 year, their names would be legally changed to Adelson. Nine 12 of 14. The defendant refers to the younger child by the last name Adelson. 9/17 of 14. The first check is written to Catherine Magbanua, signed by this defendant. This is the murder money.
September.
even though Charlie has signing authority on this account, he could write these checks. He chooses to
Donna
connect
does.
his elderly mother to a murder payment? If she wasn't involved, there is no reason in the world why she would write these checks. The defense said in opening that Charlie told Donna to write the checks because it was his business. But half of these checks were written after the business was sold back to Harvey on October 2nd, 2015. Regardless of who owned the business,
Members of the jury, you are
I'm going to back up to that objection. The defense objected facts not in evidence. I'm going to back it up so we can hear what she said. The court overrules it, but I'm going to let it roll.
said in opening that Charlie told Donna to write the checks because it was his business. But half of these checks were written after the business was sold back to Harvey on October 2nd, 2015. Regardless of who owned the business.
Oh, no, that was in evidence.
members of the jury, you
When the
are
business is
relying on
sold.
your memory of the evidence in this case. You may proceed.
Thank you, Judge. And regardless of who owned the business at the time, all the Adelsons had an interest in the Adelson Institute.
That was in evidence, though.
All three of them had signing authority on that checkbook. But the defendant is the one that wrote that check. September 17, 2014, and the 43 checks that followed. Is that consistent with what we've heard? That she would just write the checks and not ask any questions?
It's not what Rob said.
We've heard that she is assertive, she's controlling, she's a details person. She ran that business and those people's lives. She ran a tight ship. We've seen her weekly planners where she plans out every detail of her own life, making meticulous notes. She kept detailed information about Dan Markel and lots of other things. Rob Adelson testified that she's not the type of person who's just going to
Write
do
checks.
something someone tells her to do. She's going to be asking questions. And we heard that Charlie testified that he told his mother about extortion. He says he was being extorted, right? All right, let's fast forward to October of 2015. Charlie's had a couple girlfriends since the murder and is now dating June Mchinda. Remember her? June, one of Charlie's girlfriends that testified, she said they were enjoying a
wanted to be the
fairy tale
cheerleader
relationship
for the
in October of
Dolphins.
15. During her relationship with Charlie, June observes that Charlie packages his money in an unusual way. $100 bills stapled into $1,000 stacks. June also observes the defendant to be in control of the family and super involved with the grandchildren. However, she found it odd that nobody in the family seemed curious about who killed Dan Markel, nor did they seem upset about the murder. Rob Adelson also noted a complete lack of curiosity on the part of his mother about this murder in the family. When he asked what the defendant thought happened to Danny, she said, quote, "I don't know and I don't care. It doesn't concern me." As someone who liked details and who always stayed on top of everything, her total lack of interest in who killed her former son-in-law, her grandchildren's father, is totally out of character. From
Wouldn't you
July
be
of
afraid?
14 to April of 16, Donna Adelson got everything she wanted. Wendy and the kids were in South Florida where she could drop them off and pick them up, manage their schoolwork, their tennis, their piano lessons,
And then the
have her
bump.
sunshines with her every day. All the while, she's steady paying for the murder of their father. Everyone is living their best life, thinking they've gotten away with murder until the bump. Everything changed on April 19th, 2016, when the bump occurred. The undercover approaches Donna and hands her a piece of paper. The most human reaction in the world is to look at the paper. Uh-oh.
That sounds like a tech uh-oh.
I think we got one more. There we go. The defense told you in opening that this defendant is a normal person just like you and me. There is nothing normal about the way she conducts herself in the minutes, hours, and days after the undercover approaches her with that paper. The bump and the wire were designed to expose the co-conspirators and their roles in this conspiracy, and it did. Here, we're just 10 minutes later. There's only one
10
thing a
minutes
normal person
later?
would do if approached on the street by a stranger who appears to be threatening harm to them in some way. A normal, or maybe I should say an innocent person would, 1, look at the paper.
What does Donna
She didn't do that. 2, get to safety. Get help, contact law enforcement or your husband or somebody that's going to come help you. Get somewhere safe. What you would not do is lead the bad guy right to the grandchildren. The last thing a normal, innocent person would do is go get her little grandchildren and walk right back down the same block with them where this stranger just approached her. But that is exactly what she does. Then she gets on the phone with Charlie and says absolutely nothing about Dan Markel. It's pictures on the paper. What she does say on the wire, which by the way is direct evidence.
The thing
I know y'all like that.
about the two
Some
of
direct
us.
evidence. When Charlie asked Donna on State's 99 call A,
Sounds like they're going to play it.
What's that?
does it involve me or other people? Well, probably both of us.
Well, probably the two
That
of
is
us.
direct evidence. If anyone in that jury room wants to acquit her, make them tell you how that is not a confession. In call B, Charlie calls back because he can't stand it. And he asks
Oh,
his
Charlie couldn't
mother,
stand it at all.
will you send me a picture of the bump flyer?
Yeah, let me ask you this. Do you want to take a picture of the letter and send me a second?
Send it to me. Donna says, I don't want to do
No, I
that.
don't want to do that. Well, why not? Why not? Normal, nice little old lady who knows nothing about this murder and has nothing to do with it. If Charlie's the one making you write the checks and Charlie's the one that knows something about it, send him a picture of it. He's asking for it.
I don't know
She
what
doesn't
this
want
is
to
about.
do that.
Right.
Why not? Call C, Charlie calls back to say,
I'm going to read this. They're playing it in court. It's hard to hear, but they have transcripts up for the jury that's going along with the calls. This is call C. Hey, Charlie. Donna says, Charlie says, hey, sorry about that. Quick question for you. Oh, one thing I was going to tell you, obviously, don't talk about things in the apartment or any place. Donna, oh, obviously. And then Charlie proceeds to talk all over the wires for the rest of the day and the next following days. But Donna doesn't say, why wouldn't I do that? Oh, obviously.
don't talk about things in the apartment. Oh, obviously. Obviously, we can't talk about things in the apartment. What's obvious? Is it obvious to you?
What is it? Kind of exactly what they asked for.
More of the call.
This TV was probably about 5.
This is the next call. I'm just going to read the transcript that's on the screen. Charlie, can I just ask you, what did they ask for? Donna, I don't know. The TV was probably about 5. Charlie, they asked you for $5,000? Donna, uh-huh. Charlie, that's fucking crazy.
she's the original code talker. This TV, and look what he says. Well, they asked you for $5,000. He decodes it. He's not the one talking in code. He's decoding it and saying what he's picking up what she's putting down.
He was definitely not picking it up quickly enough.
There's no TV mentioned by the undercover operative that approached Donna Adelson on the street. Couple big takeaways for you, please. Innocent people do not talk in code. Second big takeaway, TV is code for the murder throughout this case. You got Charlie's joke, Wendy's chilling statement to Jeff Lacasse, the alibi of the TV, and now here we've got this TV again. A TV that's the alibi for Wendy. It sat broken for over a month so that a repairman could come out to be her alibi on the morning of the murder. An appointment that her parents set up for her, which was pointless because the TV was smashed and of course could not be repaired. Then she claimed she had an 18-minute phone call with Charlie about the fact that a smashed TV can't be fixed before she got in her car and went to the crime scene, where she did not get out of her car or make any phone calls or make any inquiries about what was going on at the house where her kids lived. Then Donna says that the undercover mentioned an ex-girlfriend.
Yeah, I
I'm going to pause and read what's on the screen. The calls are really hard to hear in the presentation. I'm sure in court it's easier. Donna, I don't know. The TV was probably about $5. Charlie, they asked you for $5,000. Donna, uh-huh. Charlie, that's fucking crazy. Donna, uh-huh. Charlie, yeah, Donna, and mentioned, like an ex-girlfriend.
Whereby, without knowing which ex-girlfriend, Charlie calls not his most recent ex-girlfriend, not the one before that. He only calls one, Catherine Magbanowa, because that's the only one he did a murder with. Because he probably did have a general idea what his mother was talking about.
She said you probably know what it's about. It involves the two of us.
When Charlie brings up going to the police, his mother says, that's not a good idea. Why not? Then instead of notifying the police, Charlie and the defendant leave the safety of her very secure building and meet at a marina just 300 yards from where she was approached by the undercover. They were observed speaking very intensely to each other in low tones.
Wait, they gotta go
After
outside.
that meeting, Charlie goes to Dolce Vita. This is the restaurant where he meets up with Catherine Magbanowa, and we are able to capture some of that conversation that was had there. In that recording, we hear Charlie make statements that are not only incriminating, but that also are totally inconsistent with the defense that he would later offer at trial. Pause on the wiretap here for a moment just to go to what his defense was and what we've learned about that defense. I told you earlier that he said that Magbanowa, Garcia, and Rivera acted alone. They just came to Tallahassee and killed Dan Markel, kind of in the hopes that they would get paid. There are several pieces of evidence that Charlie had to explain, and he designed a defense that he thought would do that. First, he had to explain that he's got this close connection between his girlfriend and the hitman. So the obvious defense there is, she heard me griping about Markel and she thought she was doing me a favor, so she did it on her own. Well, the problem with that is, normally you're not gonna have your extortionist spend the night with you. You're not gonna have the woman that has murdered your former brother-in-law spend the night with you. You're not gonna inquire about her plans to go to the pool the next morning if she's, just murdered your ex-brother-in-law. So to explain these messages, he testified that he did not believe she was a part of it. She wasn't one of the extortionists. I was extorted by the killers. I had nothing to do with it. No one in my family had anything to do with it. But I thought that Magbanua was just a victim of the hitmen too. She was a go-between for them. She was protecting him from them. All the money he and his mom were paying her, cash and checks, were going to the hitmen, not for the benefit of Catherine Magbanua. Even the checks that were being deposited into her bank account, he said he believed she was taking out and giving the money to the killers. It was just funneling through her account so she could get insurance for her kids. So Charlie testified that he had previously mentioned to Magbanua the $1 million offer that his family was going to give Dan Markel, and from that she deduced, oh, he's got a bunch of money. So she ran her mouth to her associates, and her associates took it upon themselves somehow to figure out who Dan Markel is and where he was and kill him on their own. Per Charlie, it was Katie alone that came to him on the night of the murder and demanded money on behalf of the hitmen, with the threat that if he didn't pay, they would kill him or other members of his family. Since he didn't have that much money, Magbanua then negotiated
And his
a
mom bought it
layaway
the same
plan
night,
with the hitman
right? The
for
layaway.
him to pay her monthly
And then it showed up the same night.
to go toward this amount of money that the hitmen were demanding.
Doesn't make any sense.
He agreed. He opened up his safe, not at gunpoint or anything, and gave her all the money that was in there. And because she needed to show proof of employment to get insurance, that's why that money was funneling through her account. It was all for the extortionist. The problem for Charlie with that was that he had already agreed to put Magbanua on the payroll between the two trips. You see here in June, he hadn't done it yet, but he says no problem. Okay, so he'd already agreed to do it before she allegedly extorted him. Even though he had signing authority, it's this defendant that wrote those 44 checks. So if he's being extorted, why doesn't he write the checks? It's this extortion theory that we're saying that the defendant adopted when she heard Charlie's testimony and texted everyone she knew that what he just said on the witness stand was the truth. There's a concept in the law known as adoptive admissions. That's when one party makes a statement and the statement is adopted as the truth by another person. So when Charlie says in those first couple wire calls, if there's a threat, you go to the police, it's of interest that Donna doesn't say, what do you mean if there's a threat? We've been extorted for 2 years. There's been a threat for 2 years.
That's a good point.
Charlie did tell
They
his
keep saying
best
there's
friend
no
Ryan
threat.
Fitzpatrick about the bump. So what I want to highlight here is the difference between their conduct during this like alleged extortion that was going on for 2 years versus the way they act after the bump, which we know was a ruse, but was supposed to be like a blackmail effort. So Charlie tells Ryan Fitzpatrick about the bump. He also tells him about the confrontation with Garcia in the roadway on July 1st, 2014, but he never previously confided in Ryan Fitzpatrick about, even though it's his best friend, about being extorted for 2 years by this girlfriend of his or her associates. Ryan also noted a major change in Charlie's demeanor around the time of the bump. He was displaying a level of stress and anxiety that was not present before the bump, evidencing that his story about being extorted the whole time is false. June Mchinda noticed these changes in Charlie's behavior as well, but she also noted a major change in this defendant's demeanor after the bump. Although she didn't know about the bump, around this time she observed the defendant to be a mess. She had a swollen face, was crying, and said she was on painkillers for stress. On the balcony
Why
of
so
the
stressed?
Icon, which I'm not sure this is the right balcony, but some high-rise, the defendant told June Mchinda she felt Danny was haunting her from the grave. Why would she make that statement unless she felt guilty about having wronged Dan Markel? So keeping that all in mind, let's see if the other evidence in the case makes sense with this Charlie version of events that this defendant has adopted. starting with his statements to Catherine McBanoa at the Dolce Vita restaurant. Charlie says to Catherine McBanoa, if they had evidence, we'd have already gone to the airport. Even if they bug your phone, you're still not talking about any of this. Like his mother, Charlie emphasizes that the co-conspirators should not talk about what they know on the phone. The cops would only bug your phone to get information about the murder, right? I mean, why are we not talking on the phone if we had nothing to do with it? Why are we not talking on the phone if we're being extorted and we're the victims here? Why are we not reporting it to the police if we're being extorted and we're the victims here? If the cops are listening, we're not reporting it to the cops because we're afraid they'll come kill us if we do that. Well, talk about it on the phone. If they're listening, they'll hear and they'll know you're being extorted, but they don't do that because it's bull.
Well, she said what she thinks they're thinking.
About how he's going to start arming himself. So Charlie says at Dolce Vita, I'm going to start, I don't remember his words exactly, but he's going to start carrying a gun and he's prepared to shoot. And he goes through a scenario where, you know, he might have to kill somebody in his driveway and the cops will not ask any questions because he's a dentist.
He's an oral surgeon, everybody.
If he's been an extortion victim for 2 years, why is he just now starting to carry a gun? And then he says, if somebody comes up to me asking for money in my house, he's going to shoot them. This is the same guy that's been like too paralyzed by fear over the last 2 years to report his victimization to the police or to anyone. This is a guy of considerable resources that could, I don't know, get some muscle or some help or some something.
Security.
Not just roll over and open his safe and give all his money to some girl that's not even armed. This is a tough guy that would never tolerate somebody coming up to him at his house and asking for money. But he's talking to the woman who supposedly did that exact thing, came into his house and asked him for money. He doesn't mention, well, I gave you the money, but I'm not giving this guy any money. You know, it's like they don't mention this extortion. So you see the problem. But this defendant doesn't see the problem. She says that that's the truth. The truth is out, thank goodness. The truth is out after we remained silent for so long.
All of those texts they showed.
Defense does not have to prove anything, but through cross-examination and the witnesses they called, they chose to kind of suggest, you know, maybe Charlie was involved, maybe Wendy was involved. But there's no connection to our client. But Charlie's story was that he and his mom were involved in the sense that they were extorted by Catherine McBanoa, so they knew who did the killing. They just didn't speak up because they were scared, because they were being extorted.
Where else do they use that word, extorted?
Donna Adelson calls Charlie's story the truth when it suits her to support her son and proclaim his innocence during his trial, but now she kind of wants to distance herself from that because it's ridiculous story. It's not
Donna,
the truth. The truth wasn't out.
Your face is facing.
Don't let her distance herself. She adopted that statement as the truth. She's stuck with it.
There's a preface.
And Jackie, the defense attorney, has asked to approach. Emily, why would they do that?
Take you to the jury room.
And the jury is out during closing arguments. Why would the defense be objecting to this? I suspect the defense thinks this is getting awfully close to commenting on the defendant's right to remain silent. You cannot comment on the defendant remaining silent. However, the court did grant the rulings about adoptive admissions. The prosecutor, I think, is talking about the adoptive admissions of Donna in the text messages. She adopted that admission. She was texting that what Charlie was saying was the truth. So, let's see the argument on the record. The jury is going out.
Yeah, leave everything right there on the chairs, please.
But I suspect that's what the defense thinks. I'm going to go ahead and close the poll about which defense attorney will be doing closing. It's 48 for Fulford, 52 for Zellman, but Fulford's making this argument indicating she might be doing closing, but we'll see. So the jury is out.
Everyone can be seated.
He's
Ms.
gonna-
Fulford, you may argue what you're seeking to raise.
He's going to allow them to argue this on the record because I think Fulford is going to argue that this is inappropriate comment on the defendant's right to remain silent. Let's see.
Judge, comments being made in the closing argument of the state, and I don't like to interrupt closing, so I apologize for that. But there have been several comments that have been made that are burden shifting and commenting on my client's right to remain silent. She's stood before this jury and said that the defense has some other version. She said this in a text, but now they're saying something different. We don't have an obligation to answer any of this. She's insinuating to the jury that we're going to come up there and provide her version of events. She chose not to testify.
Mr. Kappelman, any argument concerning this?
Ms. Adelson has made adoptive admissions and has suggested other alternative theories that have been developed through cross-examination. I'm entitled to comment on those theories.
Concerning this, Ms. Fulford, as I've heard the closing argument and the evidence, my recall of it, and my notes as well as to what occurred during the trial,
There were adoptive admissions.
adoptive admissions as it relates to statements that occurred during Charlie Adelson's trial. While she has not testified, the prosecutor has not made any direct comment on her not testifying in this trial. Also, as well, it is clear she has no burden to prove anything. The state is entitled to argue reasonable inferences from the evidence in the record. We will take a break at this time. If the defendant needs to use the restroom, bailiffs, please take her. If anyone else needs to, please stretch your legs or use the restroom at this point as well.
I need to stretch my
Ms.
patience.
Kappelman, on my clock, you have 35 minutes remaining.
Oh, that's getting awful close. That's getting awful close. And that's what we thought the defense was going to argue. The defense said it's burden shifting. The court reminded the defense, somebody like ran into the camera, that for all of you who are like, help, I'm lost. Okay, let's just come on back real quick. During the prosecutor's closing argument, the defense made an objection. The court, I think the same way I did, believed that the defense was going to argue that the prosecution was commenting on the defense's right to remain silent, which you cannot do at all. The court had the jury leave so the defense could make that argument and put that argument on the record. And the defense did immediately make the argument that they thought the prosecution was burden shifting, and then that they thought the prosecution was commenting on Donna Adelson's right to remain silent. The prosecution's response was, these are adoptive admissions. Donna texting everyone in her phone, the truth is finally out, at the same time that Charlie Adelson's testifying in his trial came in evidence. So Donna saying the truth is finally out. Finally, the truth is there. Dan Rashbaum, Charlie's attorney, proved extortion. All of these texts are things the prosecution said we're allowed to argue the inferences from them. We're allowed to argue that Donna adopted Charlie's statement when he was on the stand. And the prosecution didn't even go the step further and say, and that's exactly what she said in all these writings to the jailhouse informants in the script. Extort. The court agreed with the prosecution in this. The defense did not argue any further, and the court is allowing the jury to take a break before closings continue. I think it highlights for the jury that, ooh, this is bad for us, because the prosecution wasn't out of bounds, wasn't in the middle of doing anything that the jury would be like, what are you doing? So I think we'll just highlight what the prosecution was saying. All right, we're going to zoom. Hopefully we have enough room to get past this, barely we have enough room to get past this break. Okay. We're going to resume closing arguments. Welcome, everybody. Remember, the prosecution goes first, then the defense, then the prosecution has a rebuttal. The court said you've got 35 minutes left. That's supposed to include rebuttal. I wonder if the prosecution's going to push for more time. Some of you have asked, how do they determine the amount of time? The court asked the attorneys how much time they think they needed and then told them they could have that. And yesterday, the prosecution did say, ooh, don't hold me to that if we're talking about both closing and rebuttal. I think we'll see the prosecution ask for more time. The court will probably give it to them, as long as they ask before the defense goes, so the defense can also have more time if they need it. All right, jury's back in. Closings will resume, but that means she's been closing about an hour and a half, hour and 25 minutes. The court's going to tell the jury that the objection is overruled and they can move on. I mean, we're up in time to the bump operation. We haven't gotten to the flight yet.
Is overruled. Ms. Kappelman, you may continue.
And the flight's a big deal.
Your argument.
When the bump happens, you get to observe this defendant and her son in action working the problem. Neither of them would ever just lay down and let themselves get victimized by anyone. The bump is an actual recorded example of how these two act when they're threatened by an extortionist, in this case a blackmailer, and it's the complete opposite of how they say they've been acting before in the previous extortion. Several other things to note about this. Let's just compare like the two extortions, the prior one and the one with the bump. So when the bump happens, they resist, right? They don't open their safe up. It's only $5,000 compared to thousands and thousands of dollars they've been paying. $5,000, they don't pay. They resist. They take action. There are in-person meetings between Charlie Adelson and his mother, Charlie Adelson and Catherine McVanoa, and eventually with Dad too, about the bump and what to do about it. The defendant eventually downloads a recording app and records a call to the would-be blackmailer.
She's highlighting that
So she records this call.
Charlie's tale of extortion, they all go, oh no, and pay it. But in this one, they have in-person meetings, they get face-to-face, they do all of this, and they don't pay. They're trying to figure out what happens if they don't pay. It's a good juxtaposition.
An action that wasn't taken in the 2 years that they were being extorted previously. Charlie tells Ryan Fitzpatrick about the bump, although he never mentioned being extorted over the previous 2 years to Ryan Fitzpatrick. They investigate the bump. This defendant questions every aspect of the undercover. His look, his words, his behavior. You know, it's done like that, it's not done like that. Charlie enlists Catherine McVanoa to find out who it is and to handle it, right? Charlie says he's not going to take it lying down. He threatens Nazi shit if they mess with his family. Katie, I don't care what I spend. You'd better kill him because he's going to be a big problem. If he can't do it, I'll have someone else do it. Now these guys want an extra $5,000. You're going to kill him when you've been paying, I don't know how many, $100 and some odd thousand over the past 2 years. You weren't killing anybody then. They don't pay the money. If Mrs. Adelson has been blindly writing these checks every 2 weeks for 2 years, and her son has been paying additional monies each month on the layaway plan to the extortionist, and they've done nothing to investigate it, nothing to report it, nothing to stop it, but now they're going to launch a full-scale investigation over $5,000 more dollars? They don't call out Catherine McVanoa. According to Charlie and this defendant, they've been paying McVanoa now for 2 years, or at least funneling money through her. And here Charlie is talking to the person that's been collecting that money over all those months. But at no point does he acknowledge in that Dolce Vita recording or even allude to this long history of payments he's been making to her. This long history of extortion that's been ongoing through her.
The photos outside of Dolce Vita.
While they're still in the restaurant, Charlie gives McVanoa instructions. Say my friends have no idea what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate, but do not contact these people again or they're going to the police.
Now, Charlie
The
giving
whole
the
time
script.
you're talking, just say,
Right.
I don't know what's going on, and only use the words help and charity. Charlie proceeds to give Magbanua a whole lecture on blackmail, which is pretty ironic in
Charlie
light of the
mansplains
fact that his
everything.
defense is she was blackmailing me or extorting him.
Right.
And these are just a selection of the incriminating quotes from the Dolce Vita recording that you all heard.
Let me get to the airport.
After the meeting
part
with
of it.
Magbanua at Dolce Vita, Charlie calls the defendant in call F and tells her he had coffee with a friend and gave her some good relationship advice. Well, at this time, Catherine Magbanua is living with Sigfredo Garcia. Relationship advice. This means he talked to Katie and she's going to talk to Garcia and they're going to handle it and deal with the problem. Donna seems to understand this from the use of the term relationship advice. In call G, she's less sure than Charlie that this is the police. That's his theory. She's worried it might not be accurate. She says she has a different theory. He assures her repeatedly it's being handled, there's nothing to worry about, don't freak out. Magbanua does not want to make that phone call, though, and neither does Garcia. And you hear him
They start
pretty
lying
emphatic
about it.
on that wire that he's not making that phone call.
He tells Katie
But
to
everybody
deal with her
starts lying
shit.
to each other about having called it because everybody wants to reassure the co-conspirator up the chain that it's all good, I'm handling it, it's not going to come back on us. Charlie expresses concern that if they pay the money, they'll create a monster that will demand more and more.
What's interesting to me is she's talking about them reassuring everybody up the chain, getting to Donna. Ultimately, who takes care of the bump, though? Who handles it? At the end of the day, when nobody else gets it done, who handles it? Donna. Donna does.
More money. And
Yep.
the defendant replies to that exactly. So these calls go up and down the train cars, back and forth and back and forth and back and forth. Donna to Charlie to Katie to Garcia and back over and over again. In call R, Charlie is telling Magbanua that he has a very nice gift for Garcia's birthday. So if we think about his defense, the defense that this guy is extorting him after he, on his own, went and killed the ex-brother-in-law, he's gonna buy a birthday gift for the guy?
Well, birthday's just code for
The
other
man
shit
that
at this
he knows
point.
killed Dan Markel?
Here's some money to handle it.
And Donna says this is the truth.
Token of our
The truth
appreciation.
is out. Once Charlie and the defendant finally decide for sure that the bump is an undercover as opposed to a real
Extorter.
gang member, bad guy, you have never seen two people so happy to be under investigation for first-degree murder in your whole entire life. They convince themselves that they're untouchable. It's just the FBI fishing. They don't have anything on us. If they had anything on us, we'd already be at the airport. They're thrilled about it.
Charlie tries to taunt
Even
them.
on the call that the defendant staged and recorded to the undercover where she's proclaiming her innocence, it's pretty interesting the words that she chooses. For example, she
out of the
says,
loop.
I'm out of the loop.
Yeah.
How odd is that statement? It implies she knows there's a loop and she's not in it. The evidence has shown that the co-conspirators in this case were all on a need-to-know basis for their own protection. That's why Catherine Magbanua wasn't shown the murder instructions. That's why no Adelson had any contact with the hitmen. And that's why the defendant didn't attend the murder meetings with Charlie Adelson and his mother. They were insulating each other.
Plausible deniability.
She was out of the loop
Doesn't work
on
with
the
conspiracy,
stuff
though.
that the undercover was talking about. You know, my brother in Broward, Luis Rivera, she didn't know anything about Luis Rivera.
Or Tuto
She was
and
out of the loop
Tato
on that.
by design.
But she was in the loop on Catherine Magbanua. She knew an ex-girlfriend met Catherine Magbanua. She knew that Catherine Magbanua needed to give relationship advice to deal with the problem with her baby daddy. She was in the loop on paying for this murder, and she was in the loop with Charlie to get a win for the Adelson family. In May of 2016, after the bump, the defendant stops writing checks. Stops. The bad guy comes up to you and wants more money, so what do? You stop writing the checks you've been writing for 2 years under some threat? She's still not going to the police, but apparently she's not scared anymore. She's going to stand up to him and stop writing the checks, okay? Why? Isn't it because she's gotten spooked, because she's figured out this is law enforcement and they're getting close? In May and June of 2016, Garcia and Rivera are arrested. The news of this makes it all the way to Rob Adelson's operating room. When Rob next speaks to his mother, he says, hey,
2 days
they got the
later.
guys. They arrested the guy that shot Danny. Getting no response, he brings up the matter again, like, did you hear they got the guys that killed Danny?
This testimony was so
And
telling
she responds, I've got to go, and she hangs up. That is the last time that Rob Adelson has talked to his mother. Because he knew, and she knew he knew. A couple other problems for the defense that I want to point out as far as this whole Charlie story goes. These are kind of mind benders, so bear with me. In 2016, after the arrest of Garcia and Rivera, but before the arrest of Magbanowa, there's a text indicating, this is Charlie to Donna. Charlie says, basically that his lawyer was meeting with Garcia's lawyer. If Garcia acted alone and then extorted Charlie, why is Charlie's lawyer meeting with Garcia's lawyer? This is your extortionist. In fact, regardless of whatever the defense is, why are the two of them meeting? Unless they have common interests. And while
which is common with co-defendants.
Charlie's lawyer is at this meeting, he runs into Magbanowa. Magbanowa hasn't been arrested yet. She's up there seeing Garcia's lawyer. Well, why is she doing that? According to Charlie's story that this defendant adopted, Magbanowa is not in on it. She's a victim too of Garcia, her baby daddy, who's a bad dude. Why is she up at his lawyer's office? And when they learn that...
Right? The way that Katie Magbanowa testified, the way that she testified, does anybody think that Katie's like, I'm a victim of my baby daddy, he's such a bad dude? No, she testified and was like, I am a ride or die for this motherfucker. Not so much Charlie, but that dude, I have his back. That was her testimony. Not I'm scared of him. Her testimony was, I will face a life sentence in prison because I'm not going to dime out Garcia. Yep, that was exactly her testimony. It was telling Katie's testimony. Anyway, continuing.
That Magbanowa was up there, Charlie says, oh, my lawyer ran into Magbanowa while he was up there. He said she was nice and pretty, and Donna says, just like all your girlfriends. Well, why isn't she saying, what do you mean? Why is she up there? I thought she was a victim of Garcia, just like us.
Right?
All right, so here's another text. This one's from August of 16.
Donna didn't say, fuck that bitch.
Charlie and the defendant are discussing a
us.
newspaper article in the Tallahassee Democrat, which talks about a drug dealer that the killers had contact with when they were here in Tallahassee from Miami. And somehow Charlie deduces this drug dealer is going to be the state's star witness, and they're basically spitballing alternative defenses. This is August of 2016. They've known, supposedly, who the killer was. The truth came out that the killer was Garcia and that they knew about it since the time of the killing.
So why are they spitballing defenses?
But here they are saying, well, maybe a drug dealer killed Danny and a drug deal gone bad. And this is because the extortion thing hadn't been invented yet. The extortion thing didn't get invented until right before Charlie's trial in 2023, when he's trying to think of what he's going to say from that witness stand to explain all the evidence against him. Rivera gives a proffer That's on September 30th of 2016. Magbanawah gets arrested October 1st, 2016. You would think that if Charlie's story was the truth, he would be sleeping well for the first time in a long time, knowing that these folks that were taking his money and taking his mother's checks were off the
arrested.
streets and behind bars.
All arrested.
But to the contrary, you've heard evidence that he started freaking out around that time, and so did the defendant. Right? His behavior became erratic. He became angry, paranoid, stressed. Per June, he got a second phone. He started sleeping with a bag of clothes by the bed. He started communicating with her via WhatsApp.
Gun.
In April of 2022, Charlie gets arrested. In that Dolce Vita restaurant recording, he repeatedly refers to the bump as a blackmail attempt. He uses the word blackmail on the Dolce Vita recording.
Attempt.
But in trial, he switches that up to extortion, claiming that he and his mom have been extorted by the hitman. That was going on since 2014. But interestingly, in October 16th of 2023, so just 7 days before Charlie's trial started, this defendant, Donna Adelson, Googled the difference between blackmail and extortion.
Oh, there's the Google.
And the difference is that blackmail is the threat to expose some dirt on somebody. I know something about you, and if you don't pay up, I'm going to expose the dirt. Whereas extortion is the threat to harm somebody. You don't pay up, I'm going to harm you. Obviously, when they developed this defense in preparation for Charlie's trial, they realized the term blackmail was not a good word for them because it indicates they were somehow involved. You got to have some dirt.
Right, it means you got to hide
extortion,
something.
threat of harm. We're totally innocent. They did this on their own. They came to us. They extorted us. The defendant doubles down on this. So yeah, she said the truth is out, the truth is out. What does that really mean? Well, she doubles down on it when she writes that script for the witness, Drina Bernhardt, who she solicited to come in here and perjure herself to you all. What does she write in the script? Extort, underlined. This script is Charlie's story. She's again adopting it by writing it out for her
And there's
witness
the
that she's
script.
trying to recruit to come in and deliver it to y'all. Which of course backfires.
Stupid fool.
And according to the defense investigator who interviewed
one's
Bird, her
saying
first
that.
story involved the word extort. It's pretty unusual. Regardless of what you think of Drina and Bird, it's clear what the defendant was trying to do with them. I mean, when Drina Bernhardt had that script, and it read exactly like Charlie's whole story, with the exception of the part where he told his mom, it was in the defendant's handwriting. That was very compelling evidence that this defendant was trying to buy herself some witnesses.
The only one at the defense
I
table
do want
taking
to talk
notes
about
is
one
Donna.
more piece that has to be dealt with regarding this whole story of the extortion. And that's that Wendy wasn't in on it. Okay, there's a text November 1st of 2023. So this is after the truth comes out. This defendant texts Wendy Adelson, her daughter, and acknowledges that Wendy doesn't know anything about all this extortion stuff. And like, sorry, we had to
tell you.
keep it from you for so long kind of thing. If Charlie's defense was the truth, and Charlie and this defendant knew there was a threat to Wendy
It's a good
and her
argument.
kids from the people that killed Dan, it's a little shocking that they failed to mention it to her.
Why hide
Instead,
the
they let
truth?
her and the boys move to Miami, where the bad guys were, and, you know, walk up and down the street without any extra protection or even knowing that the killers knew who they were and had threatened their lives and lived there in Miami.
Good argument.
The defendant also acknowledges in this November 1st text at the bottom there.
She has got to be
Next one.
moving.
Previous
Because Georgia's
one,
gonna,
maybe?
she is gonna run out of time.
Okay, on that text, which is in evidence, it says,
I wonder if the slide wasn't working.
get the quote, "You know I'm next." This is the defendant to Wendy Adelson. "You know I'm next, but that won't happen. I'll take care of that." An important insight into her state of mind when you're considering this evidence about her flight to Vietnam. All right, 11/6/23, Charlie's jury is deliberating. The defendant gets angry about Wendy sending prayer hands. I guess, you know, your brother's on trial for his life and you're sending prayer hands, an emoji. She says, protected his sister for years. Protected her? Protected her from what? Would he need to protect her from the knowledge that they were being extorted? Or does it make more sense that the protection that's referred to is the murder, and the fact that this defendant is a little angry that Wendy doesn't seem to appreciate
Everything
what
they
she
did
views
for
as
her,
a huge
yeah.
sacrifice that her brother has made for her and her benefit. Wendy's not charged. This was all for her. 11/6/2023, Charlie is convicted. Nothing about the extortion defense adds up for Charlie, and it doesn't add up for Donna Adelson either. It's true that she did not pull the trigger. She's guilty of first degree murder as a principle,
She is
which we
starting to
talked
wrap it
about
up.
at jury selection, about how a party who assists in the murder can be charged and convicted the same as the person that pulled the trigger, even if they're not physically present when the trigger is pulled, which is not disputed that she was not. And you all agreed to follow that law, even if you ended up not liking it, right? I don't know if anyone admitted to not liking it, but you don't really know if you're going to like it or not until you have to make a decision. If you don't like it, you still must apply it. I know that I can trust you to do that. We talked in
She's
jury
wrapping
selection
up.
about the difference between direct and circumstantial evidence, and it's
She talked less about the flight to Vietnam than I expected, actually. I wonder if she's saving it for rebuttal, but she is wrapping up for sure.
true that this is largely a circumstantial case. You might recall my powdered donuts example. We had direct evidence that it was the kid not covered in powdered donuts, but we agreed that being covered in the powdered donuts was pretty good evidence that that's the child that ate the donuts.
I mean, they do get everywhere.
This case is not entirely circumstantial. I mean, she's covered in powdered donuts, don't get me wrong. But there is direct evidence as well, and I want to go over those.
I don't know if you're going to have time.
Rob,
She's calling back to
when
jury
told
selection.
that he'd already spoken to the police, she says, "Will, you
Which
don't
is
know
helpful.
anything anyway." That's direct evidence. You can consider that as direct evidence. To Charlie, after being handed an article about Dan Markel's murder, it involves both of us. It involves the two of us. Number 3, 44 checks to the killer.
I'm going to pause real quick because they put it on the screen, the countdown or the statements in the direct evidence as they're arguing it. I'm going to pause that. I missed the pause screen because they flipped away too fast.
It
And
involves the two
while I like counsel's hair, I would love to see the presentation a little bit more.
of us.
I'm going to pause when they get back to it.
44 checks.
There it is. Okay. I'm going to read this. This is what they're using in their presentation. You don't know anything anyway. It involves, quote, both of us. It involves, quote, the two of us. Dan Markel's vehicle info in Donna's planner. The statements made to Patricia Bird. The script bringing washed money.
To the killer. Signed by Donna Adelson. Catherine McBanoa
Those damn
admits
dollars.
she was in a plot to kill Dan Markel. And she got 44 checks and they were all signed by this woman. Next, that license plate number. She had the car, make, model, and license plate in her 2014 planner. Her statements to Bird, she admitted she did what she was accused of. The script written by this defendant in this defendant's handwriting
script.
for Drina Bernhardt to come in here and deliver to y'all about stuff that wasn't true.
That script.
She also speaks in code. Innocent people do not speak in code, ladies and gentlemen. And consider the things she didn't do. She didn't want to talk on the phone. She didn't want to talk in the apartment. She did
didn't want to go to the
not
police.
want to send a picture of the bump flyer to Charlie. She didn't say the name of Dan.
They put up the conversations between Donna and Charlie on a slide showing Board of Dentistry, Yelp review, false lead, phishing, one of two scenarios, patient, TV, paperwork, CD, birthday present, relationship advice. I quibble with this insofar as I think Charlie at the beginning thought it was a Yelp review in the Board of Dentistry and the FBI and the rest of it. And Donna kept trying to say, yes, the worst Yelp review, like Charlie pick up on it. And she kept running with the different examples he was throwing out until he picked up on it. But let's continue.
Markel. Anywhere on that wire, she did not say his name. Dan, Danny, Gibbers, that asshole, nothing.
Major fucker, none of it.
Why not? And she didn't go to the police. Nice, normal, Jewish grandmother approached on the street about a murder and an extortion attempt. She didn't go to the police? Why not?
Don't talk on the phone.
After
Don't talk in the
Charlie's found
apartment or
guilty, the
anywhere.
defendant sends
Don't
this
go to the
text
police.
to Wendy Adelson.
That's what it was saying on screen.
Your brother protected you for years. Now you are not guilty. Your lawyer took very good care of you. You can bury me in the dress that I bought for Lincoln's bar mitzvah. Does not sound at that moment as if she's totally committed to attending the bar mitzvah. You heard that open line call where she's making plans to either flee or kill herself. She is distraught over the verdict. And she's distraught over the knowledge that she's next.
And she is.
The defense has tried to sell you that her emergency fast-track visa and one-way ticket to a non-extradition country was a vacation.
A vacay, let's all go. Woo! Little self-care.
On November 7th of 2023, this defendant Googled a list of U.S. extradition treaties. She was looking for a non-extradition country, and she booked a ticket to one with a stop in another non-extradition country. She applies for a fast-track emergency visa for Vietnam. I wanted it the fastest I can get it. She indicates a 30-day visa is not sufficient. She requests for the longest visa, which is 90 days, which is past the bar mitzvah date. She tries to get Wendy to help with business assistance. And when Wendy doesn't respond, she ends up asking her friend, Annie Cunningham, who y'all met in court.
Oh, we
She
did
says, I can't
meet
say
Ann.
exactly why, but we need you guys to come here, both of you. Wendy's not responding to us, and we have an issue that we cannot discuss over the phone. Why can't you discuss it over the phone? You're just going on vacation. Annie responds,
That's
basically,
weird.
just say the word.
Annie's
When they leave for the
Annie's got
airport,
you.
Harvey leaves this note dated 11/12/23 for Wendy regarding what is needed to sell some property, a gun. Donna makes notes in her planner to have Wendy have the lawyer tell Charlie where they are on the lawyer's private line, so the call will not be recorded. Why not? Y'all are going on vacation. You're coming back.
She's showing the planner page on the screen with the highlights that she showed during trial. Why does Wendy need to tell Dan about Vietnam? He must tell Charlie on his private line.
You're not fleeing? There's also a note in her planner to cancel disability insurance. That doesn't seem like something one does when they're going on vacation. There's a note, tell Wendy due October expenses, child support through mid-November 2025. They're presumably for Charlie's son planning to pay child support 2 years in advance.
Well, there were
This
also
is more
plans
than
for
23.
French bakery. Can we talk about that?
All right, November 13th, 2023, the defendant is arrested trying to board a one-way flight to a non-extradition country. I mean,
We almost got out in time.
y'all decide if it's a vacation. This is a conspiracy. I mean, this took a lot of thought and effort. It's not a typical murder case. The defendant and her son set this up in a way that was designed to protect them.
To keep
the main
her
benefit of the structure
out of
of
the
this
loop.
conspiracy is that each party can insulate or distance themselves from each other. The primary risk of a conspiracy is that you're doing it with other people, right? You can get caught. Somebody can squeal. Somebody could give you up. And that's why the conspiracy is not shaped like this. Rather, you know, they're not all huddled up together. They're
No,
going
it's
to be
train
more like
cars.
train cars. This is the way we see the communication flow throughout the course of the conspiracy. The best way to insulate yourself from your co-conspirators is to organize the conspiracy like a train car, with each car only communicating with the one in front and the one behind. That way, if someone gets caught or cooperates with law enforcement, they won't have enough information on you to give you up. And it's also very important to position yourself within the conspiracy such that those that have the most information on you are those most loyal to you. And that is exactly what Donna Adelson did. To be guilty of conspiracy, it's not necessary for the defendant to say any particular word or do any particular act. But in this case, she did do that.
She paid.
We have all those words and acts that we went over that directly tie her. They are direct evidence tying her to this conspiracy, plus all the powdered sugar dust. Don't let the way she thought she was going to get away with this be the way she gets away with it. Render a verdict that does justice. Find her guilty. Thank you.
Members of the jury, at this time, we are going to take our lunch break. The bailiff will take you into the jury room. Lunch will be provided for you. Once again, I'm going to remind you, do not discuss this case with each other until we have come to its conclusion. You may discuss any other matters, but do not discuss the case. Do not seek out any outside information.
And
The bailiff will
lunch.
take you to the jury room. The lunch will be delivered shortly.
I wouldn't be surprised if counsel went overtime. I suspect they'll talk about it. We'll see. All of you are saying, I want donuts. Look, man, she's calling back to jury selection with the, I talked to you about this example. Here's how this example plays out. Let's see what the court has to say before the lawyers break for lunch. Then we'll answer some questions. I'll take a break to grab some food. Maybe Uber eat some donuts, and then we'll go from there. Not powdered donuts, because they'll end up all over me while I'm trying to talk.
Everyone can be seated. If the defense can go ahead and move forward with setting up the room in the manner in which you'll need to do. We will come back at 1:45. The defense will give its closing. The state will give any rebuttal that it has. 7 minutes and 6 seconds. Ms. Kappelman. You may request.
Ms. Kappelman said a flexible 7 minutes. A flexible 7 minutes. I imagine the court is going to say you may request more time. Let's listen.
Ms. Kappelman. You may request additional time if needed. Mr. Zellman.
With respect to us setting up, we're going to need the exhibits. The exhibits are obviously not going to stay in here during a lunch break. So once the clerk gets back from her lunch break, and we'll obviously come back a little bit early, but
Please
do our best.
return then by 1:20 so that way you can get set up.
Thank you, Your Honor.
Judge, do you want the demonstratives that were admitted, not admitted, but that were shown as demonstratives to be admitted as court exhibits? Or
Yes.
confused? Okay.
If anything does need to be reviewed, anything that was presented to the jury, even as a demonstrative, I'm sure will be.
We don't get a lot of views of this courtroom, but the jury is out. So we've got a little bit of a view from the back of the courtroom. You see where the jury is. So you can see where the prosecution was standing to look and talk to the jury. You can see kind of where the defense table is. It's a good look at the layout of this courtroom and the relative kind of size and space of that courtroom. So let's continue on.
Of use to the appellate court.
Yes, sir.
All demonstratives for the state or the defense that were used during the trial, these will be court exhibits.
Yes, sir.
Again, if anybody asks, Emily, do you like going and being in court in person? I will remind you what I say every single time. This is the view you get. When you are there in person, you get the back of everybody's heads. I really like being able to see the camera view of the front of everybody and chat with y'all.
We're in recess.
Also, my
Defense
face is loud.
To return at 1:20 to set up. For everyone else, please return by 1:30.
All right, and the audience is leaving the courtroom. The court is on recess. A more full day in the audience than it was yesterday as we are getting to the lunch recess. I'm going to take some questions. I'm going to take a break to use the restroom and grab some food. I suggest you all do the same. For those of you that are like, okay, I've got like a million things to get done, I will remind you that's why we built the Lawnerd app. The Lawnerd app is ready. The Lawnerd app is free. The Lawnerd app is on iOS and Android. I will send you notifications when the defense starts their closing argument. And then, of course, if we end up on jury watch, which I suspect we will be on today, possibly also tomorrow, we'll take a poll about how long the jury might be out when we get to the end of closing today. But I will let you know when we are going live. We have been assured that after breaking the Lawnerd app multiple times during multiple different trials, that it is very ready for verdict watch. Very ready. It's very ready for verdict watch. So when we get to verdict watch, and if we hear that there is a verdict and I am going to go live, I will let you know in the app. First, YouTube's algorithm on how they notify you, even if you hit the bell, is deeply complex. So for those of you that are like, YouTube didn't tell me, it happens. I know. It does. So Lawnerd app, I've got you. We keep breaking it and rebuilding it stronger. It's interesting doing what I do with all of the amazing law nerds here is that every time something happens, people are like, huh, we didn't expect that. And I'm like, I keep telling y'all, the law nerds are a dedicated bunch. Huh, we didn't expect that amount of traffic. Huh, we didn't expect it to go that. Huh. I'm like, yeah, we're invested. Not as invested as it seems Donna Adelson was in her kids' lives, though, because that, to me, seems like an unhealthy level of investment. So let's talk about closings real quick. We saw the prosecution touch on the things we thought they were going to talk about. I was not expecting the Spider-Mans pointing at each other meme. I was not prepared for that at all. I'm here for it. I was not prepared. We saw the prosecutor talk about what Charlie's defense was because it's an adoptive admission to Donna Adelson through her text, the truth is out, and because it lines up with the script. And even if the jury is like, jailhouse informants are just going to say whatever to benefit them, how do you explain the script? How do you explain what Donna wrote? And how do you explain that she's saying extort underline after she was Googling blackmail versus extortion? And how do you explain then that Donna was telling those in custody that she needed them to come in and testify for her? The prosecution says that was Donna trying to buy some favorable testimony. Did Donna bring in people to give her favorable testimony? Did we see that play out in this trial? And is that to be expected? Some of Donna's friends were really clear-cut, really straightforward. Some of Donna's friends were like, our Donna would never. And I mean, that's what one would expect from friends. It's not so much that her friend came in and was like, Donna would never. It's that it lends to that Donna would do the exact same thing with those she befriended in custody, doesn't it? And that's what the prosecution pointed out. A really good point that the prosecution made that I hadn't really thought about much, because this trial, by the time we got to the end of it, I was like, Allah! Is the difference of behavior between the bump operation. And for some of you just checking into this trial, because closing arguments are the best, the bump operation was an undercover operation to, as they say, tickle the wires and try to see what would shake out. Like, what happens if we go and bump into Donna and like, hey, we know about the thing that the guys did up north. We know you're taking care of Katie, paying her. We need you to take care of our family. You need to take care of us. What do? How do they behave after that? And I think that, especially as to Charlie, they acted predictably. And then how did they act when they say that Catherine McBanawa was extorting them? Are those two behaviors the same? And I think the prosecution did a good job of highlighting the difference between the bump and between the 2 years running up to it. Because Charlie said, oh, they just went and committed a murder, and then they came to us and were like, give us money. Like, or what? Or you're going to go to the police and say we had involvement in something we didn't have involvement in? No, we weren't involved, and now we know you were involved. We're going to go to the police and tell them that you're involved because you're trying to extort us for being involved, and we're not involved. That's not what happened. The mildy, damp dollars, musty money was given to Katie. And Charlie told Katie, my mom washed it. Literally with water. Not laundered it, washed it literally with water. So, what is the jury going to believe? I was surprised the prosecution did not spend more time focusing on first-degree murder. The prosecution just said this is a first-degree murder, but didn't spend a lot of time focusing on the principal instruction and reminded the jurors that they talked about it during jury selection. So we'll have to see. I think the defense is going to focus a lot on that first-degree murder and the instruction to the first-degree murder and try to pull the first-degree murder out of this and say, look, if you can't get to there, you can't get to here, even with all these conversations. I think the conspiracy charge is going to be real hard for the defense. And I think they're going to go after the first-degree murder and try to raise doubt there as much as they can. All right. Let's get to some of your questions. You've got questions. I got questions. We got questions. Let's get to some questions. Remember, while we take the lunch break, because court is still out, while we take the lunch break, make sure you have the Lawnerd app, because we're going to get on to Verdict Watch. It is a live court kind of a day. So make sure you grab the Lawnerd app. Let's get to some of your questions because we're ready to go. Let's see. Meet Me at the Sidebar said, no spoilers if there's a verdict already. Will somebody tell Meet Me at the Sidebar that they're at lunch and that the defense hasn't done their closing yet, just to reassure them? Those I don't think are spoilers. That's just informative. No. It's not going to go that fast. And if you're the jurors, chat, let me know. If you're the jurors, remember, the jury has not been able to talk about this case. They have not been able to chat with each other. They haven't been able to pulse check with each other. They haven't been able to be like, can you believe the amount that these people talk about World War II? I mean, who the fuck is doing that? They haven't gotten to talk about those experts. They didn't get to talk about George's cross yesterday, where George is like, ma'am, for real though, they didn't get to talk about any of it. So expect that the jury is going to want some time to talk with each other. And if you're like me, probably look at some of those emails. Are you going to want to sit down and look at some of those emails and just be like, what else is in there? The jury's going to need some time to talk, because they've been going to court, talking about the weather, their jobs, the food they're having for lunch, but not about this case. It is their time to get together and talk, and jurors want to talk to each other. They generally get to know each other and enjoy one another's company, and they haven't gotten to chat about the case. And I'm sure there's going to be some questions. Not everyone is just readily super comfortable with the idea that if you're not pulling the trigger, you can be convicted for first-degree murder. That is not something that we often think about outside of the context of like TV. Conspiracy cases and solicitation of murder cases are not the most common type of criminal trials we see. So it's to be expected that the jury is going to want to talk. So let's see what time we get to at the end of the day when the jury goes out to see what we think. Because also, what has the jury heard a ton in this case? That person's doing life. This person's doing life. That person got life. The jury is not supposed to consider sympathy or punishment, but it's already in their mind. You know that it is. And there is a weight when you are the one sitting in the chair going, am I going to make this verdict? They're not supposed to consider sentence. Now, there might be some jurors who are like, I am fucking done with this. Go do your life. But it's not uncommon to think that there might be some who have a bit of pause of sitting in judgment of their fellow human in that way and might need a night to think about it. They might not, they might be done. But it wouldn't be unusual if they also just need a night to take a breath. I guess we'll find out. Because if they're done, like Alec Murdaugh's jury was fucking done. And after Murdaugh testified, I understand why. They got to see him in action. I think it helps Donna that she didn't testify. I think Donna's testimony, just from what I've seen of her in court hearings and listened to in the calls and seen in the emails, if Donna testifies, I think Donna looks a lot less likable. Now she's still a little bit of an abstract. So we'll see how it goes, and we'll see what time we get to when the closings are done. I think the court's going to give some extra time to the prosecution. The court has given the defense, well, almost all the time they asked for. I think the prosecution will have some more time for rebuttal. Potato said, quick question. Why is no one on trial for extortion? Just alleged murder in one degree of 15 degrees or another? Because extortion didn't happen in this case. The bump operation was the FBI. So the FBI is not getting charged for fake extortion. And there wasn't extortion. There was solicitation based on the evidence. There's no evidence that Charlie and Donna were being extorted. So that's where we're at. A lot of you, Donna dollar bills, damp dollar Donna. Like, the laundering the money. Also, Donna's behavior to me, especially through the testimony of Rob Adelson, is so out of line with just my own experiences. And that's different for the jury. The jury does not have the life experiences that I have. I don't have the life experiences they have. That's why we have, juries from the area, from all ages and backgrounds and life experience and work experience and everything. I think it's absolutely one of the shining points of our system. But it speaks very loudly to me that after the arrest, no one seemed to care. In other cases we have watched, in other cases we have seen in the media where there is an extended amount of time before an arrest, even if it's just a couple of days or a couple of weeks, victim families are generally beside themselves. We heard this in the Koberger prosecution, that law enforcement, Sergeant Payne, was calling the victim's parents every single day to give them an update, to try to stay connected with them and tell them what was going on. When the arrest does not happen at the time of the crime, families are beside themselves. It is almost all they can talk about. It is almost all they can think about. It is pervasive. It is non-stop. And it's in your own life, you can think of waiting for a large decision or waiting for, results of a massive test, results of a court proceeding. You can think of examples where you have waited and it has taken over all of your brain space. This is a million X that. And no one seemed to care. Rob cared. Rob's coworkers cared. Rob's coworkers were like, oh my God, did you see? 2 years later, there's an arrest. Rob's coworkers cared. Nobody else did. And it doesn't matter that it's a divorce. If you think somebody's targeting the parent of your kids, the parent of your grandkids, you're not worried? Well, the prosecution pointed out because you know something. I saw a great question in the chat asking, Sam asked, how long is the fastest guilty verdict you've seen, Emily? Again, I can only speak from my experience. We had a verdict in a case that I tried that the jury hadn't even gotten the evidence back yet. I was still in the courtroom packing up my stuff and they buzzed. It was less than 10 minutes, but it was also a 2-day, 3-day trial. And it was a Friday and it was Friday of the Long Beach Grand Prix. So the jury was like, nah, we're done. This is a longer case. The jury instructions have more to talk about. This is a conspiracy case. And a first-degree murder with a principal. There's a lot of things they might need to talk about. So, let's see. Can you explain a cat's got hearing and how it relates to Wendy? The disgruntled moderate, I'm going to hold on to this because today is Donna's day. We will have other days to talk about Wendy. Do not worry. Giselle said, EDB, appreciate your breakdowns. This case is a circus of bizarre behavior. It isn't, it isn't. I think after the bump, they acted how law enforcement hoped they would, right? I think, and this is purely my speculation, I think that the FBI probably profiled Charlie based on everything they could find about him and planned the bump operation to poke at Charlie being the weakest link. And oh boy, was it successful. FBI profilers are very good at their job. And they were just like, book, book, book. And Charlie, you saw it in those initial calls. Mommy, mama, mama, mother, mother, mama, mom, mom, mom. Was it the IRS? Are we being sued? Who was it? What was it? Tell me what happened. What's in the thing? I don't want to talk about it. I don't want to send it to you. It's about the thing with the two of us. But what is it? What is it about? What is it about? Can you tell me what it's about? I need to know. What is it about? Can you send it to me? Send me the thing. I want to see the thing. I'm canceling my day. I'll drive down there. I want to see it. I need to see it. I need to see it now. Mother. Is it about me? Is it the IRS? Am I being sued? Charlie, it's about the thing. With the two of us. We should talk about it in person. But what is it? I need to know. Oh my God, can I ask you one more thing? But what is it? What is it about? Are we being sued? Poke. And Charlie just spiraled right out over all those calls. Just absolute spun like a top. So, Nebula Spiral said, spiraling like, I'm teasing. Nebula Spiral. Can you imagine Georgia versus Alan Jackson? Yes, I can. And I think both of them would have a strategy to deal with the other one because attorneys adopt to their case and their opponent. So I think you would see them adopting. But Georgia's closing was heavy on the be so for real right now. Like the whole tone of the prosecution's closing was be so for real with me. Are you kidding? That's not what this is. It was a little bit of a level of disdain. In a homicide case, I'm not mad at the prosecution expressing disdain for the behavior, for the life that was taken. Arguments where the prosecution gets to argue. They have to know their jury, and they have to know it's not too much for the jury. Or they can lose jurors who are just like, I mean, that's a little bit too much. It's between the prosecutor and the jury, which is why jury selection is so important. Blue Sky STV said, Emily, how is time limit in closing decided? It varies by every single court. In this court, they asked the attorneys what they thought they needed and said, okay. That was it. Carissa said, how do they decide who goes first in closing arguments? For Karen Reed, I believe the defense went first. Massachusetts is its own little bubble of stuff. In almost every jurisdiction I have seen, because the prosecution bears the burden, the prosecution goes first, then the defense, then the prosecution. In Massachusetts, because the prosecution bears the burden, they do not split their closing. They go at the end, and the defense goes first. I've only seen that in Massachusetts. Now, in civil cases, especially where it is countersuits, it will generally be the first plaintiff to sue would go first, and then the defendant / co-plaintiff, not co-plaintiff, cross-complainant. My brain just would not shift gears to civil there real quick. It was like, we got stuck in a gear. But most of the time, it is the prosecution before they bear the burden. Same with the verdict slip. They talked about that yesterday. The defense attorney said, I'd really love it if you would put not guilty first on the verdict slip, please, which they do in Massachusetts. Can we put not guilty at the top, Your Honor? Just can we make that the first checkbox? The court said the prosecution bears the burden. You get to select guilty or not guilty. Also, most verdict slips, and I have to say most because the ones in Massachusetts, I can see where the confusion was, but it gives you two options, guilty, not guilty. The jury can find the option that they're looking for. They take what they're doing seriously. All right. Does the jury get the PowerPoints to look at during deliberations? They do not get demonstrative exhibits. Those are to aid them and aid their understanding. They do not get them. They only get the evidence. Donna K said, how's long for the jury to come back with a verdict? I'm voting within 24 hours of getting the case. I will put up a poll. I don't poll on guilt versus innocence. That or guilt versus not guilt. That's for the jury to decide. But I will put up a poll of how long we think they'll be out once we get to the end of the day, because that may change. Like, it's different depending on how much time's left in the day, right? If they have an hour left in the day, they're not, they're not going to come back today. But if the court's like, you guys can have dinner, you can go to 8 o'clock if you want to. If you want to get this done today, let's go. We'll see. Amy asked, if they prosecute Wendy, can her defense use previous arguments like the prosecutor's closing, which make Wendy look more sympathetic? They can't necessarily use the prosecutor's closing. Would they get into arguments of like judicial estoppel and stuff? We can talk about that down the road, but can the prosecutor completely go 180 on Wendy? Not necessarily. I think the prosecution has really walked that line of what Wendy knew that's been proven in this case without saying like, oh, Wendy was just a bystander in all of this. They didn't argue that. It would be improper to argue like, Wendy knew nothing. Wendy was just a bystander, and then turn around and prosecute her and be like, just kidding. Of course, unless evidence changed. So there's the conversations as to Wendy, I think, are much more complex. Today is Donna's day. There will be time to talk about Wendy, because I imagine what's on all of your mind is, okay, how long will the jury be out, and what about Wendy? We learned a lot in this trial about Wendy, didn't we? We heard Wendy's name quite a bit. A number of you in the chat, including Dana Huggs, said, it's my birthday today, and all I want for a present is a big fat guilty verdict. Well, birthday presents have kind of been tainted by this trial, haven't they? It's just been like birthday. Marissa Bell said, if second degree is also life, why would they want that too? The prosecution asked for it to give options. The defense was asking for manslaughter, so if they wanted manslaughter, you should put murder 2 in there too. And then they took them all out today. KK said, no malice was towards your mug. No, malicious. Oh, Dr. B definitely felt bad about breaking the mug. I was very confused this morning when all the coffee was running out the bottom of my mug. Dr. B and I will chat about that. Don't worry, I'll find a replacement mug. Lawnards, do not send me mug. I will find him. I will be fine. It's just, There's times when you're just like, meh. I will figure it out. I just had no idea that it was not completely intact because it didn't look like it was not completely intact. I'm really glad the whole bottom of the thing didn't fall out when I made my coffee this morning. So thanks for small favors. I'm going to have to move one of my computer monitors to get the coffee out from underneath my my monitor, but we'll see what we can do to figure it out. It's very cute. Natalie Jean said, my lawn art merch made it to Australia today. So excited for my hoodie. Hoping it's super oversized and tumbler. The drop shoulder ones are oversized. Don't worry, we will bring back the oversized hoodies soon. We have another launch coming up. And to get ready for that, we do have some stuff that's going to be going on sale in the shop to get ready for making a little room for a next launch. We might have some Easter eggs about that. So Jen said, is this all because Donna is trying to run the show? I think Donna is a very involved client. And so we have definitely seen the defense put things on the record to make sure that they are on the record. The defense has to go into a trial with the, how do we protect the record if she's convicted? Also, do you think these defense attorneys are sitting there going, well, if this doesn't go well for Donna, she's not going to turn around and try to sue us? Brandy All Armory said, Emily, you make my day. Today is my 50th birthday. Happy 50th birthday. Lots of birthday folks in the chat today. Thank you. Puddlegum said, Emily is such a great teacher. I was told my entire life I did not have the patience to be a teacher, and yet here we are. I think it's the you get to choose to be here that works well. You all get to opt in, right? I felt bad for jurors, that jurors didn't really get to opt in. Some of them just hadn't opted out well enough. And so I really tried to make sure that they knew we were working and moving along, and we knew they were disrupting their lives and how important it was. But that was always my goal in court, was to explain what happened in a way that the jury can understand and say, I think the evidence shows all of this. Do you agree? Crime, facts, verdict. What do you think? But it's the same when I worked with clients. I try to explain the law things realistically, even if it's not what people want to hear, even if it's not what people feel is right. We talk about legality versus morality quite a lot on this channel. We see cases where we talk about it quite a lot. And it's hard in the law to explain what is, even when people don't like the answer to what is. Sometimes that's legally what is right now, and it doesn't help anyone telling them what they rather hear when that's not what is. So it's just being able to do that in a way that doesn't make people feel attacked or defensive, right? Necro said, I feel like EDB, this is incredibly kind. Thank you. I feel like EDB is the Miss Frizzle of the law nerds, and we're all on the Magic School Bus. I mean, we're all on the Magic Air EDB with first class for everybody and unlimited snackies and drinks of choice. Like whatever the drink of choice is. Like, it's fantastic. The imaginary EDB Air is the best. The Lauren, thank you for your memberships. Chuckles Quad said 3 years of trials, and this was one of the clearest, easiest to follow prosecutions we've seen in a while. Yes. The prosecutors have the unusual benefit of having done these trials since the arrest in 2016. I mean, this prosecution team has had a lot of time with this case, so they knew what they needed and what they didn't need. I think what we saw in the first Karen Reed trial was Lally didn't pick. There was no discernment. Discernment is a huge part of being an attorney, but Lally did not discern. He was like, here's all. After we saw Karen Reed too, you can decide if his method worked ultimately better or not or whatever, but no discernment, just all. Here you go. Here's all of the information. You decide. This trial was discerned and streamlined. However, the prosecution had so much leading. And I think part of the reason the defense was like, is because it went to things not specific to Donna. The defense chose when they were going to object on things, and it was when it went for Donna. The stuff that went to the murder, the defense is like, we all agree a murder happened. We don't agree that Donna was involved in any way. Donna didn't know. Don't tell Donna. But they didn't fight on those things. And the prosecution just leading question after leading question after leading question, which also makes it more streamlined. Because they're just like, boop, boop, boop. And the prosecution was just like, fine. It's fine. Who just said discernment is a big part of being a Virgo? I mean, Astro, Stephanie, you know that I'm a Virgo rising. We've talked. Yep. So, let's see. Carrie and the Cat said, I didn't get selected for a jury because I was so uncomfortable with the mandatory minimum sentence for something I thought should be illegal at all, and I thought shouldn't be illegal at all. That's fair. It's fair to be like, no, I don't think somebody should be prosecuted for this. Fair. Bree said, Charlie really said, to which of my many crimes are you referring here, Mom? Charlie was real worried about the IRS, wasn't he? Wonder why. This Nights Who Say Knee, this is a fantastic idea. My hubs broke one of my favorite mugs in a similar leaky way, not shattered way, turned it into my sunglass holder. Have it be your pen holder. I might go put it in my closet. We'll make it work. I love all of you are now talking about all of your astrological signs. Look, the law nerds run the gamut on all of the conversations, but yes, discernment matters to me quite a lot. I don't realize there's times when I'm like, look, for me, it's one of the key traits for a jury to get to the point. And then make sure that you're understood. And that you gotta look at the jury to do that. Law nerds, they are gonna be back from lunch very soon. I am going to take 10 minutes to go to the restroom. All of you are asking, are we on verdict watch? No. Lunch break, followed by defense closing. Miguelina, if you don't mind, will you just put up a note saying that the court's on lunch break, the defense closing arguments will follow lunch. I am going to ping you all in the app when the defense starts their closing. They should be back in about 10 minutes. I don't know if they're actually going to be back in about 10 minutes. I'm going to run to the restroom, hydrate, grab some snacks. The defense gets 2 hours to make their closing. I don't know if they're going to use the whole 2 hours, but we will see. And we'll see what they say. I imagine it's going to go a lot of Donna didn't know. Scotty didn't know. Scotty didn't know. Scotty didn't know. Don't tell Scotty. That's what we're going to see from the defense closing, I suspect. And if I was them, I would look at those instructions on first-degree murder and be like, you don't have this. You don't have that. You have a first-degree murder, but not as to Donna. This is horrible. Donna didn't know. Donna didn't do it. Donna trusted Charlie. Charlie's already been convicted. The people responsible have already been taken care of. You know, not Donna. We'll see how that goes. All right, law nerds, get some lunch. Remember, when I come back, A, I'll put a message in the chat. B, you'll hear this if you have your sound on. Defense closing arguments are up next. Get the law nerd up, get some food. I will see you in a bit. 10-ish minutes, maybe 15. See you soon. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. All right, Law Nerds. I hit the wrong button. We got to hit the button. Are we ready to go back to court? Court took lunch. Remember, the defense will be starting closing. So we are going to get back. I grabbed snacks very quickly, got some fizzy water. We're ready to go. Did we grab enough snacks? Probably not, but we'll see. We got 2 hours of closing. It's going to be fine. Did I have time to pop popcorn? No, we had to do other things. It's all good. I'm ready to go to court. You're ready to go to court.
Bring the jury.
I'm ready to see the rest of these closings and the final instructions and send this jury out to deliberate. So let's get us to court, shall we? All right.
It's also the other ones that we...
Before the jury comes back in, it seems we are talking to the judge, so let's see what they have to say.
The ones that are in evidence.
It's not just the ones that are in evidence, Your Honors. It's also the other ones that we had requested to be put in evidence and submitted as court exhibits.
Well, these are items that are not in evidence. I believe the state's demonstrative specifically dealt with items that were in evidence as a part of its closing presentation.
I don't dispute that, Your Honor.
For anything that is not admitted at this time, it cannot be presented to the jury at this point as evidence for consideration or argument for consideration.
Are they arguing about the
pages of
demonstratives?
The two calendars that are in evidence, you certainly can.
And we are back to arguing about Donna Adelson's diary. This is about the pages that were not admitted into evidence. Remember, the court ruled on this morning. It came up yesterday. The defense wanted to admit Donna's planner into evidence as to 2014. Only the one page with her ex-son-in-law's make and model of his vehicle is in evidence. As to the 2023 planner, I think it was like 2 pages that were in evidence. And then there was a sampling of it that was a marked demonstrative that was used for the handwriting analysis, but was not admitted into evidence. The court had denied this. It sounds like the defense is trying to use pages of that planner in closing.
You can use the physical book.
So the court is telling them what they can use in their closing with regard to the planner pages. I'm going to back up to hear what the court is saying, but the defense is going to try. Again, I appreciate that the defense is seeking clarification from the judge rather than just doing it in closing. That is the better plan. Ask the judge, make sure you're clear on the ruling, make sure you know what can come in, rather than just going for it in closing and being like, ask forgiveness, not permission, right?
Or anything that is not admitted at this time, it cannot be presented
The jury's
to the
not
jury
in
at
yet.
this point as evidence for consideration or argument for consideration. The pages of the 2 calendars that are in evidence, you certainly can use. You can use the physical books themselves as demonstratives if you want to show the jury. Beyond that, getting into pages that have not been admitted and are not a part of evidence.
Yeah, that's a no-go.
What would be the proper basis of doing those?
Yeah, that's a no-go.
Again, Your Honor, the way in which it's been presented is misleading.
You argued this
Client
already.
has, even if it's not a specific basis for admission of the rules of evidence.
I will say the state was very careful in closing to talk about Harvey's note about what was being sold. They did not mention Donna's notes in the planner about selling things. They did mention Donna canceling her insurance that was in the planner. That came up.
The Constitution allows my client to present evidence in support of her defense, and just based on
the defense has said My client is allowed to present evidence. Counsel. Closing arguments are not evidence. You cannot bring in something that is not in evidence. You can bring an argument, you can bring in demonstratives, but you can't bring in something that's not in evidence and say, see, this proves that. And he's arguing about, okay.
Again, Your Honor, the way in which it's been presented is misleading. My client has, even if it's not a specific basis for admission under the rules of evidence, the Constitution allows my client to present evidence in support of her defense, and just based on, as I said, the way that the state has misrepresented items in the calendar, we would like to be able to present that as an argument to the jury.
Again, at this stage, for items
Evidence
that
is
are not
closed.
in evidence, I do not find that these are specifically exculpatory. You can make any reasonable argument or inference as it relates to the admitted evidence, but items that were never admitted at this point are not to be presented to the jury.
Yes, sir.
You can make argument and inference from admitted evidence, but you cannot present new evidence. I just have to wonder if this is a client-led decision. If Donna wanted to talk about her planner, she could have done it. She chose not to. The prosecution did not admit it into evidence. The defense could have brought witnesses in to admit it into evidence if they could lay the foundation. They didn't. The court has made this ruling like 4 times today because the defense has said, but please. And the court has said, but yeah, but no.
You can bring in the jurors.
All right.
Bring the jury.
I expect the defense will start their closing argument after the jury comes in. I'm going to zoom to get the jury in. Magdalena will let the app know that he's going to start, or somebody's going to start closing. The jury's coming in, counsel. What do you need?
Your Honor, since we don't have a beautiful presentation as a state while Ms. Fulford is giving the closing, I will be assisting by putting the items on display.
That's fine.
Ms. Fulford's giving closing. What are they doing? The attorneys are still talking. The attorneys are still talking, so I'm not going to zoom because I want to see if they put anything else on the record. I know the poll had him doing the closing. I thought he would too. I was with the majority of y'all. I really thought they would split up the closing, but defense attorney Fulford's doing the closing. The prosecution really pushed on the defense's opening and closing, didn't she? The defense said this in opening. The defense said that in opening. The defense told you how great the victim was, and then they brought in evidence yesterday to do the opposite of that. The court has nothing to type and is just stacking papers. What are we? Are we standing waiting for the jury, or are we? Ah, there they are. I mean, it's not hear ye, which I think is one of my favorite things in any of the trials ever. It's not hear ye, but the scepter of jury in is very, it's very stately, I think.
Everyone can be seated. Members of the jury, I hope you enjoyed your lunch break. At this time, we are going to continue with...
One of the jurors said, yes, sir. And I think when the jury came in today, they have been giving the judge robust greetings in the morning. And I think it's because at the beginning of jury selection, this judge said, good morning. And they all went, good morning. And he's like, ladies and gentlemen, I said, good morning. And then they all go, good morning, Your Honor. I imagine through this trial, the jury has become more fond of this judge, as have I. So I'm not surprised that this morning they were like, good morning, Your Honor. Also, they're nearing the end, so it's lovely.
Defense is closing.
It is time for the defense
You may
closing.
proceed.
And away we go.
Good afternoon. It's been a long day. You've heard a lot, but I hope you'll stay awake so you can hear me too, okay? So, it's been what, 2.5?
Counsel, they're adults. They're not going to sleep through your closing. They're going to give your client a fair opportunity. Just don't start with, I hope y'all don't just fall asleep on us now. Ew!
Half weeks, I guess, since you started this venture with us, and you've heard an awful lot. And I'd like to take you back to my opening statement. In my opening statement, there were some things referred to today that I'd like to address. The first one is that I stood up in my opening statement and said all of these wonderful things about Dan Markel.
She did.
And then I called witnesses to attack him. That is not true. That is not true. In fact, the defense is the only part of this case that actually elicited evidence through testimony about the good qualities of Dan Markel.
I would object to that.
We elicited that on cross from his ex-wife, Wendy. And all of the things I told you in opening about what a wonderful man he was, a wonderful father, well-educated, successful, we elicited that testimony. And criticized today for having two witnesses who came and testified on the stand about the dissolution case and things that had been filed in it. That was not to attack Danny Markel. We didn't put that evidence on. The state is the one that made it an issue. They put those documents into evidence, the things that Mr. Markel had filed. So we're the defense, and we represent Donna, Adelson, and we're just supposed to say, okay, well, they've put it in, let's just let it sit there. We have an obligation to represent our client, and what happened in that divorce, whether it was contentious or not, was an issue the state brought up. They've been calling this a bitter custody battle for years. And they started this case by saying the same thing. So
That's a fair
to have the
point.
people who were actually involved in the case point out that there never was a bitter custody battle is important, because there never was one. There was never a time when they were fighting over somebody having access to the children. In those pleadings, nobody says, you can't have them, I've got them. You can't have them, I've got them. When they filed their initial pleadings, they did what everybody, according to the lawyer who was on the case for Mrs. Adelson, meaning Wendy, on the case for Wendy, they all filed their typical pleadings. And in the beginning, you ask for certain stuff, and she asked for 5149, maybe for a tax purpose. But there was never one single time, and you can't be convinced that relocation was the issue where they were going to take Danny Markel's kids away from them. If you believe that, you are ignoring the evidence that the state of Florida put on against Donna Adelson.
Ma'am, did they take Dan's
And when I
kids away
told
from
you
him?
in opening that this was all about theory and belief of what a motive was, and there was no evidence that a crime was committed by my client, Donna Adelson, that is exactly what has happened in this courtroom. The state is ignoring the evidence that came in through their witnesses that support our defense, and instead they stand before you with calls and text messages, and they tell you what they mean. That's not evidence. Their argument about what a conversation means is not evidence.
That's true.
You decide what it means. You've got it in front of you, and you have to consider it in the context of all of the evidence that's presented. Not just what the state puts in, but what the defense puts in. And I know at some point when we were putting on evidence, you all were looking probably at me like, what are you doing? Who cares? Some of those little things matter, and I'm going to cover those in the defense, and you'll see why we...
Hey, counsel, where was this level of self-awareness yesterday? Also, why are you yelling at the jury and banging at the podium of them? Why are you yelling at them? If you were on the jury, would you feel yelled at? Also, this self-awareness would have gone a long way to cut off the last or the second to last witness yesterday.
Put those things in that didn't seem like that I had a hoot to do with anything, because they actually did. Now, I think the state, near the beginning of the case, and I don't recall who the witness was, but near the beginning of the case, the state, through a law enforcement officer, elicited testimony about how this event transpired, this brutal killing of Danny Markel, how it transpired, and how they were able to break the case. And what did they tell you? They told you they broke the case because Luis Rivera, who was one of the killers, decided he would cooperate with the state of Florida in exchange for a deal.
That's not
which
what they
for
said.
his crime, he ended up, the testimony was, he got 7 more years for committing that crime. This is the man who got in the car, got the gun off the street, drove up to Tallahassee, Florida, stalked, is the best way I can describe it, Danny Markel in a car with his children from his home, watched him take his little boys out of his car and put them into the daycare center, followed him again to where he went to work out at Premier Gym, and sat in wait for him.
Yeah, that's why it's a capital.
Sat in wait for him.
Capital crime.
And then when Mr. Markel came out, trying to work some things out with his ex-wife, Wendy, about having the kids and who's picking them up at what time, even leaves her a really nice voicemail that they could get together and walk at the school to talk about the education of their older child, where he was going to be going to school because he was going to be starting kindergarten.
Charlie
and Wendy pushed back. You know, she pushed back.
Charlie.
This was his time with his little boys, and she's telling him no. You know, I've got plans. Well, it wasn't her time to do that. So leading up to his death, she's arguing with him over about an hour and a half worth of time that she thinks she's entitled to with the kids, but it's his time. And I agree with the state of Florida. The most
There's a lot of banging the podium. Is the defense going to be fuck Wendy? It's not Donna's fault. Like Donna doesn't know, but fuck Wendy. Is that where we're going with the? I mean, the jury might agree, but it's not Wendy's day. Her fist is ready to literally bang the podium. We'll talk about what law professors say about banging the podium another time. But it seems that her plan is to just bang the podium. Is the closing going to be fuck Wendy? I'm curious.
important thing to that man was
the most important thing to the victim was his kids. Yeah, I'm glad she agrees with the state on that.
So leading up to his death, she's
mad at me.
arguing
Sorry,
with him
Google.
over about an hour and a half worth of time that she thinks she's entitled to with the kids, but it's his time. And I agree with the state of Florida. The most important thing to that man was those little boys. And he fought for every minute he could get, and rightfully so. Then he drives home in his car while he's on the phone, and Luis Rivera, driving the car that's been stalking him all day, pulls up behind him in his driveway. Sigfredo Garcia gets out and shoots him twice in the head, and they pull off at a pretty high rate of speed and leave Danny Markel dying inside his garage. Left him to die.
I mean, yeah.
Those are the people that killed Danny Markel.
Right.
Those two people. And
Donna
the state
didn't
has
know.
all kinds of arguments about how Mrs. Adelson's involved because she said these things about him, and we'll get to that in a second. But if Luis Rivera is telling the truth, what did he tell you when he got on the stand? What did he tell you? He said, and this is his signature on this document dated March 11th, 2025, when he was deposed, and those numbers and circles are his. And he testified to you that, where's my numbers?
Wendy
That Catherine
wanted it.
Magbanawa, that's right. Catherine Magbanawa is the person that elicited Sigfredo Garcia to kill Danny Markel. Now, her versions change over time, so we'll have to address a few of those. And then she says she didn't even know Luis Rivera was involved. This is a woman who the state has admitted lied first time, second time, third time, fourth time, maybe the fifth time. Every time she puts herself under oath and swears to tell the truth, she's going to say more. She told you she didn't even know Luis Rivera was involved, but the phone records that were put in by the state of Florida prove otherwise. Because during the time that they're traveling to Tallahassee, when she can't reach Sigfredo Garcia, whose phone is she calling? She's calling Luis Rivera. This woman can't tell the truth. But in any event, Luis Rivera then puts this number 2 next to Sigfredo Garcia because he's the one who actually killed Danny Markel. Number 3 next to himself because he's the one who got the gun and drove the car to kill Danny Markel and then away from the scene. This is the man that he says they killed. Who else on this document do you recognize?
Ma'am, I'm
On
too
this
distracted
exhibit?
by the
Who else?
recording
Who else was
sign.
involved in this? Well,
Can you just
all
get
the
a
players
pointer?
that the state claims are involved are pictured on this document, and he says, Wendy Adelson, she's the lady who wanted to get her kids back. This is why we were committing the crime. Wendy Adelson. And Doctor, the dentist, he called him, which is Charlie Adelson, who he identified, was the one with Katie. This one and this one are the reasons that they're coming to Tallahassee to kill Dan Markel. And I said, well, what about Donna Adelson or Harvey Adelson? No, they weren't involved. I said, would you put an X next to them if they weren't involved? And he did. Donna Adelson's name never came up, but Luis Rivera is telling the truth according to the state. That's who you're supposed to believe, and he says my client is not involved. There's some issues that I might address further, but I want to go through some of the things that the state stood up and told you.
Are we doing this on the fly?
Relocation, relocation, relocation. That's the issue. That is the reason that my client had Danny Markel killed, because relocation was lost. Danny Markel was killed July the 18th of 2014. Relocation was done for over a year. That's the motive? It's been over for a year, and they said yesterday in court that the relocation issue didn't stop when Danny Markel was, when the divorce was over. It continued going on. The emails showed that. There is not a single email that's been put in by the state that shows that my client, Donna Adelson.
A number of you have said, and Nightbot doesn't love the all caps because I can't read them because it's really hard for me to read all caps. But a lot of you have said when the facts and the law aren't on your side, bang the table. That's where we're at in this closing. I mean, I am here for defense counsel making a case against Wendy. I mean, I'm real curious. Just keep making a case against Wendy. Like, what else did they say about Wendy? Just keep telling me what else they said about Wendy. Okay.
Was continuing on a rampage about relocation. The last email that they showed you today that my client wrote about relocation was July the 19th of 2013. The divorce was final on the 31st, said and done. They bring Wendy Adelson in here to testify. That's their witness. And she said it was done. Now, have Charlie Adelson and Wendy Adelson been honest with their mother? The evidence says no. They haven't been.
Oh, Donna doesn't
because
know.
the whole time Wendy Adelson is telling her mother, she's telling her mother that relocation is what she wants. She's the one who starts that. She's the one who asks her lawyer about it. The whole time in the spring leading up to this hearing, Wendy Adelson admitted in her testimony she's sending these messages to her life coach and telling her life coach, you know, I think I want to stay in Tallahassee. But she didn't bother to tell her mother that. Her mother still thinks she's trying to get relocation. She does it in April. And then she writes to her again in May. I think I'm going to give up relocation. I can stay in Tallahassee. The kids will be close to their boys. There won't be any plane rides. And I like my job. It
But
gives me
I
all
would
this flexibility.
lose face
I'm going to stay.
with
but she still doesn't tell her mother.
Mother. She said in that email, I would lose
She has
face
her mother
with my
believing
mother.
we got to fight for this relocation. She testified. Well, I said, why did your mother get so upset? Well, she's venting to her mother about what she claims Danny Markel is doing, and she's venting to her mother about what she wants to accomplish, only she's not being honest with her. On the backside, she's making other plans. It'd have been nice for my client, Donna Adelson, to know that, because these emails that have been submitted here, which are proof that she wanted to have Danny Markel killed, would not have been written. And when she goes to her hearing on the relocation in June of 2013.
So if Wendy wasn't telling her mom that relocation was what she wanted, her mom wouldn't have written all these emails to get relocation, because her mom wouldn't have done anything possible to get relocation, because if Wendy was honest with her mother, then her mom wouldn't have said, well, we need to get this done for Wendy. Is that... Because if we follow that train of thought, counsel, I don't think you like where it leads. But let's see.
She has her mother stay outside. Her mother can't hear what's going on in the hearing. She admitted she had several witnesses to call beyond the two that got on the stand. And then after the judge made the comment, she gave up. She could have continued with the hearing and put her witnesses on. The judge could have ruled against her, and then maybe she has an appellate issue. She gave up because she didn't want it anymore, but she didn't tell her mother that. When she told her mother, well, this is how the judges ruled, the mother understood that through the court system it was done, but not with her daughter, Wendy. Because you can continue to negotiate all the way through a final judgment. And that's what those emails say. They do suggest some crazy stuff. They do. But she puts in there, we're trying to negotiate. We're trying to negotiate.
And what happens when negotiations
fails? You can
fails?
still work on this. She doesn't know when she's writing those crazy emails that there's no reason to write them because her daughter agreed. You know, you can have a dismissal on an issue. You can have a denial on an issue. She agreed to it with prejudice, which means it is over. She already made an agreement. She's not going to seek relocation anymore. So my client is hanging out there trying to support her daughter, and now she's sitting in a court of law charged with murder because of what she wrote in emails. Because the truth is, you are here to judge my client based on her conduct leading up to and to the time of death of Danny Markel. That's her conduct. Can you consider things she said and did after to see if it corroborates that she was involved? You can. But her conduct leading up to the day that Danny was murdered is in this book that the state has entered with emails. It's separated between where you can see it, where they lead up to the divorce, and then after the divorce until the time of the homicide. Now, my client did say ugly things about Danny Markel. During the divorce, she did. And the state has put them in. This is State's Exhibit 64. And they have emails.
I mean, counsel's arguing if Wendy had just
going up
said
through July the 11th of 2000.
if Wendy had just said she didn't want relocation, her mother would have stopped fighting. But she's then saying that Donna didn't stop fighting. So, okay. Here's the book of emails.
2014. These are the bad names that my client called Danny Markel. During the course of a divorce where her daughter is constantly venting to her about what she says Danny is doing, she said some really bad names, and I'm going to say them, although you shouldn't say bad words in court. She called him some ugly stuff. The first one that they wanted to put in was from 2011.
Major fucker.
He was killed in 2014. They introduced this email from March the 28th of 2011 at 64A, and inside that email, they claim shows the hatred for Danny Markel. And you want to know why? according to their exhibit list here,
do the dates
because
help?
Mrs. Adelson referred to Danny's parents as, quote, the royal couple. And she and Wendy were bantering back and forth about some issues
I don't even remember
with
that.
Mr. Markel's parents. That's not hatred on Danny. It's not even hatred on his parents. We're sitting here with murder charges because she did something like that, called somebody a royal couple. She said other bad things. She called Danny a major fucker, Gibbers, which Wendy Adelson testified that she came up with that nickname for him.
Silly. It was a silly nickname.
A religious zealot, and Wendy testified that the issues in their marriage included matters of he had now become more strict in their religion than she wanted to follow. That was one of their problems. She called him a royal jackass, a piece of shit, a fucker, crazy, a bastard, and she called him Elvis. That's why we are sitting here today. That is hatred for somebody. That proves they wanted to have him killed. Are you serious? You call somebody some bad names and that means you wanted them dead? My client has lack of any ability to stop herself from saying things. She can't do it. And I'm not trying to be offensive to her, but she can't. And all of these...
What? What? Also, facts, not in evidence, but what? The evidence shows it's Charlie who won't shut the fuck up, to be honest. Donna's trying to get Charlie to shut the fuck up quite a bit. I have to back that up. What? I swear, if she says verbal diarrhea in this closing argument, I might fall over.
Are you serious?
I had to hear it again. What?
You call somebody some bad names and that means you wanted them dead? My client has lack of any ability to stop herself from saying things. She can't do it. And I'm not trying to be offensive to her, but she can't. And all of these emails that they have introduced prove it. She is not a one-word person. She goes on and on and on and on. And they believe that she had Danny Markel murdered because she said some bad words. There's not a lick of evidence in here that they submitted of what she did prior to July the 18th, 2014, where she said not a single word, that she wanted him killed, she was planning to have him killed, she was going to find somebody to kill him, she was going to pay somebody to kill him, she was going to kill him, that she was glad he was dead. That's not in here. And this is it.
You're going to break a nail on that binder, counsel.
This is it. Before he was killed.
Did you gel?
You're judging her conduct before he died, up to his death.
Gotta be hard gel.
And that's all you've got. And I told you that in the opening statement. They have a lot of theories, and they like to spin evidence a certain way to make her look bad because she said ugly things. That is not proof of somebody having somebody killed. And that's it.
She run out of air?
Besides the relocation issue, which has been dead for over a year before he's killed, bad choice of words, I apologize. It had ended over a year before he was killed. Now they want to bring in something called the grandmother motion. This is what had to push her over the edge. Their own witnesses said she didn't know about it.
No, they didn't.
Let's see who testified to that.
Sure, let's. She responded, wow.
Wendy testified, her daughter, that she never showed it to her and she never talked to her about it.
She emailed it to
But then
her.
there were two more witnesses for the state, and they were Craig Isom and Jason Newland. And when they testified on cross, they admitted that there was no evidence that that motion had ever been forwarded to my client. Not a single piece of evidence. What if she had gotten it? Do you want to know what it accuses her of? That a 3- and 4-year-old said that they called Abba, that she had called Abba stupid.
Are we going to get at what she would have said?
And that drove her over the edge? One, she didn't know about it, but two, somebody claiming you said the word stupid, that's what brings us to murder charges? It's unbelievable. But that's their spin that they want to put on it, because they've got this theory that she's the mastermind. And then they stand up here in their closing and they say, everybody who's been charged in this case, so they want to point at the other one, and point at the other one, and point at the other one.
Well, they
No. Who is pointing at these people? The state of Florida. The state of Florida is doing the pointing. They're the ones getting the warrants. They're the ones doing the investigation. They're the ones charging people, deciding who they're going to give
that's
deals to
fair.
and not. That's them pointing the finger. That's not my client. There's no evidence of that. They bring the charges. They prosecute. They get the convictions. They get people sent off to prison. Not us.
I mean, they did do that.
What? We're pointing the blame at the killers for killing them? They proved that those are the people who killed them. That's not us pointing the finger. They actually did it, and it's been proven. And we're distancing ourselves from Charlie Adelson? Let me tell you something.
Tell me.
They elicited the testimony about Charlie Adelson over our objection, if you happen to remember that. It came in. Charlie Adelson is not on trial
Anymore.
You may be sitting in that jury room thinking, well, Charlie did it, and it sure looks like Wendy did it. That doesn't have an ounce to do with Donna Adelson doing a thing. Not a single thing. If you think he did it, he's been convicted. He admitted in his testimony that he is the person, although he claims he was extorted, he is the person that took $138,000 out of his refrigerator-size safe that he has at his house with the money exactly like he says he kept it, stapling $100 bills together in stacks of 1,000, staple, 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 staple.
Damp dollars?
He said he took that money out of his safe and he gave it to Catherine Magbanowa that night. Whether that's his girlfriend and they're still fooling around on the side, that's between the two of them. That's got nothing to do with my client.
I mean, she kept putting herself into the middle all
He
that.
did it. But now they want to say Donna Adelson did it. Pick one. You don't like our theory? That's what they say. You don't like our theory? Oh, well, you like our theory on everybody else. Pick one. If you have prosecuted Charlie Adelson for paying the $138,000 stapled just like their other witnesses in this case said, why are they now saying Donna Adelson provided the money? Oh, wait. Oh, because Catherine Magbanowa, who's been sentenced to life and is telling her sixth story now, has decided she'd like to see her kid someday.
Oh, there's
so
the
now
life.
she's going to come in and provide information that will help the state prosecute an innocent woman so she can go home to her children. That's what that's about. So she claims that this all goes down.
Okay.
Charlie puts the money, Charlie, not Donna, Charlie puts the money stapled just like she knows he does into her trunk. She drives it the next day to Sigfredo Garcia, her baby daddy. He takes it out of the trunk, and a day or two later, she gets hers back. And she says he puts it in her closet, and to this day,
That's not what she said.
she wants you to believe that that money sat in her closet, and she spent it along the way. The records that Miss Hull testified to, showing all her cash deposits, she clearly was doing something with it, right? But to this day, she wants you to believe
Well, we know what
has
she did with some of it.
absolutely no idea how much money she had. Never counted it. Really?
Honestly,
She must have think y'all was born.
I want to know what you guys think about this point. I'm going to pause it. I want to see what you think of this point. Counsel's point is Katie thinks y'all were born yesterday if you're going to think she didn't count her money. Here's my question. Do you think Katie knew how much money she had? Or do you think Katie was like, Charlie's going to keep giving me money. I don't give a fuck how much money I have because he's going to keep paying me. So, you know what I have? Money. More money. I don't know exactly how much cash I had because I was just going to keep spending it. And if I ran out, Charlie was going to give me more. Let me know what you think.
She must have think y'all was born yesterday. But here's something. She's got this new thing she wants to testify to. That the money was wet, and Charlie told her that Donna had washed it. Her money's wet, that she hasn't touched, that's been somewhere else for these number of days. Well, what did Luis Rivera testify to about his money that he got? He said it was weird. Well, how was it weird? Well, it was stapled in $100 bills, stacks of 1,000. Not a single word about wet, and he got his money before she did. He got it straight from Sigfredo. This washing
That's a
money
good point.
wet thing is nonsense, and they've already proven that it was Charlie Adelson's money that was paid through Katie Magbanawa to those two killers. Whoops, it's gone. But now it's her
gone. This
And
washing
I'm not
money
sure
wet
what this is
stuff.
all about. The state standing up saying that the defense has suggested that Harvey is the one that did the Evite. We haven't said a single word, presented any evidence, or made any argument that Harvey Adelson is the one who created the Evite. Their witness that they called, Wendy Adelson, sat up there and said, what did she say? She probably did it because her mom doesn't know how. And then their other witness, Chris Corbett, Sergeant Corbett, who does all the media and cell phone tower stuff, he sat up there and he said it was clear to him from his research and investigation that my client, Donna Adelson, didn't have a clue how to work that.
Well, she reached out to Evite.
But she's responsible for sending out an Evite that Wendy says she did, where the names come.
The birthday was such a big secret that she needed to delete text messages, and she's having Harvey send the Evite? Ma'am? She's telling Charlie to delete the texts because it's such a secret, but she's like, Harvey, go ahead. Send out your birthday invite.
Come up with guests who are going to be there that are Wendy Adelson, because she kept that name, and her two sons. So it's Wendy, the name of her two sons, and then Adelson at the end. If that's how it appears, Wendy did it, not my client. And there's more proof of that real quick to come. But the Evite thing is a non-issue. I just can't imagine what that is about. The state has argued that between the time the killers came to Tallahassee in June and the time that they came back in July and actually killed Danny
That's what
Markel,
the digital evidence shows.
that Catherine Magbanawa said in her testimony that between those two time periods, when she was discussing scenarios with Charlie, he would say he had a call from his mother, step out, have the call, come back in and say, oh, they're stressed, they're stressed. Catherine Magbanawa, not one single time testified to when that occurred, number one. Number two, if you've heard evidence in this case and paid attention, Charlie Adelson is not a one-woman man. He's got lots of girls. She doesn't know if that was really the mother on the phone. She doesn't know who he was talking to or what they were talking about. But she wants to get out of prison. So
I'm sorry for all of you listening in the background for my outburst as the prosecutor just blatantly begins to yawn. No cover in her mouth, just blatantly begins to yawn during this closing. That is what I was laughing about. But Charlie's a womanizer. You're a womanizer. He wasn't really talking to his mom. He's talking to the ladies. Except we heard all of his calls with Katie where he talks about his mom a lot. So it's okay.
We're talking about.
But Georgia's just
But
like,
she wants to get out of prison. So she's got information she's willing to share now.
it's a good point about Katie. Like, look,
Charlie's business.
Katie's
There
a
is
lying liar. Do we
slide
believe
that
her?
the state had in its presentation
argument.
this morning that they showed to you that shows that Charlie Adelson owned the dental practice up until 2015. Do you remember seeing that slide? Well, here they are again, ignoring the real evidence. They got a theory and they got to spin it some way, but the evidence from their expert witness, Mary Hall,
yelling.
financial
Ma'am, can we
investigator,
downshift a
forensic
little?
investigator, Mary Hall.
Can we just downshift on that?
She's up here testifying for them, and she says
no, we're not.
that Charlie Adelson was the owner of the Adelson Institute until 2020. And yet their slide says, oh, he sold it back to his father in 2015. That's not what the evidence is from their own witness.
It was sold and then resold.
There was some argument from the state about some things that were in
Oh, now we've done shifted. Thank
Mrs.
God.
Adelson's planner in 2023, around
Fred?
the time that Charlie Adelson
Careful,
was convicted,
counsel.
and they apparently were going to flee the country, take flight to a non-extradition country.
I mean, they were literally trying to take flight.
And
when
there's
they
a
were arrested.
notation in there shortly after Charlie is convicted that says cancel disability insurance. They want you to take what they believe that means as,
Is she going to argue they were canceling Charlie's disability insurance? That's not a bad argument because Charlie was on the phone in one of those wiretaps talking about insurance and Brown & Brown. That's a fair inference to argue. Not bad, counsel.
they were canceling their insurance because they were going away and never coming back. Could it be? Those were the words that were used. This is not a could it be situation. This is beyond a reasonable doubt. They have nothing other than that notation. Well, could it be that Charlie was convicted and he no longer needed disability insurance because he was going to prison for life?
I mean, he hadn't been sentenced yet.
Just as likely.
Fair.
How
It's
about
a
this?
fair
Could it
inference
be?
to argue.
Could it be in State's Exhibit 142 on the front page that they showed you with
That's a
this little
fair inference.
notation, notify everyone who was invited to the 70th birthday that party is off if that's what HJ decides to do. And that's on June the 13th. Could it be, the state says to you, that if the killing had actually taken place the first time the killers came up, then they'd be canceling the party because Danny would already be dead? What?
Well, it would be in bad taste.
Does that, where is the proof of any of this? Could that be what it means? This is not, could it be? And a birthday present. The birthday present, according to the state, for a 70-year-old man is that they're going to have Danny Markel killed. Happy birthday. Let's have a party. What? There's no birthday present, according to Rob Adelson. Wendy Adelson, who was at the party and who was involved, and there are emails that tell this, involved in helping get a caterer for the party where the man came and cooked paella out on the balcony for everybody.
Oh, now we can
But that's
pronounce
what Charlie
paella.
decided to give. But you got to read the worst in every single piece of evidence that they present to you. You have to, because that's the only way you can convict, and they want you to convict her. There's no evidence that there was a birthday present to Harvey Adelson to have this man killed. None. But that's their theory, and they're still spinning it. And you gotta ignore the witnesses that they put up there in order to follow their lead into that jury room and convict my client. Let's talk about Rob Adelson. They brought him in here, and he got up there and he testified on the
Ma'am.
stand about allegedly all of these things that he claims his mother said.
It wasn't alleged, it was his testimony. If you don't find it believable, that's different. But going after Rob does not seem to be the vibe, ma'am. Oh, Chad, I'm with you. Throw Wendy under the bus all you want, ma'am. Don't come in here throwing Rob under the bus.
If you were paying attention by the time we got to cross-examination,
If
what
you were
did we
paying
learn about
attention.
Rob Adelson?
If you were paying
He's
attention.
a doctor, and he's got little kids, so he's real busy, which is his explanation for why he rarely speaks to his family on the telephone and has, in that time period, only been down to see his family 2 times in a 2.5-year period.
Your argument is that Rob is not an involved enough son, ma'am? That he's a working ENT and he has 2 very young children during this period of time? And he flew from New York to Florida twice? Donna seemed to like move up to Tallahassee to be with Wendy. She could go to New York. Ma'am.
And he rarely talks to him on the phone.
I interrupted her flow. Apologies, though right now it's all just kind of one note.
His explanation for why he rarely speaks to his family on the telephone and has, in that time period, only been down to see his family 2 times in a 2.5-year period. And he rarely talks to him on the phone, but somehow Miss Adelson has made all of these comments. This is a guy with an axe to grind, right? He doesn't have any of this information. Ooh. He's not talking to him. They got him to come for the birthday party, and what was his testimony? He's a busy guy. He flew in the night before the birthday. He was at the birthday party and got up the next morning, packed his bags, and put him and his wife and his kids on an airplane and left because he was busy. He's not hanging out with his family.
Reporters, wait. What is the court reporter looking at? The court reporter's face was incredibly expressive in that. I'm backing up, but she's just throwing Rob under the bus. But for everybody who's listening in the background, if you can, I'm just going to replay that real quick because the court reporter's face caught all of my attention.
They got him to come for the birthday party, and what was his testimony? He's a busy guy. He flew in the night before the birthday. He was at the birthday party and got up the next morning, packed his bags, and put him and his wife and his kids on an airplane and left because he was busy. He's not hanging out with his family.
Huh.
He's nowhere to be found. Oh, but you got to believe everything he tells you. A huge percentage of the argument of the state was, well, what did Rob say? What did Rob? Rob doesn't have the knowledge of anybody. He's not here. He lives in Albany, New York, and he's not around these people. But let's...
Ma'am, there might be a reason that Rob's not around these people. These people. Your client. There might be a reason that Rob is not around these people. Ugh. Attacking Rob is a wild choice, but it shows you that the defense thinks that Rob's testimony is damning. Because Rob doesn't talk to his family that much, and yet his mom called him up and said, don't talk to the FBI, and he's like, I already did. Well, you don't know anything anyway. That's pretty damning testimony, isn't it? But she's going to say Rob has an axe to grind. Did Rob come off as a witness with an axe to grind? Because that's not how I read his testimony.
Use her son, who's clearly estranged from the family, to try and bury her.
The state used,
Smarter.
The state used her son to try to bury her. Woo! Counsel!
Percentage of the argument of the state was, well, what did Rob say? What did Rob? Rob doesn't have the knowledge of anybody. He's not here. He lives in Albany, New York, and he's not around these people. But let's use her son, who's clearly estranged from the family, to try and bury her. You're smarter than that. So my client has been charged with the murder of Mr. Markel.
Oh boy.
Conspiracy, the planning to commit murder, and solicitation, hiring the hitman that killed. We're going to go through the jury instructions briefly. The judge has already gone through them, but we're going to go through in a minute what actually is there that the state has to prove. And just like I said in opening, what the state thinks happened does not matter. What they believe happened does not matter. What spin they want to put on it does not matter. You can only make your decision based on the evidence presented to you, and up through the time that Dan Markel was killed, that's all they got. She said some ugly things, and she meddles in her children's lives. Meddles in their lives. Gets involved in their divorce. She's a parent. She's just being a parent, not a killer. She's a meddler, not a murderer. They haven't proven that to you.
How long did you work on that line, counsel? I need to know. She's a meddler, not a murderer. Donna didn't know. That's their defense. She's just a mom.
Just like I told you in opening, what they were going to be able to prove, and that what you were going to hear a lot of evidence about, lots of introduction of exhibits was going to come in. They proved that those two men killed Danny Markel, that Catherine McDonald was the one who found the killers, that Charlie Adelson is the one that paid the money. That's it. Oh, and Wendy Adelson is the one who wants to get her kids back. That's why they're killing him. Nothing about Donna Adelson. We sat here for days listening to testimony of witness after witness getting on this stand. Not a single one of them connected my client to Danny Markel's murder. Not one.
That's what the evidence shows.
I think the state introduced a couple of exhibits. They would be 64C and F.
I'm actually a little thankful that she stopped yelling.
Sorry, I can't do technology. Somebody has to help me.
Well, at least you've stopped yelling.
And these are emails where she's giving her daughter advice on what she should do, preparing for mediation.
It's like a full
Oh, how
Scooby-Doo
terrible
defense
of
at this
her.
point.
But what they didn't want you to see in this email, you see that highlighted part? If she thinks she's going to have him killed, why is she telling her daughter in mediation, make sure in the final order that he has to pay half of this expense and half of that expense and extracurricular activities and tennis lesson and baseball teams and travel? Well, who cares if they're going to kill him? Why is she writing that?
Well, what day is that?
Negotiate.
What day is that?
Negotiate. Shame on her getting involved in her daughter's divorce. Negotiate. Let him know that you want him to see his children. And they talk a lot about this bribe. Bribe. This man, they were considering giving him $1 million to relocate because he had already lived in Miami with Wendy. Relocate back to Miami. He taught, according to Wendy, 2 days a week.
So relocation wasn't
He could
done?
commute by airplane. They were willing to pay for plane tickets, give him money to buy a house, expose his children to a more strict Jewish environment where they had Jewish schools and all kinds of activities and be around more kids, kosher like Danny. Relocation was never about taking those kids away from him. It was, how can we make it happen? You can live in the same city, we can co-parent separately, but be together, be around each other, and all have family support. Shame on them for wanting to help him like that. They act like they were doing something illegal. That's not illegal. You heard the woman testify. It happens a lot in divorces.
He didn't
People
want
offer
to.
money to get certain things that they want, or they concede something they're entitled to. But if Mrs. Adelson does it, she must be up to no good. This grandmother motion, I want to point out something to you.
Except he was
in
murdered,
just a
counsel. Yeah, ma'am,
second. That would be 60 JJ.
he didn't want to move to Miami and fly back and forth to teach at FSU. But, you know, they're still talking about that relocation, aren't they? I'm glad she's not yelling.
The state calls this the grandmother motion because they're prosecuting grandma. Sounds kind of cool, right? There's this terrible motion, this grandmother motion that was filed against my client, Mrs. Adelson.
I mean, it wasn't filed
This
against her.
pleading is actually entitled, let's see here, Former Husband's Counter Motion for Enforcement of MSA, which is Marriage Settlement Agreement, on Parenting Issues and Motion for Contempt and Sanctions.
Were any of you confused that this was actually called the grandmother motion? Was anyone confused? Did anyone think that Dan Markel's lawyer titled it the grandmother motion? No one was confused about this, cancel. No one. No one was. Okay.
And this pleading goes on and on about, he says Wendy's refusing to facilitate video teleconferencing with the 3 and 4-year-old, that she's failing to regularly facilitate telephone contact with the children.
I can't wait to hear what she says
that she
about,
routinely violates the right of first
Vietnam.
refusal, resulting in the children missing days from preschool. That she violates her duty to inform, that's in the MSA. She fails to follow clinical recommendations. She violates by refusing to communicate with Mr. Markel. She persists in inhibitory parental gatekeeping. Refused to provide access to have both children on one of the child's birthdays. The only single complaint he makes about my client is she called him stupid, according to a 3- and 4-year-old.
Where'd that twang come from all of a
And-
sudden?
Not sure I can do this, but I'll try. Number 6, this is the section. You can write a motion and put all your complaints in it in your legal argument, and then you ask for what is the relief that you want.
I'd like to file a complaint.
He wants all kind of relief related to Wendy. And this is what they say. The state says that he's saying that the grandmother cannot have any unsupervised contact with the children. That's not what it says at all. It says consistent with the right of first refusal. And safeguard the children so she doesn't call him stupid anymore. This does not mean she can't have unsupervised contact. It means consistent with the right of first refusal. If grandma's in town and she's going to watch the children, according to their marriage settlement agreement, he has to be given the opportunity first if he wants to take care of the kids. That's what was agreed to in the divorce. That doesn't say no more unsupervised contact with grandma. Now, besides her not knowing about it,
Donna didn't know.
what is the evidence? I don't want to mess this up.
I'm starting to poll to see if the defense is going to mention that jailhouse script.
What is the evidence that supports 2 things? 1, that my client did not know it had been filed, and 2, that Danny Markel was not trying to keep my client from having unsupervised contact with him. Well, the proof is, from Wendy's testimony, that he continued himself because during the course of the marriage and separation and divorce, my client, Mrs. Adelson, didn't just continue to assist Wendy when Wendy needed help with the kids. She continued to assist Danny. And in fact, that motion was filed on March the 26th, and the testimony was for almost 2 weeks in April, my client watched the boys while both parents were out of town. And my client facilitated the Skype with the grandsons for Mr. Markel. Now, if he's really worried about her having unsupervised contact, is he going to leave him with her for almost 2 weeks in April?
Banana
And he
bread
does
gonna
it
come up?
again and again. And the last time that he does it is on July the 11th. That's according to Wendy. He comes home and he needs help. She's going to go do something, and then now it's his time to have the children. So he asked my client, Mrs. Adelson, if she could watch the boys, and she does. And she knows he likes this particular kind of banana bread that she makes, and they're going to mock us for this, but that's okay. He likes this particular kind of banana bread. It's got chocolate chips in it and no nuts. And so what did my client do? Before he came to pick up the boys the next morning, the evening before, she makes him a loaf. But she hates him. She hates him and she wants him dead.
She wanted him to
clearly
move
he
to
hates
Miami.
her because he filed a motion. It's unbelievable. Us sitting here is actually unbelievable. Now, I want to talk about the day that Danny was killed with respect to my client. We're not going to go through all the details again. But what is
You've
the
done it a
evidence
lot.
about my client? The state has said that my client tried to set up an alibi for her daughter. I don't know how it could have ever been considered an alibi because the man was going to get there at 8 o'clock in the morning, and the evidence is he got killed around 11 o'clock.
It was actually a window
But
between 8 and 12, but
State's
okay.
Exhibit 64FF.
Ma'am, have you had Best Buy come to your house? I think once they've come at the top of the appointment. Generally, it's toward the end, but okay. There was a window. But all right.
is from the Geek Squad. And the state presented earlier that not only did Donna Adelson send an email to Wendy that morning, or before then actually, not only did Donna send an email to her about the appointment, but Harvey, the dad, did as well. And here is the form that was completed, not by Donna, they say Donna arranged it. Mr. Harvey actually made this appointment for the broken television. They had purchased a plan for protection on this television and believe they may get a replacement or a repair. When they made it, you have to fill out some information on the form. And what does this say? Would you be willing to accept a sooner appointment if one became available? Yes. Well, now, are you going to accept an earlier appointment if it becomes available? If you've got a homicide planned? That doesn't make any sense. This is supposed to be her alibi, but they're agreeing you could come earlier if you want.
I mean, you argue what you got.
And then the mother sends an email. Do we have that?
They're arguing what they got.
And what she tells her daughter is, if you can't keep Friday, July the 18th between 8 a.m. and noon, call that number to reschedule. The contract is under Harvey Adelson's name with Dad's cell phone number, but the purchaser is actually Miss Donna's name and cell phone number, and she provides her with a work order.
I thought Charlie bought it.
We did this for you, like we do everything else for you, and apparently that's a bad thing according to the state, helping your kids this much. But here, we helped you out, but if this doesn't work out for you, change it. A fake alibi, that's what they want you to believe. You got to read bad into every single thing they present to you to come to the conclusion that they come to. Now let's talk about Defense Exhibit 71. There was, according to the testimony that you heard from the state, Wendy Adelson was interviewed at TPD the day that Danny was killed. They went and found her at a restaurant, and they've introduced these pictures about what she did that day and where she went and how she took the long way around. But she's sitting at TPD being interviewed, and she has requested to be able to call her mother. And unlike other exhibits where the state hired someone to enhance it so you could hear the call better, they didn't do that in this case. And the recording is actually inside the room. You can see it. That's an interview room at TPD. And not only are you hearing what Wendy is saying, there's the victim advocate that testified that my client was shocked when she heard the news, but my client is actually on the other end of the phone, so it's not real easy to hear. But if you put the headphones on, you're actually going to hear some things, and you can hear what my client's reaction is to finding out that Danny Markel has been shot, excuse me. Can we play that? If you could just please put your headphones on. It's not easy to hear.
Can we play that? Do we know how to? The thing is, the points the defense has made for me get lost with the screaming and the banging on the table, because she has made some points. If a juror is like, yeah, I'm not comfortable with this, there are points that a juror can say, what about this? What about this? What about this? However, a lot of those points are just getting lost in the yelling. But the jury hasn't seen this yet. It wasn't published. It was put in evidence. Yes, they can publish it now and use their time to do it now. It wasn't published because it needed to have some statements taken out of it. That was yesterday. So now they are going to publish Wendy calling Donna in the interview room to tell her that Dan Markel has been shot. Optimistically. I mean, I hope they play it. Let's see if it plays.
Want to hear?
I need to sit down. I'm fine, and the boys are fine.
I'm fine and the boys are fine. I'm going to try to gain this up a little.
Danny has been. Dan, you can put me on speaker. No.
I've never seen this. I'm going to back this up one more time now that I got it gained up. Donna looks like her face is about to start facing. Does her mom cut her off a couple times? when she's starting to say Danny has been curious.
Here?
But I've never seen it, so I'm going to back it up one more time now that we've gained it up.
I need to sit down. I'm fine, and the boys are fine. Danny has been. You can put me on speaker. Yeah. Danny has been shot. And I don't think he's gonna make it. And so I know. So I found this out around 1 or 2 today, and I'm at the police station, and I'm trying to help them figure out who may have done this. The boys are fine. I had Lynn and Ellen pick them up from school, and they're with Lynn and Ellen right now. And I'm gonna leave here soon and go be with them. But I really need you to come here and be with me. I want you to either fly, and obviously you can't leave right now, but I need you to get yourself together. If it's too much to drive, I'd really rather that you flew up. I'm at the police station, and I'm gonna leave soon and be with the boys before they go to bed. They're with Alan and Lynn, and they're totally fine. Yeah, the boys are fine, but they don't know anything yet. In his house, I know. So I just need you to calm down before you get in the car, okay? Okay, so, and it's evening, so if you want to come here tomorrow, I have a lot of people that'll, be here with me, and, we'll have a lot of support. So I want you to take your time and just be safe in getting here, but I'd like you to come when you can, okay? Okay, all right. I love you. I think Jane might, I have the car here, but Jane might take me. I'm not going to be alone, so I have a lot of support, and I'll be fine. Yeah, if you could just come here, that would be great. He's in the ICU in the hospital. Okay, but be careful, okay? Okay. Okay. Okay, love you too. Bye. Mom.
I haven't actually put the headphones on, but hopefully that assisted you in hearing. But like the victim advocate for TPD testified, she was shocked. She's not sitting home waiting for a phone call, let us know that it's done. It's 7 o'clock at night, and Wendy's calling from TPD to tell her mother that Danny has been shot. She has to tell her to calm down before she gets on the road, and you can clearly hear her elevated voice. She's asking about Danny. How did it?
Mom, I'm okay. The kids are okay. Danny's, yeah, you can put me on speaker. Danny's, yeah, she's cut off like 3 or 4 times. I'm okay, the kids are okay. When I'm okay, the kids are okay, or the first sentence, the next thing is, what happened? No, yeah, you can put me on speaker.
Happened, where was it at?
Okay.
Well, where's he at now? He's at the hospital. This is not somebody who's planned for him to be killed. Now, the state has made a pretty big deal about the road trip that the 70-year-old man and 64-year-old woman take that evening when they leave their home.
What?
It's 11 years into this case. It's this July that just passed before the investigator in this case, who's given testimony again and again, after he's deposed, decides, I'll go ride the route.
Drive the route.
11
I gotta turn
years.
her back down because she just
They've
keeps
been
yelling.
claiming now my client arrested
Better.
almost 2 years ago, that this ride is completely off, but they haven't even tried it themselves, right? And even when he testified, and also when Agent Sanford testified, first of all, he didn't do the whole route, he did a segment, because he's determined that in this segment is where Mrs. Adelson was at for too long. Did you take any snacks when you did the ride? And he's only doing part of it. Well, yeah.
I mean,
Did you get
snacks
some
are
coffee?
critical.
Yeah. But they've calculated this drive for these folks who have just received horrible news and they're clearly upset about it, that they had to be at their son's house dropping off money that was washed, because there's a period of time that it takes them longer to get to their hotel in Orlando than it should have.
Well,
They took into consideration nothing with respect to their
Charlie said.
age, that they hadn't had anything to eat. They didn't calculate any time in to stop and get gas, or to use the restroom, or to maybe sit down and have a meal. None of that's counted in. It's got to be a strict from here to there, and you're not there, then you must be doing something bad, and it must have something to do with murder. They give no consideration to that whatsoever. But what's stronger than that is their own testimony from their expert. They have all of these slides that they've shown you where they can show where everybody is in the entire world. And did you notice that for the killers, they had collected records with SunPass and cell towers, etc., and they have a whole map that they're showing you of where they went and what they got. They got the SunPass records for the killers. Agent Sanford said that my client was a person of interest from the beginning, but he had her locked in a year. And yet here we are 11 years later.
That was me.
And they never bothered to get her SunPass records. They can get them. They got the killers. If they want to tell you that they're stuck in a certain area and they've gotten off in a certain place, all they had to do was get those records. But they didn't do it.
Well, the
They can
testimony
prove
was
where
they
the killers
tried
are,
to.
but not my client. But
And
one thing for certain that they
nothing
did
was
say
returned. It's a fair argument.
is they cannot put my client's phone at Charlie's house during this time period that they say that they took too long to get somewhere.
The other point
They
was
also
better.
testified that there is never a point in time that evening where Charlie's cell phone is hitting on a tower and either Harvey or Donna's cell phones are hitting on the same tower. They don't even have them in the same vicinity, much less the house. But they want you to believe that means Mrs. Adelson was there dropping off money. They have no evidence of it. It's just their theory. That's all it is. You can't convict somebody based on theory. You have to have evidence beyond a reasonable doubt. Now, how about this text message that says outside your house?
Yeah, what about that?
According to them, outside your house means outside your house.
Was it code, counsel? Was the text outside your house code for something other than outside your house? Also, Charlie says like 10 minutes, and then the cell phone tower his phone pinged off to send that text for 10 minutes was 10 minutes away from his house. But beside that, the state wants you to believe that the text outside your house means outside your house. I'm fascinated to learn what else it might mean. I can't believe she actually said that. I don't know what to say about that.
How about this text message that says outside your house? According to them, outside your house means outside your house. I'm not saying that's illogical to jump to that conclusion, but do you have any evidence of it? No, they can't put her there.
Sorry.
And according to State's Exhibit 142,
You were better with the other argument, counsel.
if Mrs. Adelson was at Charlie's house, what in the world is she doing hanging outside for over 30 minutes before he gets there?
His text literally said 10, but whatever.
She's got the garage door code to get in. But she's outside the house. They introduced this. She had talked to him, according to their records. She had been on the phone with Charlie. She talked to Charlie. And then later on, they send this text message, and it could mean many different things. But it would have been 30 minutes while they were waiting there for him to get there. And
30
there's
minutes?
no reason for them to be outside the house because they know he's not there.
Where'd 30 minutes come
It took
from?
him 10 minutes to send, or 20 minutes to send a message back saying he was 10 minutes away.
Oh, from the
And then he
text
had
times?
to travel there. They don't have proof that she went there. They want you to envision it and imagine it and believe it because that's their narrative.
She just said, I wanted to look at the times. So Donna texts at 8:59:26. Charlie texts at 9:19:17. It's a good look. It's a good thing to point out. Hey, this is 30 minutes. They're saying she's got this hour unaccounted for. It takes them 30 minutes to say 10 minutes. That's a fair point to point out, but it's getting lost with they want you to believe outside your house means outside your house. That argument is stupid. This argument, look, it takes him 20 minutes to even text back and then another 10 for him to get there. So that's 30 minutes. Why are they waiting? That's fair.
That's what they tell. And I don't think I said it before, but the witnesses, the additional witnesses that testified that Charlie kept his cash, these $100 bills stapled together, that was Miss Umchenda and Mr. Fitzpatrick. They both testified they knew Charlie well, and that's what he did. No evidence at all that my client did that. Do you remember back in jury selection? I didn't do it for Miss Adelson, my co-counsel did, Mr. Zellman. But he asked you a series of some similar questions, and he asked you, would you agree that the state could make a mistake in the theory of their case? Yeah. Would you agree that law enforcement could make a mistake in their investigation and determining who they think committed a crime? Yeah. That was the overall response that we got. It was asked of everybody who came up that got individual questions. I mean, questions as a group. Well, according to Special Agent Pat Sanford with the FBI.
The who?
Do you remember his testimony? According to him, he has never made a mistake.
That's not what he said.
Not one time in his career has he ever thought somebody committed a crime and he ended up being wrong. You know what the problem is? When he thought she was a person of interest from the beginning and then he, according to his testimony, locked in on Donna Adelson, the path didn't lead to Donna Adelson. They tried to build a path with something as flimsy as these emails that they say are the motive for her to have him killed. They made some other mistakes. Rob Adelson calling him to testify was a mistake because they've clearly relied on his evidence, and he testified himself. He wouldn't have the basis to give it. He's never around.
Ma'am.
And then they called Patricia Bird.
That's a
next
better
mistake.
That's a better argument than
She
going after Rob.
claims different ways that Donna was going to buy her some land and a trailer to put on it, a small car to drive, and fix her teeth to testify untruthfully. She said that a white female investigator actually offered her all of those things. But then when it was pointed out to her that the investigator that came to see her was actually an African-American female, oh, it was her that did it. Then she wants to tell you that my client confessed to her. I asked her, did she do what they said you did? And Miss Donna said yes. Well, she's not clear on this confession because when Mr. Zellman was asking her questions, she couldn't remember if it was Donna said she wrote the checks or she confessed to the whole crime. But here's a woman sitting in front of you that has come up all of a sudden at the end of the game, and here she
That's not what the
is
evidence showed.
claiming that an investigator offered her these things, and that was for false testimony, that Ms. Adelson was trying to elicit false testimony, have her come in here and swear under oath and testify to things that were not true. Well, both investigators came in here and said that never happened. She was never offered anything. She never told us that Donna had offered her anything. Most importantly, she never told us that Donna confessed. None of that. She's facing going to prison, and she has an opportunity to come in here and testify against Miss Adelson so she can get a deal. What was she facing, 5 or 6 years? Here's the biggest part. Did you hear what the judge read to you this morning before he started with the jury instructions? He read to you a stipulation. As he explained, that means the state and the defense agree to certain facts, and you must accept them as true. And what was the stipulation? Patricia Byrd was never on the witness list for Donna Adelson. Well, isn't that interesting? She was going to come in and testify falsely for Donna Adelson, and she's never been on a witness list.
I think y'all like your bar licenses some, but that's just me.
And then you got Drina Byrd.
Oh, all right. I'm going to end the poll. The poll was up. Over 8,000 of you voted. Will the defense mention the script? I said, yes, they'll argue it. 41%, no, they'll ignore it. 59%. I'm going to end that poll. Thank you for the 6,000 of you that voted. Now we're getting to Drina Byrd. Let's see what she'll say. She might just call her a lying liar and move on.
This is not just someone who is hoping for some help in her case.
Not Drina Byrd. Drina, did she say Drina Byrd? Drina Bernhardt. Sorry.
And then you got Drina Byrd.
Yeah, she said it wrong. It's Drina Barnhart.
This is not just someone who is hoping for some help in her case. She already got it. Her testimony was she is a 27-time convicted felon and/or crimes involving dishonesty,
which can be misdemeanors,
facing 15 years in the Department of Corrections as a prison releasee reoffender, which means you get day for day with no gain time. Here she comes saying she's got all this evidence, and Donna's offering to do the same things for her that, oddly enough, Patricia Byrd in the same cell block has said is going to happen. What does she do? We tried really hard not to bore you by playing the whole tape, but there's an exhibit that we put in, and it's the video of where Donna and Miss Bernhardt are sitting at a table. Oddly enough, Miss Byrd wasn't there, and she told you that she was with Donna Adelson day and night talking about her case. She wasn't anywhere around when they're sitting at this table, but you can watch that video again.
Middle though.
I would just like you to recall this. Who shows up to that table first? Drina Bernhardt does. Who shows up with paper and a writing instrument? Drina Bernhardt does. And while they're sitting at the table, is Donna sitting there just telling her? No, they're having a conversation. How does the writing start? Miss Bernhardt gets out her little hot pink folder, paper, whatever it's called, notebook, plops it open, shoves it towards Donna Adelson, and starts tapping on it. Let's get busy writing. You don't hear those words, but that's what she's doing. Here, write. And allegedly, she's going to do the same thing, give false testimony, and her name is not on a witness list. A little bit more about Catherine McBanawa.
Chat. She inferenced the script, but she didn't mention it. Did she? Inference, but she didn't directly mention it. I think she's ignoring it. She didn't say script. She said, let's get to writing. Oh, that's a gray zone. We might have to argue this one later. Because she inferenced writing, but she didn't mention the script. My question was, will she mention the script? She didn't mention the script.
Actually, I covered that.
We'll see.
So if this is all they've got, up until the time that he died, just that she said bad things about him and helped her daughter with her divorce, what is the evidence that they have after Danny Markel was killed? They put this evidence in. They got nothing to show that my client was involved in any way leading up to the time that he was killed. But they elicited the testimony that it was 2 months after the murder when Charlie Adelson discloses for the first time to his mother what he knows about the case. Now, all she knows is what he's telling her, but it's 2 months after the murder when he's telling her, well, what happened was I got a girlfriend and I had told her about this $1 million offer, and she said it in front of some of her friends, and they've gone up there and killed Danny Markel, and now they're demanding money. And so they said if I didn't turn over my third of the $1 million, this is what he claims that they elicited, if I didn't turn over that money, then I'd be dead in 48 hours or they'd kill my family. So he goes into his safe and pulls out $138,000 cash, puts it in a bag, gives it to Katie, tells his mother 2 months after the homicide, now he's being extorted.
That's not in evidence.
She works at Adelson Institute. They want you to believe this is a family business. Does family work there? Clearly. But who owns the business? Who does the money belong to? Who is Mrs. Adelson writing and paying all the bills for? Who's she doing the salary for? Everybody there. Everybody there. So he tells her, right around $1,000 a month to Katie Magbanawa, it'll save my life. They had this forensic investigator, and they didn't present anything to you, not a single check ever, that Charlie Adelson signed for his business, because he had his mother paying the bills, doing salary and other things at the dental office. That's him paying these people. She's doing her job because he says it'll save his life. She believed it was the truth, so she did what he told her to do.
That's not in evidence, counsel.
Was there pushback or not? We don't know. They didn't present any evidence about that. They claim she would have pushed back. Maybe she did.
Present evidence about your client's state of mind either, but
what we do know is it's 2 months after the murder before she knows what has gone down.
We don't know that either.
That's their evidence.
Okay. She's saying it's a reasonable inference.
But she conspired with people to have him killed. She got the hitman to have him killed, and she wanted him killed, and he ended up dead. She doesn't even know about this going on.
Donna doesn't know.
And the only version she knows is what her son has told her. Did she say, oh, the truth's coming out, the truth's coming out, the truth's coming out? She did, because that's what Charlie had told her the truth was. And that's her son. And she believed him. And she didn't want her son to die. She wrote paychecks at Charlie's instruction. That's not her giving cash and paying off murderers. That's a paycheck to Katie.
Surprised they didn't object.
That's it. That's all she did. So we're bumping along, and now we're in 2016, and it's a bump. Law enforcement testified to you that they created this scenario where they could try and get information to further investigate this homicide. So they've locked in on Mrs. Adelson, so they're going to set her up. Funny thing is, Mr. Sanford testified to what probable cause is that you have to get a wiretap on somebody's phone. And You have to have proof that a crime has been committed, and this is likely the person who committed the crime. It's not proof beyond a reasonable doubt. It's the same that you have to get a warrant to arrest someone. But when they do this bump in April of 2016 to June, who do they get wiretaps on? Charlie Adelson and Catherine Magbanawah. Not Donna Adelson. But they're just sure she's the mastermind behind this. So what do? They follow her.
Oh, counsel.
They watch her daily routine. They pick a location where she is taking her grandchildren, Mr. Markel's children, to and from school.
Whose last names have
and
been
they
changed to
decide
Adelson.
that's where they're going to do this bump. This is State's Exhibit 113 of the bump on the street that took place on April the 19th of 2016.
Are they going to play it?
Am I in anybody's way?
Black shorts. What is it?
Oh, they are going to play the bump.
Okay, I got that.
Excuse me, Mrs. Adelson? How you doing? Just want to give you this. Listen. No, don't be scared. Listen, just want to let you know that we know that your family has been taking care of Katie and her friend Google for quite some time after your problem up north that was resolved. And I want to let you know that my brother, he's incarcerated. He helped your family with this problem you guys had up north. And we want to make sure that he's going through some rough times. We want to make sure that you take care of what he's going through, the way you're taking care of Katie and Tuco. Well, this will explain it. Thank you.
What did she say? You scared me. And he goes on his little explanation, and her response is, I don't know what you're talking about. Now, the state says, from what happens next, which is a phone call that Mrs. Adelson makes, she has to be involved in this murder. Because she doesn't call the cops, she calls Charlie. Well, why'd she call Charlie? Because Charlie has confessed to her his role in paying the
I don't think
killers
that's an
back in
evidence.
September of 2014, that it's his money, claiming he's being extorted, claiming his life is at risk. That's who she's going to call, because guess what? Now this man is talking about the people who are involved in the murder.
Is
You're
it an
taking care
evidence
of
that Charlie
Katie.
confessed to her?
So yes, she calls.
That he did
And
this?
the state wants you to believe that there's this huge made-up code. They allowed you to look at the transcripts when that was going on, and you looked, I watched, you were all intent looking at the transcripts and listening to the calls. If you go back and want to hear them again, you're welcome to do that. She's responding to his questions and his instructions not to talk about this on the phone, but he keeps pushing and pushing and pushing.
He does do
So
that.
she's trying to give him a hint without actually saying on the phone what's going on.
Or shut the fuck up.
These are hints, not code words like the state wants you to believe.
The prosecutor's face is like, hints, code words, we use them synonymously, but we listened to all of those wiretaps. Was Charlie picking up those hints?
Can I have just 1 second, please?
I mean, counsel, it's your time. I really don't think there's any evidence that Charlie confessed to Donna. They're approaching. I'm just making a note. I really don't remember that being in evidence. Maybe it is, and I've forgotten. A lot happened in this case, but the defense said, "Can I have 1 minute?" And then said, "Can we approach?" And it looks like they were checking the clock. I guess I would speculate they were checking how much time the defense has left.
Members of the jury will take a brief break at this
They're taking a break.
time. If you need to use the restroom, please do so during the break, and we will continue with the closing argument.
Okay. I'm not quite sure why they're taking a break.
Everyone can be seated. If you need to use the restroom or stretch your legs, this is your opportunity. Or something to
or
keep
not.
yourself from passing out. This is your opportunity now. 5 minutes.
I'm not sure what counsel needed for 5 minutes. Let's zoom and see if we can we get past that break. Good. We had enough zoom room. All right. They took a 5-minute break. I don't know if the jury's back in or not. I guess we'll see. Court is click-clacking on the keyboard. I wonder if they're waiting for the jury to come in. Everybody's sitting in court. I'm going to zoom. The defense is showing something or getting something from the prosecutor's desk, looking at something on the prosecutor's desk. All of you are like, Emily, what are they doing? I don't know. But here we are. I'm suspecting we're waiting for the jury now. All right, everybody stood up for the jury coming in. All right, jury's back in.
Wolford, you may continue with the defense closing argument.
And they're continuing. Okay. Defense closing continues.
As you recall from the testimony, there was a meeting between Charlie Adelson and Catherine Magbanawa after the mother had...
The defendant?
It was after the bump, right? Do you have that? There's a transcript of that. You can't make out everything they say, but this is part of the transcript that I wanted to point out to you.
How do you not know that it's after the bump?
Talking. Don't waste your time with mom. They need to talk to someone who's first person. Wouldn't it make sense that they make a connection to my family, to me, to my family, not my mom? And then he says to Katie, "You're the office help. Checks are on me. That's just because they found out you come in and work on the weekends. Trust me, I'll keep you on full time, so you're going to get your checks." That's Charlie Adelson agreeing that he's keeping her on payroll, and the checks from him will keep coming. After the bump on the street, Mrs. Adelson receives a letter. statement from, or the evidence that came from the state's witness, you recall that he said that his instructions on when he met her on the street was to be polite. This is not so polite. The next thing, she gets a letter and it says, so my phone is not ringing, so you don't care about Tato and what he did for you. He knows he is fucked, and soon so will you. Now, it doesn't say I'm going to kill you, but now the threatening behavior is coming, and they're taking the next step to try and get Mrs. Adelson to come out and admit to something. If she pays the $5,000, bingo, right? She doesn't do that. So that happened on April the 26th.
It's funny because in all the calls and
Then
texts,
she
Charlie
does
says they're
nothing
not threatening
still.
enough.
She's scared, and you recall from the phone calls, she's scared. She thinks it's someone related to the killer. She's worried about her safety. She thinks something bad is going to happen to her, but Charlie just keeps saying, Mom, everything's okay. You have nothing to worry about. Then on May the 4th at 2:09 in the morning, the undercover sends her a text message, 2:09 in the morning. So you don't take me serious. You think I'm playing. You have some puta call me to see if I'm for real? If you think what Katie baby daddy did for you can't come back, you're fucking crazy. I want the now, or I'm going after the 100K. So, threatening. I'm going to go to the police. This is not going away. Don't think that I'm gone. We're still here, and you're going to do something about it. That happens on May the 4th.
Be with you.
As you recall from going through the wire summary with the state, other calls
That
take
date
place
I
in
remembered,
between.
the May 4th.
And then on May the 6th, finally, Donna calls the undercover at the number that he had provided initially, that shows here on State's Exhibit 83 with the
They kept talking in
article
code
about Danny
about
Markel being murdered. Call or text, that's the number that was provided, 305-712-6570, and the dollar amount of $5,000. Now, the state has said to you, innocent people don't fold the paper up and put it in their pocket. I'm pretty sure there's not going to be a jury instruction that tells you she must be guilty because she folded it up and put it in her pocket. She took it very seriously. She got her grandchildren, she went home, and she immediately called Charlie to report that. But now she's calling the number that was provided, and you've heard from the testimony, she downloaded an app so it could be recorded, but of course it was being recorded by the undercover as well. Could we play that call? And I think we have provided a transcript to you because it wasn't provided previously, if you'd like to read along.
This is the call with the undercover.
This is Mrs. Adelson. Is this Sandy? Sandy. Okay. My grandchildren had my phone before, so
Senor Adelson?
I'm Mrs. Adelson.
Yes.
My grandchildren had my phone before, so that's, and I just saw that you called.
Oh, okay. You left a message on my voicemail.
Right, I did.
Yes.
This is my problem. You approached me on Alton Road. You handed me an article from the
This is my
newspaper
problem.
about my ex-son-in-law. You told me I need to call you and help your friend who is in prison. Now, at the time you did that, I didn't understand what you were talking about. I didn't call you back. Then you mailed me a threatening letter. Then you send me a text message to my phone that says I'm not taking you seriously. So I am taking you seriously. And I really want you to listen to me. I have to tell you, I mean, this is important. I have been so stressed out. I have spoken to 10 or 12 people who are close friends of mine, telling them about this and basically picking their brains and asking them what I should do, because I don't know your friend who is in jail. You mentioned a name. I don't even know his name. I never spoke to him. I don't know what he looks like. I've never met him. I'm sorry your friend's in jail, but I don't know what that has to to do with me.
You know exactly what it has to do with. You know exactly what. Listen to me carefully. Listen to me. You just got to listen to me.
You need to ask who this person looks like, or what their name is, something, because I know there's a big reward out there, and if you need money for your friends, that's the way to get it. I mean, I'm asking you nicely. I don't know who he is. I am out of the loop. It is not me. If I can help, I would help. I mean, that's what.
Just like I told you, listen to me. Just like I told you that day, we know that your family had a problem up north. We know that problem was taken care of about a year and a half, 2 years ago. And we know that Katie has been taken care of.
She doesn't deny any of that, does she?
And has been taken care of. Now my brother in jail, we were in Broward together. He told me the whole thing, and he hasn't been taken care of. You know. Now, all that's being asked for is 5K. That's all we're asking for is 5K. And he told me everything, and I know everything. I know who's involved. I know everything, and I'll get the 100K for myself.
You know,
All I ask is to send the 5K. Everybody knows what's going on.
I don't, you're saying everyone knows. I know I lost my ex-son-in-law. I did not have anything to do with it. That's why I said.
There, she denies it.
That's what my brother Tato told me. He told me everything when we were in jail. He told me everything and who was involved. I know everything.
Well, I don't. That's the problem. I'm telling you, it's not me. It's not me. I have had a year of aggravation, a year and a half of aggravation over this. My daughter, my grandchildren. It is not me. And when I asked my friends, what do they think? They said, well, this person needs to get a description of you because of what you look like, or it's not me. I don't know who caused this. It wasn't me.
I don't know who caused this.
I don't know.
I'll tell you, just like that day when I talked to you, this is not going away. This is not going to go away because Tato told me everything. He wasn't being taken care of. He needed the 5K. Spend 5K. That's all we were asking for. You don't do that?
I don't know who Tato is. You don't understand.
We know you know who Tato is, but you know who Katie is. And you know the contacts Katie has, and she has, listen to me, let's stop fucking around. Let's stop fucking around. Okay? You know who Katie is. And you know that Katie has somebody that knows Tato. And they took care of a problem for you people. That's just the bottom line. The bottom line is you know who the fuck Katie is.
Look, I don't.
I'm not fucking around with it. You know who Katie is. You know that they took care of Katie and her people. Nobody's taking care of Tato. I know you don't know who Tato is.
No,
but we know who all of you are. And this ain't going away.
You know what?
So I can give you you want to send the 5K?
Here's what you need to do. You need to go and.
Don't tell me what to do. I know what to do and I'm doing it.
You're looking for money. Get $100,000 or whatever whatever the reward is. It isn't me. You have got the wrong person. That's why I said ask your friends.
You're Donna Adelson.
Yes, I am. Yes, I am.
Well, I know. We know who's involved in all this.
Yes, this is not making any sense. I mean, if you want the money, you should get it from the police. They can give you a whole lot more than you're asking me for money for someone. I can't do this. I have had too much stress and too much aggravation from this, and I don't know what you are talking about. I just don't know. I just don't know.
Good. I think you should talk to Katie. Talk to people that are involved in this. You'll know. You know what's going on.
That's why I'm.
You can tell me, you know, Adelson, you can tell me all you fucking want, but I know you know. Because I know, because I heard, when I was locked up in Broward with my brother Cecil, he told me everything. Everything. He told me everything. I just wanted to take care of him because fucking Katie was being taken care of with her fucking food.
I just think instead of asking me, you should get the money from the police. There's a lot of money out there, and I know, if you think you know who this is, then go ahead and do it, because I know it isn't me. I know it isn't me. And I can't take this kind of level of stress. I just can't. I know I didn't do anything.
You talk to people, you talk to the right people, you talk to people, you make this 5K come to me. That's all I need. Just do it and get it to me. Do it and get it to me. Bye.
They tried 5 different times. I'm sorry. Did you want a particular position? Yeah. Sorry, Judge. 5 times they tried. They tried to get her to pay the money. They tried to get her to admit that she was involved in this. And 5 times it failed because Mrs. Adelson tells them in this call, he keeps telling her, I know everything, I know everybody, I know what happened. And she tells him,
that was me, sorry.
If you know, go to the police. Go to the police and get the reward. Why in the world, if she's guilty of committing these crimes, is she telling somebody who apparently knows everything to go to the police? If you're guilty, you're not sending anybody to the police. That's why they think they can get her with the 5K. But she didn't do it. And
if somebody's blackmailing you over a murder, they're not going to the police
nothing to worry about.
either.
Don't worry. You can hear the fear and worry in her voice on that call.
Do you agree that that's what you heard on that call?
Now, the state talks about coding and code words, and one of the things they say is that in one of the discussions with Charlie, Mrs. Adelson says, it's about the 2 of us. It couldn't be more clear what that means. Her son told her in September of 2014 that he got extorted. He has to pay this money. He has paid the money, and he's going to keep paying the money so he doesn't get killed. Right? Now somebody has walked up to her on the street about the exact same subject, Mr. Markel being killed, and demanding $5,000 from her. So now he's brought her into this. It is the 2 of them. They're not knocking on his door. They're coming up to her on the street. They're sending her text messages. They're sending letters. They're calling. They won't stop. But she didn't do anything. If her son did, that's on him, not her. There's no evidence that if Charlie Adelson had not told her in September of 2014 what he told her, there's no evidence that she would know anything at all about what happened.
Huh?
That's her single source. And he brought it to her.
Well, we know Charlie's her single source. No evidence that
Bring
if he
cash.
had not...
That's one of the things she says. Bring cash. Without telling him what has happened on the street, she's telling him they want cash. That's not code. That's hint, hint, hint. You don't want to talk on the phone, but you won't stop asking me. So I'm going to hint to you what this is about. There's nothing code about that.
She said we can go out to eat, make sure to bring cash. There's nothing. They're not talking about paying for dinner.
What they think these things mean. It's not their interpretation that matters. It's the evidence that's presented. The judge has read you the jury instructions. So I'm not going over all of them with you.
You should go over the one for murder, though.
Murder in the first degree.
Oh, good.
The state has to prove that on July the 18th of 2014, Donna Adelson intended that Dan Markel be killed on that date. They have to prove that. There's no evidence of it. First-degree murder is killing with premeditation. Is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. They've got no evidence of her doing anything until after Mr. Markel is dead, when she writes the checks at the instruction of her son. Conspiracy. The state has to prove beyond a reasonable doubt that the intent of Donna Adelson was that the offense of first-degree murder would be committed on the date that he's killed, not after the date, before and up to the time that he shot and killed. They have to prove beyond a reasonable doubt that she had that intent, and they have nothing. Solicitation to commit first-degree murder. They have to prove the following two elements beyond a reasonable doubt. I'm sorry, back to conspiracy. I forgot to say this.
Okay.
In order to carry out the intent, Donna Adelson had to agree, conspire, combine, or confederate with Charles Adelson or Catherine Magbanawa or other persons to cause the first-degree murder to be committed. Had to be before. No evidence of it. Solicitation. Prove the following two elements beyond a reasonable doubt.
And moving on to
Donna
solicitation.
Adelson solicited Charles Adelson or Catherine Magbanawa or other persons to commit first-degree murder. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine Magbanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. What does solicit mean? It means to ask earnestly or to try to induce another person to engage in specific conduct. We know that the state has not presented evidence of Mrs. Adelson actually shooting and killing Dan Markel. They are asking that you find her to be a principal, that these other people did the killing, but she's a principal. And to prove that she's a principal, you have to show that she helped another person or persons commit the crime. In doing so, the state has to prove beyond a reasonable doubt that the defendant intended the crime to occur and the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. For first-degree...
So that's the instruction on principles. This goes to count 1 and count 3. Counsel is going through the jury instructions, which I think is absolutely critical for the defense to do in this. So she is going through what a principle to the first degree and solicitation mean. And that's what's up on the screen right now.
Premeditated murder, the state must prove the defendant intended that the killing of Daniel Markel occur. Then you heard the instruction of a principal when active participant is hired by the defendant. If the defendant paid or promised to pay another person or persons to commit a crime, to commit a crime means she paid or promised to pay them before they killed him. There is no evidence of that at all. She never paid any of her money. All she did was write the checks that her son told her to write from his business account. Says you have to show that she made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime. Nothing. There's nothing at all linking her to Catherine Magbanawa, Sigfredo Garcia, or Luis Rivera. Her link to Charlie Adelson is it's her son. They like to show those little arrows going back and forth like it's a train, I think they said. This isn't a train. This is somebody's life. Danny Markel's life. And now Donna Adelson's life. This isn't cute. This isn't powdered sugar. They have charged my client with first-degree murder, conspiracy to commit first-degree murder, solicitation of the people to kill, and their example is she's got powdered sugar all over her. No, she doesn't. They want you to believe it. That's their theory, but a theory doesn't prove a crime. They have to present evidence, and they haven't done that. Let's talk about Vietnam.
Is this what they're going to end with then? Let's talk about
And
it.
the evidence that the state has introduced. Their exhibits 129 and 130 are the visas for Donna Adelson and Harvey Adelson. That one's Harvey's. Would you put Donna? Now, there's something very important about these. It says their name and what they're going to do. You see that line? It's in, I guess that's Vietnamese, but underneath it, it's in English. And it says, good for single/multiple entries. That it is a visa for tourism, not residence. It's a visa for tourism. They can come and go as they please. And that it is good until, where's that date?
9/9/2028.
Here it is. It's good until, they put the dates backwards. So this is February the 5th of 1950. And the state says,
What?
oh, well, she was going to be gone past the date of the bar mitzvah.
Nobody thought she was going to be gone until 1950. It isn't a TARDIS. I think she was reading a date of birth. But okay.
This visa allows them to come home, and if they want to go back, go back. Now, here's something really important. The state said that we're trying to tell you she was going on vacation. That's not true. Her prior attorney testified that before there was a conviction, she was very upset and said she wanted to kill herself if her son was convicted. And her husband was concerned about her doing that, so he wanted to get her away, to clear her head so that she wouldn't take such a drastic step. That's not a vacation. She's beyond herself. And then he gets convicted. And it's worse. And here's the thing. The state has been saying, since this woman was arrested, that she was going to flee this country to avoid prosecution. Flee. She's going away. She is not coming back. She's going somewhere where we could never get her and bring her back. They took almost nothing with them. They took a few credit cards, some cash, 2 pieces of luggage, and 1 carry-on. This is Defense Exhibit 147. When the search warrant was executed, after Mrs. Adelson was taken into custody, here's the luggage in plain view with the tags on it to go to one stop and then to Vietnam. And that's terrible. I'm sorry, I'm not criticizing.
I mean, it's just not in focus.
You gotta hold it. In any event, there's the luggage. It's there when the search warrant is executed, and the gentleman from Miami, what did he tell you about that when they executed the search warrant? They didn't even look in the luggage to see what they had.
I mean, should they have?
Not even look in the luggage. More important than that is they conducted, according to him, a thorough search.
I mean, they figured there were clothes in the luggage because she was leaving.
Exhibit 160.
I don't even know if they had a
And it's
warrant
not
to
real
look in the
easy to
luggage.
see, and I might just have to pass it along to you because this is really blurry. You see that? You see that little light down there underneath the white shirt? See that?
What, like a router?
That's the size of Mrs. Adelson's safe, sitting there on that little shelf. They never even bothered to open it and look in it to see if there's any stapled cash. That little bitty safe on that shelf, is that where she allegedly got $138,000?
I don't think it's an evidence that that's a safe, but the argument is from them, I guess, that their inference is that that's a safe. But this was 2020 3? Oh, Charlie, we'll just add it to your pile. Okay.
Dollars in cash and washed it and stapled it after she got this phone call and took it up to Charlie. Never happened. Couldn't happen. Wasn't going to happen. And the investigator was so concerned about it, he never even touched it.
In 2023?
But here's what the state presented, and just like so much other evidence that they presented in their case, this is a state witness. And on cross-examination, when asked, Sergeant Chris Corbett testified there was no proof that they were actually going to flee. When confronted with the 90-day visa, his testimony was, well, they were going to be gone a long time. That's not fleeing. That's not avoiding prosecution. She got arrested almost 2 years ago under that claim. And it took them almost 2 years to come in here and have a jury seated on these serious charges.
Ma'am.
And they finally admit.
Y'all moved for continuances. The other defense attorneys got yeeted. Oh, it took them 2 years. Ma'am, that argument is just not, it's just not accurate.
There was no evidence.
It took them, she's arguing it took them 2 years to come in here. What, because there's no evidence? Okay.
She got arrested almost 2 years ago under that claim. And it took them almost 2 years to come in here and have a jury seated on these serious charges. And they finally admit there was no evidence that she was going to flee. Danny Markel was killed on July the 18th of 2014, and Mrs. Adelson, according to Agent Sanford, was a person of interest, but she was not arrested in 2014. They immediately started, according to him, gathering bank account information, emails, phone records of Donna Adelson. 2015, she was not arrested. In 2016, they conducted the bump operation against Donna Adelson.
Why did it take so long?
Just gone through that entire bump operation. And still, even though others were arrested, Donna Adelson was not arrested. She was not arrested in 2017. She was not arrested in 2018. She was not arrested in 2019 or 20 or 21 or 22. Not arrested. And what did Agent Sanford tell you? That they had listened in on this call or heard the recorded call where Mrs. Adelson thinks she's gotten cut off from her son, and she's talking about going away, getting airline tickets, and she wants to kill herself. She talks about it on there. She wants her and Harvey to do it together. And he wants to get her out of town and away from the media and clear her head. And Agent Sanford said, here's how invested he is, they think they might get a warrant for her on the day that she's arrested. They're not sure if they're going to try or not. But maybe they're going to. So he's up here in Tallahassee, and what does he do? He hops in his car, and he starts driving towards Miami, not even knowing whether they're going to try to get a warrant.
It's not his decision.
When Mrs. Adelson got her visa, there was not a warrant. She was doing nothing wrong. When she booked the ticket, or Rick Sugarin helped book the ticket.
That's fair.
There was no warrant. She was not doing anything wrong. She got advice of her legal counsel that there was no warrant.
Well, that wasn't then.
There was no promise with Mrs. Kappelman, but her lawyer told her of the possibility if they got a warrant, she could self-surrender and turn herself in.
That wasn't an agreement. She was free to leave until she wasn't.
She packed her bags, no warrant. She gets in her car to drive to the airport, no warrant.
Well, there was at some point.
Gets to the airport, and sometime therein, they actually get a warrant, and she knows nothing about it. They go to where she is seated with her husband, waiting for the flight to board, sitting down amongst the crowd, and they watch her and wait, even though they've got a warrant. They don't arrest her. And he gives some, oh, well, you know, there was a crowd of people. There's no more crowd than when you enter the jetway and everybody's trying to get on the airplane. They waited until she presented her ticket and walked through the little door, so they could say that she was actually fleeing. It was a setup. They knew exactly what was going on.
It was a setup? Did they push her through the doors? They just waited to see what she was going to do, ma'am. That is not a setup.
They set her up so they could claim, oh, we captured the matriarch murderer. She was fleeing the country to flee prosecution, never to return. It was a great story. Got a lot of headlines.
Oof.
Spun with their theory.
Oof.
But we're in trial almost 2 years later, and they know she wasn't fleeing this country. You know, I'm gonna sum it up here. And this is from the
Please
state's
do.
evidence. TPD, FDLE, the FBI, and one agency in Miami-Dade are all involved. They have people listening to phone calls around the clock, 24 hours a day during this 2-month bump period. In their investigation, in their words, they have collected hundreds of thousands of emails, over 2,000 phone calls during that 2-month period, recorded text messages, bank records. They got experts analyzing all of this stuff. They got cell tower records, and I don't even understand all that stuff, but it supposedly can place you in places. They've been working on this case, according to Agent Sanford, right up until the time he was sitting on the stand, still investigating Donna Adelson. If you were going to have proof that Donna Adelson committed a crime, you should have had it beyond a reasonable doubt before you put handcuffs on her in the Miami International Airport. They still didn't even know that day if they were going to arrest her. In all the evidence they have collected, she can't help herself but run her mouth. Not a single email, no phone calls that are recorded, no written documents, no emails, not one single thing that said anything about wanting Danny Markel killed. The most aggressive thing they have are her foul words and wanting to aggravate him. This is not, could she possibly have done it? Could she probably have done it? Might she have done it? You have been sitting here hearing testimony for almost 2 weeks, and there's not a single piece of evidence that connects my client to that murder. Charlie Adelson? Yep. Potentially Wendy Adelson? She's the one who said she hated him. She's the one fighting with him in court.
Her parents hate
Donna
him.
Adelson? Nothing. Not a single piece of evidence. You have to find her not guilty because they have failed to do their job on all 3 counts. They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it. Please take this case seriously. Please go back and review the evidence. Please discuss what's been presented. Don't get talked into something that you don't agree with. The verdict has to be unanimous. If you don't reach an agreement, if you can't be unanimous, there's another procedure we go through. But please don't buy into what the state is about to do, telling me how wrong I am or telling you how wrong I am about everything and how they have this mountain of evidence, because they admitted it. Agent Sanford admitted it. There is no direct evidence linking Donna to anything. And all this circumstantial evidence isn't really circumstantial evidence. It's argument about what it could mean, what it possibly mean. Could it have been? That's not beyond a reasonable doubt. Thank you.
Ms. Fulford,
I think they're going to
give you a rebuttal.
Oh, they're not going to take a break. Right to rebuttal. Okay. As the state is getting up for rebuttal, we will continue to debate whether the defense addressed the script or didn't address the script. She talked about the writing. She kind of argued it, but she didn't say script. She kind of sidestepped it. The defense brought up some connections and some points that might help if there are jurors that are like, hey, yeah, I'm real curious about that. Made some connections where I'm like, that's That's a good point. But she yelled at the jury for quite a long time in a way that I don't know if it will be helpful to the defense. But there were points where she said, look, the defense wants this inference. But what about this inference? Which leads to doubt. I appreciate that the defense did go through the jury instructions and say this jury instruction and that jury instruction, but I worry that because she was yelling and just banging the lectern for the first half of her closing, that those points will be lost. And the end of her closing was, this happened in 2014. If they had any evidence, why are we here now? Why didn't they do this sooner? Why did it take them 2 years? Why are they still investigating? And at the end, she said to the jury, don't buy into the state getting up here telling me I'm wrong. The only thing you can do is go back and find the defendant not guilty. She definitely ceded to some of the jurors, don't let anyone talk you out of it. Don't let anyone talk you out of this. So now the state gets to rebut it, and away we go to the rebuttal. It looks like they're going to set up some of their closing. I think there's I'm not sure the stuff about what Charlie told Donna and when is in evidence, but we'll see if the prosecution brings that up or not. I'm curious to see what she says. I mean, the defense alluded to the script is what a lot of you are saying. She threw Wendy under the bus more than I thought she would. So there was that. I don't like the way that the defense went after Rob. And rebuttal.
Well, y'all tired of hearing lawyers talk yet?
Yeah.
Down for another hour or two? Kidding. I think I've got 7 minutes. He hasn't started the timer yet.
Okay, counsel, that was defense's joke. Defense said, no, we're going to play the rest of this for this and then. The defense already made that joke.
It does not matter what Miss Fulford thinks, if she's right, if she's wrong, if I'm right, if I'm wrong, what the lawyers say is not
It matters
evidence.
what you think.
You have the evidence before you. They say it means one thing, I say it means something else, only you guys decide, right? I think outside your house means outside your house, but apparently outside your house means something else. I think a very contentious divorce means a very contentious divorce. They think it means an amicable divorce. You guys decide, right? Look at the evidence and you guys decide.
Fair.
Is everything not what it seems and actually something else? You guys decide. A TV repair appointment is not an alibi because she could have changed it to earlier, but she didn't change it to earlier. That's where she was when he was getting killed. That's an alibi. This TV, that doesn't mean, that's not code, that's a hint. A hint for what? It's code.
It's a hint that he wasn't picking up on.
What does it involve? The two of us. Oh, well, that actually means it doesn't involve the two of us because we're being extorted, we're victims, it doesn't involve us. So what does it involve? The two of us actually means it does not involve the two of us. That's what we've heard. A one-way non-extradition ticket to Vietnam? It's not fleeing. It's a setup. How did I set her up? I didn't make her do that. I didn't get her a fast-track visa. I didn't get her a one-way ticket. She did that. She made those choices.
She made those calls.
Wendy didn't bother to tell her mom she was ready to give up on the relocation. Yes, she did. Look in the emails. She was giving up, and Donna wasn't having it. That's when she gets the totally unhinged email from her mother suggesting, You're not going to give up. Well, you want to move on with a sense of peace?
After all we've done for
Hell
you.
no, we're going to fight this guy. We're going to dress your kids up as Nazis. That's what happened when when Wendy suggested giving up. Never, never, never give up, right?
Oh, they must have been writing this while the defense was doing their
Murder charge is not
closing.
based on the fact.
The prosecution just put up a slide that somebody was typing while the defense was doing their closing, which is really quite impressive and speedy. Outside your house does not mean outside your house. A very contentious divorce does not mean a very contentious divorce. TV repair is not an alibi. This TV is not code. What does it involve? Answer the two of us. Doesn't mean it involves the two of us. So that's a slide that's on the screen. Let's keep going.
This murder charge is not based on the fact that she said some bad words. I mean, I'd be facing murder just in this courtroom.
Same.
Obviously, people. That is not what this case is about. You've got to look at all the evidence. I mean, it is death by 1,000 cuts. It is powdered sugar.
Not a great analogy.
You've got to look at the whole thing and make a decision. And I'm sorry that
Puzzle
there's not a
pieces.
smoking gun, but she was too smart for that. She thought about it. She planned it. She made sure we could never get her, right?
She made sure she was out of the loop.
She took precautions, but she did make mistakes. And that's what all those exhibits are. Mistakes. My spin and the spin I'm putting on all the evidence, that's not, it doesn't matter what my spin is. It's your spin. You look at the evidence, you decide. I tell you what I think it shows. They tell you what they think it shows. Come over to the other side. And what do they think it shows? They don't have to prove anything. I have to prove the case. Yes. But what are they saying? Circles. Wendy. Oh no.
The prosecution put up another slide showing what their argument is vis-a-vis what the defense's argument is.
Charlie, definitely. Wendy, maybe. Not Donna. But also, not Charlie. We were getting extorted. Not Charlie. I mean, you can't have it both ways, right? It's like hard to get your head around it, but we can't be getting extorted by the killers who killed Dan Markel on their own. And also, Charlie's pretty guilty and Wendy looks a little guilty too. It's got it like, there's no lane that's been picked.
They all go together.
And they don't have to prove anything, but they're throwing all that out, right? And it's like, you were getting extorted, or Charlie and Wendy did it behind your back and they don't tell mom what they're doing. Can't charge Donna because Charlie already went down for this. No, that's not true. Everyone that's responsible for this murder should be held accountable for their role, not just Charlie,
Like
not
Wendy
just
said.
the two killers that came here and shot him. Everyone that played a part in it should be held accountable. They said some things in their closing that doesn't comport with my recollection of the evidence. For example, Corbett said that the defendant did not send the Evite. My recollection is the complete opposite. You guys took notes, you have remembrances, you guys rely on your own memory. I don't want to go through every single thing, but there were a few of those.
Yeah, that's not what I remembered either.
The only complaint from a 3- and 4-year-old was, Grandma says you're stupid. Oh, that's dumb. Well, no, I remember that the kid also said, Grandma hates you.
I recall that.
Rob has an axe to grind.
Well, we know
Mary
what
Hull
Georgia
said
thinks
that the
about that.
Adelson Institute was Charlie's until 2022. Not my recollection, but hopefully you remember that it changed hands in 2015. No SunPass records. Do you need SunPass records to know that Donna Adelson was outside Charlie's house on the night of the murder? We didn't know that. Catherine Magbanoa told us when I got to Charlie's, he told me his parents had just come, right? And brought the money. But when we looked in the records,
There's a text.
There's a text outside your house corroborating what she said. That's important. She was outside his house. Oh, well, she had the garage code. Why didn't she go in? I don't know if she went in. Maybe she did. She told him, I'm outside your house. He said 10 minutes. He's going to be there in 10 minutes. Maybe she did go in. I don't know.
Nobody knows.
But she was there.
Nobody was there.
That I do know.
Except for her and Charlie.
I don't know why she's denying that. Grandma motion. We disagree with what the words say. I mean, I don't know what to tell you. I say the words say, I don't want the kids around grandma because she's disparaging me. Somebody needs to be there to monitor. They say, no, that's not what it means. It means something else. Charlie's extortion story. She wrote the checks because she had to save her son's life. Well, right. So if that's the case, we're picking lane 2 here, down below. And that's where all that evidence comes up about that pushes back on that. Like, that couldn't happen. They're not going to be spitballing the drug dealer defense
if they were being extorted.
After they've been extorted. Like, that didn't happen. That was a lie, right? That Charlie came up with in his testimony, and that she
helped him
then
with.
Kind of got stuck with after saying all the truth is out, truth is out, truth is out. Plus, she's got to come up with something for writing those checks. She paid for the murder.
I bet counsel's out of time. The court said, please approach. I imagine the prosecution's going to say, can I have just a little bit more time? Please, a little bit more time. So the court said, please approach. I imagine we're getting to the end of the prosecution's time for rebuttal. She had said, can it be a flexible 7 minutes? And the court said, you can ask me for more time. I don't know if she did. She's probably going to say, Your Honor, 5 more minutes, which has been quite the experience of this trial. I'm going to zoom. We are almost in real time, so there's... Judge is looking at his watch. Counsel? TikTok. It is like 4:15 local time. We're just a few minutes behind real time. It is 4:20 real time, local time. It's getting late in the day, counsel.
Let's continue.
I imagine the court gave her 5 more minutes.
Sanford said he never made a mistake. Not my recollection. What's the pushback on extortion? Her behavior on the wire. She doesn't say, oh my gosh, it's happening again. She doesn't say anything about the prior extortion. If the prior extortion had occurred, she would immediately tell him it's happening again, or some reference to the fact that this is something that's been ongoing. She doesn't do that. Instead, she talks in code. It's a TV. What the heck? Why are you talking in code? Her Googling extortion versus blackmail 7 days before Charlie's trial. That wouldn't happen if the extortion was real. She wasn't extorted. Charlie didn't tell her there was an extortion because there never was an extortion. She was paying for a murder. She knew it was going to be a murder. She's the one that wanted it done. Her discussion of Charlie's lawyers meeting with Garcia's lawyers. What? If she was being extorted by Garcia and Charlie was being extorted and his life being threatened by Garcia, their lawyers aren't going to be meeting up. Look at those text messages. She said, bring cash. They say, oh, that's not code. She said, bring cash. She literally said, bring cash for dinner on that call.
Yeah.
It's not a hint. It's a code word. They say the bump failed. I say the bump succeeded. She said it involved the 2 of us. That was before we got made.
You know what I'm
before
talking
that
about.
Matt Surrey operation where they literally see the camera in the bag and know the camera's in the bag. Yeah, she called and put on a great show when she called the undercover. But what did she say in the first call, the second call, and the third call before we got made, before she knew it was law enforcement? She said it involves the 2 of us, both of us. To these, okay, I want to hit one more thing. Don't call time on me. 2 years after the murder, we've got 2 emails,
Your Honor, please.
64T and 64I.
Let me go.
The defense told you in opening that this defendant cares about others more than she cares about herself. The problem is that she decides what other people need, what's necessary for other people in their lives, and she is willing to justify whatever ends she thinks are needed, right? Any means to get to those ends are justified in her mind. The problem is she doesn't care about the collateral damage to get to her ends. The evidence has shown that this defendant, I think, did believe that Wendy and those boys were better off in South Florida. She thought that's what they needed. They would be better off with her, and she was angry that that couldn't happen. Dan Markel was the thing standing in the way. What was the cost of that to not only Dan Markel, but to those little boys? Those little boys lost their father. Look what she says in 64T. Children are 2 and 3. Children do not even have a memory of life before age 5 or 6. Look what she says in 64II when Wendy is concerned. This is 2 years after the murder. Her child is having trouble at school, crying because he misses his father. And this woman, this nice grandmother, innocent woman, says, quote, "I still do not believe that Ben is sad about his father." Quotations on the sad. 64II. "I still do not believe that Ben is sad about his father. I spend a minimum of 25 hours a week with him, and oftentimes more than that, including weekend times and sleepover days, and have never experienced a time when he was sad. I think it's just another phase of the many, many phases that kids go through. The problem is they have a highly intelligent and sensitive mom." She doesn't believe that this kid is sad because she can't take accountability for her own actions and the catastrophic consequences that this had on everyone's life in her family. Not just her son, not just her daughter, not just Rob, not just Dan Markel, but those boys who lost their father. It wasn't better for them to be in South Florida. It was better for them to have their father. You must not base your verdict on the feelings of sympathy, prejudice, bias. Your verdict must be based on the evidence and the law. Yes, she's a grandmother. Most murderers don't look like that. But the evidence has revealed what she is. Please don't let her appearance influence your verdict in any way. It involves the two of us. What about the script? They didn't even talk about the script. She wrote a script.
All
for a
right,
witness.
counsel agrees. Counsel agrees they didn't talk about the script. We're going with counsel.
It was perjured testimony based on a lie, an extortion lie that's been proven in court to you to be false. This defendant tried to erase Dan Markel, thinking there would be no harm to those little boys. They don't have a memory of their father. They feel the absence of their father. This defendant decided they didn't need their dad. She doesn't get to decide that. She wanted it done. She brought the money. She stroked the check. She didn't have to do that. Charlie was a signatory, had signing power on that account. He could have written the checks. She wrote the checks. Why? Because she was neck deep in this thing. She wrote the checks. She said it involved the two of us. She wrote that script. May you have the strength and the common sense to see this evidence for what it is. It's only one thing. There's only one truth. It can't all be right. It's only one truth. Render a verdict that does justice. Find her guilty. Thank you.
And that's
In just
the
a few
end.
moments, you'll be taken to the jury room.
That's the end of the prosecution's rebuttal. The court is going to read the final instructions and the jury will be sent out to deliberate. The rebuttal was fast. You could tell that time was getting to this prosecutor, but you can also tell she wants to make sure that the jury gets it because it is so much. And she was trying to say, it's this and it's this and it's this. It is the puzzle pieces. And it's a lot of them. And the jury has to put that together. And so at the end, she said, look, there is only one truth. It can't be all of it. Do justice in this case. Find her guilty. And so the prosecution was, well, I think running up against time hurdles and a very long day because we are just a few minutes behind real time. It's almost 4:30 local time. It's been a very long day. It was a very quick trial. And you could tell that the prosecutor wants to make sure that the jury gets it. You can tell from the defense that the defense was saying, look, nothing points to my client. And I think the prosecutor really wanted to make sure that the jury knew what all those puzzle pieces were, including those emails that she didn't bring up in her closing. She brought them up in rebuttal, the emails that said, kids don't even have a concept of missing someone. I thought we would see that argument from the prosecution, and we did. Kids don't even have a concept. Donna thinks it's better for them. Donna thinks she knows what's right for other people. Donna thinks they won't remember. She doesn't think the kids miss their father. And we saw that argument play into the rebuttal, and the court's going to start with those final arguments and send the jury out to deliberate.
By the bailiff. The first thing you should do is to choose a foreperson who will preside
I feel like I've run a
over your
race
deliberations.
listening to these attorneys zoom.
The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room.
Put them in the basket.
Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations.
We'll have the evidence.
Photographic, disc, jump drives, reports, and document exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Before the deliberations begin still afternoon. We are going to discharge at this point the alternate jurors. If the clerk could please read out the names of the alternates.
Oh, not the names. Oh, good. They muted it. Okay. The court mic muted it. So they're going to read the names of the alternates. The court's going to thank and excuse them. Being an alternate would be the worst.
No, I will have my assistant contact you with that information. We thank you for your service. You are excused at this time. Members of the jury, you may follow Ms. Tolbert and Ms. Vance.
He is saying the names of, it might have been of jurors. I don't know. I thought it was of the bailiffs, but I'm surprised that the court dismissed the alternates before they started deliberating. Lots of courts hold on to the alternates just in case something happens during deliberation. So it's interesting to me that they did not do that. Also heartbreaking to be an alternate. You sit there and you're just like, okay, we're going to deliberate. We're going to go talk about it. Nope. You're not. The worst. All right.
Instructions and your notepads with you.
Pool camera's done a great job of being mindful of what might be names.
One moment before you go back in. The transcripts of the recorded call, these are to remain out here. Please leave those in your seats.
So transcripts on the call stay on the
Only
seats,
jury
phones stay on the
instructions
seats.
and your notes.
I think courts should just have like little Faraday cages to lock the phones in. But that's because it would cause me great anxiety to leave my phone on a chair in a public courtroom in a high-profile case. I'd be like, can I just lock it in a Faraday bag or something? Like the ones you get at comedy shows or whatever? Just. Are they going to take their Apple Watches too? Because you can communicate on that thing. But my preference, I don't get to decide that. It's also expensive.
If you can check.
A lot of the courts I worked in, they were like, here is a basket. Just put them in the basket. Put them in the basket.
On the radio to see if there's another jury room possibly that they can be taken to temporarily while the headphones and the audio equipment is moved.
Okay. Judge, we learned that the headphones can just be unplugged, and there's stuff already set up back there for them to plug them in, so we don't have to do anything.
Oh!
Well, that makes that perfect then.
It's already done.
Everyone can be seated. If the parties can review the items that will go back into the jury room.
Jury's
with the
out.
Jurors.
To deliberate.
The instructions that were read aloud with a copy of the verdict form. You can inspect that as well before it goes back. I will hand that to the clerk at this point. Instruction 4.2, instruction upon discharge, that will just remain out here as the case is not yet concluded.
Oh, all of you are like, Emily, why do they say charge the bailiff? You swear the bailiff to take charge of the jury. So you give the bailiff their charge to take care of the jury. So that.
Also, please leave your phone numbers with the clerk so that way if there is a question or a verdict, everyone can quickly assemble.
Stay close.
Unless there are any other matters to address for the court, we will be in recess at this point.
How long are you letting them deliberate for tonight, Your Honor? Can you just... I have to go to the bathroom.
I'm aware.
That was a long day. I wouldn't be surprised if the jurors took a break for the night and came back tomorrow. I really wouldn't. But I will ask...
Check for pages 8 and 9.
How long the... I will poll how long the verdict will be out. I'm going to poll by hours.
Else, you may step out.
Ah, that was me. I'm going to poll by hours because I don't know when they will break tonight. So I'll put up the poll by the number of hours. I jumped back in time when I went to pause. The court says for everybody else,
that as well. Before
you can
it
go.
goes back, I will hand that to the clerk at this point. Instruction 4.2. Instruction upon discharge, that will just remain out here as the case is not yet concluded.
Donna will stay in the courthouse until they retire for the evening.
Also, please leave your
There's a
phone
lockup in the
numbers with
courthouse.
clerk, so that way
She will
if
be
there is
there.
a question or a verdict, everyone can quickly assemble.
The jurors are starting to deliberate.
Unless there are any other matters to address for the court, we will be in recess at this point.
So the jurors went out just before 4:30 local time. This court's been running past 5:30 on their full days. Florida will let their jurors deliberate pretty late if the jurors want to stay. They don't have some of the restrictions that other jurisdictions might have. So they'll let the jury
Verdict
stay and
form is
deliberate.
in there. Check for pages 8 and 9.
So, but I'll ask.
For everyone else, you may step outside the courtroom or you may remain at this point. We will be waiting for the jurors.
We're going to be waiting for the jurors. So the jurors can ask questions. The jurors can review the evidence, but the jury has started to deliberate. All right. The one thing that doesn't happen with paper is it doesn't run out of battery. So let me plug my notebook in. I have taken quite a lot of notes today. I will be reviewing those. I'm going to just give a quick summary. I am going to put up a poll in a minute, but I have got to use the restroom. So I will probably take just a brief break and come back and answer questions. I am going to stay on stream for a bit. We will see if we hear any word from the jury. Let me just take a moment to remind you, if you are new to the Law Nerds or to watching trials with me, or you just are like, I have stuff to do. I can't just stay glued to the YouTubes. Law Nerd app at lawnerdapp.com. We built it for you so that we can keep you in the loop. If I stop streaming, I will let you know that I'm going to resume streaming. If I am still streaming and we hear from the jury, which has happened, then I will also let you know. So I will keep you posted either way. I'm going to put up a poll in just a few minutes. I'm going to run to the restroom before that, but let's give a little bit of a summary. Look, court is, I might put it was so much easier with the fan. Emily, you missed the fan. I mean, yeah, I love this judge, but with the fan, you could tell it was still running because at least the fan was moving. The seal is lovely, but sometimes you're like, wait, are we game on or no? So we are in real time and the jury is out deliberating. That was a very full day of closing arguments. We saw some of the arguments from counsel that we thought we would see, and some arguments that surprised me. Some connections that the attorneys made that I hadn't thought about, but I'm not surprised. The attorneys have been with this information longer than we have, especially when it comes to the prosecution. Time was a little bit of a factor for the prosecution. It didn't feel like the defense felt rushed in their closing. I didn't feel like they were rushing, especially as they decided to play the full extent of some of the exhibits. I felt like the defense was taking their time in their closing, where at the end, the prosecution was like, and then there's this, and then there's this, and then there's this. And it felt like they were zooming. In Florida, the courts often let the jurors continue to deliberate if they want to, but if you are feeling kind of drained and tired from today and like the whirlwind of the last couple days, I imagine that the jury is too. This is a case that has lasted, with jury instruction, 3 weeks. It started 2 Fridays ago with evidence and opening statements. I wouldn't be surprised if the jury took the night to think about it, especially considering that they are getting this case at the end of the day. I wouldn't read anything to that or into that. I wouldn't say, well, if they take the day, it's because they're doing this or doing that. I think given the late hour, it would not surprise me at all. It would actually surprise me more if they didn't take time to sleep on it, get some rest, and then come back in the morning. But we'll see. They might be like, done, let's go. But at the end of what? Day 9 of trial, the jury is deliberating. So it seems that, Charlie's verdict came back in about 3 hours. I mean, it's 4:30. Coming back at 7:30. I mean, could they do that? Sure. Do they want to? I don't know. I would imagine they're tired, but could they come back that quick? They could. But if they want to go through the emails, if they want to go through any of the calls, they could take a break and come back and do that tomorrow. Either way, I will keep you posted. I'm going to take a quick break and go to the restroom and then come back and answer questions and chat with y'all. Y'all have lots of questions. I've got them saved. So I'm going to come back and answer questions. If you're like, I've got to get a few things done before verdict, don't worry. I will ping you in the Law Nerd app. When the jury goes home, I'll tell you that the jury's out for the day so that you can be like, whew, we're done for the day. No more jury watch for the day. And I will keep you in the loop about what we're doing tomorrow and going from there. The defense had, 11 witnesses? There's a lot of a case for them to go through. And the defendant didn't testify. In Charlie's case, he did testify. I haven't watched it. But when someone testifies, the jury sometimes gets a sense of that defendant, like an Alec Murdaugh. And the case often becomes about, do we believe them or not? Do we believe the defendant that testified, or do we not? And it really narrows down the deliberations. The defendant didn't testify in this case. I think that was legally a smart choice, but that means there's a lot of evidence that the jury might want to go through, because they're not just deciding, do we believe what they said on the stand, which makes it kind of easier. So I will put up a poll after I take a break. You guys, I'm going to run to the restroom. I didn't even eat lunch. It's still sitting here. We'll answer questions and we'll go from there. So, law nerds, hang out. I will put up a poll on how long the jury will be out when I get back, but I have to run to the restroom. I appreciate you. We're going to take a short break. We'll be back to answer questions and chat while we are on Verdict Watch. So we are on Verdict Watch. We have a Verdict Watch bumper, but I forgot to put it in the new software. Sorry, law nerds. We'll run it tomorrow, I promise. Dun dun. We're on Verdict Watch. But we're taking a quick break. I'm just going to put up live stream break because court is out. Elena, thank you for posting that we're on Verdict Watch. Don't forget to get the Law Nerd app if you need to step away. I'll be right back to chat with y'all after a short break. Thank you, Law Nerds. You're the best. All right, chat. We're back to do some Q&A. We're on jury watch. It's getting near 5 o'clock local time. I've got the court up, but you know what? Let me see if I can pull up. I had not tried to do this, but let me see if I can pull up a small picture-in-picture in a little bit. But I've got the court feed up. It's just the seal. I mean, we don't have the spinning fan. I'll work on that for tomorrow, I think, because I don't know about you, but my brain is tired. Are y'all tired? I'm tired. I love closing arguments, but there was a lot of energy coming at us in those closing arguments. Like a lot. I'm going to go through my notes at some point, and I will probably summarize or coalesce more of my thoughts on closing arguments. But there were the defense attorney like yelling at me was a lot. I mean, not me, but all of us. Like the defense attorney just like hollering at everybody was a lot. But then there were times where the prosecution was like, I mean, come on. It was like we need a little more than And I think the prosecution has more than But if there are jurors that are like, look, what proves that what Donna wanted was for a murder to take place? I think the prosecution could walk the jury through that, but it's still a circumstantial case. And Donna's behavior, afterwards really does go to what Donna knew before. Because Donna was bringing the cash over to the house, but if jurors don't believe that the cash came over to the house, which is why the defense was saying Catherine McBanawal wouldn't know the truth from, I don't know, whatever analogy you want to insert there. Just Catherine McBanawal wouldn't know the truth if it walked up and pinched her. Then do you believe that Donna brought the money over to Charlie's house? Because the defense said Charlie's got this big old safe full of cash. He just pulled it all out. So let's go ahead and put up a poll about how long the jury will deliberate. For those of you new to watching trials with me, A, welcome. B, I do not poll on the ultimate jury decision, but I will poll on how long we think the jury will be out. How long? Not how's, Emily. How long? Let's see. How long will the jury deliberate? So, let's see. 3 hours or less. 6. Let's see. I can't type and talk and think apparently today. And let's see. The last one, 16 or more. All right. How long will the jury be out? I put 3 hours or less, 6 hours or less, 12 hours or less. So like 6 to 12, 16 or more. So let's see what we think. Because I can't really say, will they be back tonight? I don't know how long they're going to give them tonight. So we will see. Jojo said, why do I have the image of law nerds with binoculars during verdict watch? They're just like, oh, verdict, where are you? It's so much easier when you're in the courthouse for verdict watch, because then you just like, what's going on in court and but when your view is seal, it's much harder to know. You don't have as much of a sense of what's happening in court. So I understand the disconnected feelings. Ashley said, what in the world does the defense have to talk about for 2 hours? They played a lot of video and said, that doesn't connect Donna. Donna doesn't know. Donna doesn't know. For 2 hours, Donna doesn't know. Though at other times in the defense's case, I felt like they were filibustering. playing the videos in their entirety, I think was important to the defense. It didn't feel like they were stretching for time. I felt like I was being screamed at, but it didn't feel like they were stretching for time the way it has in other parts of this case. I think they used, at the end, I was like, please stop yelling at me. But it feels like they used their time, made the points they wanted to make. I didn't agree with all of their points, but made the points they wanted to make. Rob has an axe to grind is strange. I completely agree with them going after the jailhouse informants and the flight. I think that is some of the most damaging evidence to Donna, especially when taken with everything else. But going after Rob having an axe to grind, I don't know if his testimony felt different in court, but his testimony felt incredibly reluctant and sad. Rob's testimony to me felt heavy and sad that this is where we are. And when she's like the things he's alleged to have said to his mom, I believed Rob's testimony. So we will see. But the defense being like, yeah, Charlie did the things. Wendy might have done the things. But Donna didn't know. The meddler, not a murderer. I'll be interested to see how that lands with everybody. She's a meddler, not a murderer was an interesting alliteration. And then she hearkened back to, the prosecution wanted to get the matriarch murderer or whatever, which is, I think, what other channels have named this case. And I think the defense is probably just watching that. But counsel, we don't give cute names to cases. It's Florida versus Donna, but that's what they're trying to say, right? The prosecution had to get the matriarch murderer. I think the prosecution is just like, every domino in this train is going to fall. Every single one. And we're going to keep going up the line of train cars. Nobody talked about the fact that Donna called her jail daughter her sunshine, did they? M. McAttack asked, are Dan Markel's parents in the kids' lives? From my understanding, the Adelson family has completely isolated the Markel family. The Markel family sued in Florida about it. New laws were written in Florida about it. But no, it seems to me that the entirety of the Markel family has been estranged from the kids. And depending on what was going on in that, it might be very difficult for the kids to bridge that gap on their own after everything that's happened. It makes me incredibly sad. The core of this case is awful. Wendy changed their last name. She changed one of the son's middle names. I have to wonder if that's because the middle name was either a family name or was Dan or Daniel. But it's incredibly sad. And the lives that have been devastated by this case are innumerable. And it just... There was court process that was ongoing and that could have kept on going. And that changed. But I don't believe for 1 second that Garcia Rivera and Katie McBanawal were like, you know what we should do? Y'all go up to Tallahassee. Find this guy. Here's his car. Here's where he lives. Here's when he travels. Here's where he goes to the gym. Go find this guy. And then kill him and then go to his in-laws and try to get money for it. Miss me. Megan in the chat said, if Wendy was at brunch, this was in, I don't know why it's not pulling up. This was in Super Chat much earlier today. If Wendy was at brunch when the murder occurred, then what's with the TV repair? She wasn't at lunch yet. The TV repair happened. Then she drove to go buy alcohol for a party. That was the bullet. She went and drove to pick up the bullet and then drove back to the other side of town to go to lunch. And that's when law enforcement saw her. So she had her whole day accounted for, except she drove by the house, didn't she? She wasn't super concerned when she drove by the house. But Mary Smith said, I wonder if the judge would be interested in ceramic keycaps. Imagine what it would sound like in the courtroom. It would be great. It would be great. Ashley said, if their closing arguments become she didn't intend for Charlie to have him killed, I will fall off my couch. It got to Donna didn't know. Charlie knew. And I think the prosecution made a good point saying Charlie gave a shit about go-karts and girls. Charlie wasn't this invested in his sister's divorce. His mom kept him invested. His mom kept giving him the updates. His mom is on the emails. His mom is in the, this is point 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And his mom was invested, not him. He wanted to date anyone under the age of 25, like he's Leonardo DiCaprio, and become a professional go-karter. And apparently never treat patients ever because the man is on the phone. Y'all know, Emily, this is going to get real personal. Yeah, real quick. Y'all know how I feel about the phone in my house. I can't get Dr. B on the phone, on a text, on an Apple Watch. And he's like, I didn't have my phone on me. Dr. B, the internet's out here. I didn't know I was in the yard. What? When Dr. B was at his dental practice, there was no getting Dr. B on the phone. It was passing notes. If something was urgent, his front desk would walk into the operatory with like a Post-it note with a little note on it. Say, Dr. B. And then he would say, this, that. And then she would come back and say, he said this, that. There was no talking to this man during his work day. As a dentist, he had his hands in people's mouths. There was no conversations at all. Dr. B, are you running late? No. So it's bananas to me, just based on my own life and knowing dentists. It's bananas to me how much this man was on the phone. Constantly on the phone. Oh, just constantly on the phone. I'm like, Charlie, what are you doing? Rachel said we should start to buy this judge a drink fund. Rachel, I love the sentiment. I love the heart behind the sentiment. Judges cannot receive gifts from the community unless they are in an election cycle and they get campaign donations. But judges cannot take gifts from the community. We can send him vibes. Vibes, Your Honor, vibes. We can send him vibes. All of the vibes. Rune Munch said, I think she knows it's all or nothing for her. If she gets convicted, she will be there until she's no longer with us. Yeah, she will be. So Donna is definitely, I think, worried. And you saw a bit of a change of expression from her. A lot of you are asking about Wendy. We'll have to talk about Wendy another day, but I don't know what the prosecution wants to do. They have taken a lot of time with all of this and have gone strategically through this case. Charlie wasn't arrested until they clarified the audio where Charlie's like, if they had anything against us, we'd be on a plane. They waited and waited and waited. So will they choose to go after anyone else, or is this the end? I don't know what they will do, but we definitely saw a lot of what Wendy was up to. Olivia said, can we talk about what an excellent judge he is? Yes, we can. We can talk about what an excellent judge he is. He's great. This judge was very even keel. Just very even keel. And even when frustrated, he still went by the law. Even when you knew he was frustrated, he's like, the law allows for this. The law doesn't allow for this. And I think he protected the record. I think he was patient. And I think yesterday he was kind of done with 5 more minutes. 5 more minutes. It's like this. I need this judge on my like snooze. The time is now, Miss Baker. You must get up. No more snooze. Up. Out. Every day. Get up. Kel said, I wonder if they think that life is the only option. The jury might not be comfortable with finding her guilty. The defense talked about life quite a bit, quite consistently. and just a lot. Michelle said, I'm a little behind. Thank you for narrating the silence. I'm audio only. No worries, Michelle. A lot of people listen audio only, so I try to explain what's going on just in case it's a moment to like take a peek at what's going on or to timestamp it and come back later. Chuckles Quad said 3 years of trials, and this was one of the clearest, easiest to follow prosecutions. It was. They've had a lot of time to think about it. Kelly asked in the chat earlier in the day, isn't not guilty usually the first option? Not in most jurisdictions. So the defense asked for that, and the state didn't say anything about it. And the court's like, no, they have the burden. Guilty is the first option on the verdict form. If a jury wants to find somebody not guilty, they're going to find somebody not guilty. If they want to find somebody guilty, they're going to find somebody guilty. It's the lesser includeds that get real confusing. But those were removed today. So Mandy said, question, I heard wearing red in court was a no-no. Is that a thing? Not that I know of. I would imagine that defense attorneys don't always want to wear red if red is associated potentially with guilt in some way, but I think it has to do with the attorney's own vibes. You're going to be shocked to know this, chat. I wear black. Sometimes black with navy, sometimes black with purple, sometimes black with blue and black. I wear black. Did I wear white ever? No, it's going to get dirty. Or black. I think I had one pair of herringbone pants. They had a big old cuff on them, and they were still like charcoal. Big old cuff. Then my heel got stuck in the cuff, and I never wore those pants again. So I had a fantastic pair of like turquoise heels that I loved. So I definitely had some colorful shoes. Everything else was black. The suits were black. But trying to find suits that were the same black was difficult. So I had many different suits, but trying to find suits that were the same type of black, it was like, shit, this jacket doesn't go with those pants. Damn it. I had one pink jacket, like bright pink, and one like black and white plaid jacket. That was it. Black. Just all black. Everything. It's shocking to no one. Giselle said, EDB, I appreciate your breakdowns. This case is a circus of bizarre behavior. I don't disagree. And the jury can say, you know what? The consciousness of guilt here is screaming, right? So they can decide. And they've got all of the information to go through. So, all right. Who said I just went to the movies and you're still live? Yeah. It has been 7.5 hours. It was a long day of closing. Gen Xer Meg said, Lamau, that's me, 47 shades of black. I'm near 50. I mean, same. And we have the same color wardrobe since teens. Yeah. Yep. I did have a very, very like brown black pair of Docks in high school. Those weren't black. Purple in the hair. It is definitely grown out. The hair could use a trim. The hair could use a zhuzh. Griffin takes offense to my gray racing stripes. I love them. He's like, Mom. And I'm like, dude, I love the silver. I'm here for it. But yes, we definitely need a little bit more purple in the hair. I'm going to, maybe this weekend. Darkling, I listened, said, it was not a phase. It was never a phase. Never a phase. Did you ever wear Dave Matthews shirts under the jackets? Not in court. I don't even think in the office. I don't think there was ever a band shirt that came to the courthouse with me unless I was working on the weekend. But no, I don't think there was ever a band shirt in court. Though there were definitely days where I was like, I am not in court clothes. And then they're like, Ms. Baker, we need you in department. Shit. Not planning for court today. So there was always like a spare. I mean, I think every attorney that works in a courthouse has a spare like outfit hanging in their office and like a spare jacket. You have like backup court clothes just in case You never know. Or you might spill something. Ronald, thank you for the 5 gifted memberships, and everyone who gifted memberships. Thank you. Jenny Marie said, verdict watchable at the dentist office. The irony is not lost on me. Hopefully your dentist is not running in and out on the phone. I'm sure they are not, and I'm sure they are lovely. So let's see. Introverted Draft said, rumor was Donna was wanting to change her mind on testifying. Would that be allowed? They didn't put anything on the record today. The defense didn't push for it. Evidence had closed. It would have created a difficult issue, but they hadn't really gone beyond evidence was closed. Could they theoretically reopen evidence today before they got to closing? They could have. After this, they can't. Obviously, the jury's deliberating. But the defense could have asked. I think it would have created a massive appellate issue if the defense had asked and then the court had said, no, that time has passed. But he had already taken the waiver. She had already said no. I'm sure she will rethink that decision for quite a while. I do think it was the right decision. I don't think Donna could have explained some things. And I think allowing her defense to say, the prosecution is all just smoke and mirrors in theory. Look, Donna doesn't know. Donna doesn't know. Donna doesn't know. Donna doesn't know. Charlie. Yeah. It was surprising to me, though, that the defense was leaning into Donna just can't stop running her mouth like she's a talker. That Donna, she's a meddler. Because on those phone calls, Donna's the one that's like, you can hear Donna thinking, Charlie, shut the fuck up and get off the phone. Like you can, it seeps through all of the calls. Charlie, shut the fuck up and get off the phone. But Donna's not the one running it like that. Charlie is just like, and he's like, and one more thing, and one more thing, and let me tell you one thing, and let me tell you another thing, and let me tell you another thing. And Donna's like, can we talk in person? Can we please talk in person, Charlie? Can we talk in person? Can we talk in person, please? Charlie was not picking up what she was putting down. Inri. Celia versus Alessi. I'm a little behind. I know some Florida courts allow juries to run into the evening. Did we get an indication if court will shut them down at 5:30? We did not. I imagine this judge is going to be like, take your time. So Daniel said vibes, not vibes. Vibes. The defense was wearing out those air quotes during closing, though, wasn't she? Megamia said, I wonder if Wendy was supposed to drive by his house to actually be the one to find Dan, since they had talks about trying to meet up. And when she went and turned down the street, the police were already there. I don't know. It's an interesting thought. But she turned around right quick, didn't she? She was just like, whoop, and out. But she didn't seem to freak out about it. Would you have freaked out? I would have freaked out. But again, the jury gets to say, look, we can use common sense. If anyone's had a life experience where they're worried something's wrong, or they see like lights and sirens on the street of someone that they love, they're going to be like, what the fuck is happening? Tell me everyone's okay. Maybe it's just me. But yeah, they had been texting all day. She doesn't text him. Your street's shut down. Are we still meeting? Everything okay? Radio silence. And the prosecution made a good point today that I didn't even think about. Because they made the timeline more succinct. But the prosecution talked about the fact that Wendy and Dan are going back and forth about who's picking up the kids and this, that, and blah, 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 blah. And then Wendy and Charlie talk for 18 minutes about the TV repair or whatever. They talk for 18 minutes. I mean, yeah, they can't fix the TV. I'm just going to get another one. No, they talk for 18 minutes. And then all of a sudden she's like, yeah, fine, whatever, with the kids. Okay. Terry says, I think the outcome of Donna's trial will determine if they charge Wendy or not. It may. I don't know if the prosecution will ever talk to us about it because murder doesn't have a statute of limitations. So if Donna is convicted, if Donna is sentenced, I am not anticipating that, tomorrow they're going to charge Wendy. We'll see. I wasn't expecting they were going to charge Donna, but when they arrested her at the airport, I was like, okay, this isn't done. They went and arrested Charlie's mom. Shit, Mom, what did you do? I'm curious. Tell me everything. But I wouldn't expect Wendy gets arrested over the weekend. I am not anticipating that at all. We'll see what they do. So Steve said that towards the Dr. B mug replacement fund. Thank you. Again, not Dr. B's fault, but I'm still just like, my stuff. Who else is a don't touch my stuff friend? Dr. B was trying to help wash the mug and it fell. It happens. Kayla in the chat asked, EDB, why didn't this get charged as a RICO charge? I think it's, one, conspiracy gets you where you need to go with all the evidentiary things in co-conspirator statement. 2, RICO needs predicate acts, and you would have to really argue that they're running everything through the business. And with the amount it seems that they were trying to keep things away from Harvey, though they were using the business to improperly pay Catherine McBanawa, I don't think they were using the business as an organization. They weren't doing things through the business to lead to the murder. They weren't regularly committing crimes with the business that we know of or that have been charged the way that was alleged in other RICO cases. There has to be a pattern of behavior. This was one crime. Even if they have fuckery going on with the IRS, which they well might, it still isn't like IRS fuckery and then kill the ex. It doesn't track in a consistency of pattern of racketeering behavior. So RICO doesn't fit the facts, and conspiracy absolutely gets you there. Conspiracy gets you the co-conspirator statements. Conspiracy allows you to bring in what other people did. Conspiracy gives you all that kind of evidentiary leeway, and there's no other charges to bring in. Like, one of the things they really lean on RICO for, especially the feds when they do it in an organized fashion, is other bad acts. So RICO really lets you bring in all those past bad acts that even if they've never been charged, like we saw in the Diddy case. So they bring in all this other stuff and Kid Cudi's car and the rest of it. And in bringing in all those other bad acts, they're allowed to do that because of RICO. You couldn't necessarily do that in conspiracy because it could be 404'd out, character evidence. It might not be relevant. In RICO, it's relevant because you need that pattern. In conspiracy, you don't need that pattern, but there's no other bad acts they're going to be charging here. They're charging the conversations. They're not charging that this family's operating like a crime family, no matter what Charlie thinks in his head. Charlie is a legend in his own mind. But that doesn't make it so. As much as Charlie wants to be. So that's right. Member for 43 months. Me, please tell me you're not home right now. Yeah, the stress. The stress of what is going on. It's immediate. It's like when the school calls, those of you that have had school age kids have be on the emergency contact form. The first thing they normally say is, everyone is okay, but, when Travis got stitches, and I don't even remember what grade it was because Travis gets stitches. It's shocking. It was, Travis is okay, but he did fall and he does need stitches. Could you come pick him up? Like everything's okay. However, they lead with everything's okay because we naturally get stressed. We're humans. We get stressed. And a lot of times that stress exhibits itself as anger. It's, like fear and anger can go so hand in hand. But I had never seen Wendy's call from the police department that they showed in closing. I didn't hear fear or anger from Wendy. Mom, I'm okay. The kids are okay. But Danny, and then Mom gets interrupted. But Danny, yes, you can put me on speaker. When you leave, why is Donna interrupting when Wendy's trying to tell her what happened? And she says, we're okay. You start with we're okay. And then it's like, and what happened? And she is just like, I'm at the police station. She said it twice. But she didn't sound... She did say, I've been here all afternoon. And maybe that gave her time to just... But yeah. Heather's Budgeting said, I immediately called my BF prepaid right inside our addition because I saw a wreck 3 houses down with a silver car. How you're not worried about your kids? Yeah. Oh my God, that's not you, is it? Everything's okay, right? Yeah. Now that the trial is over, super note review, please. We will definitely do a super note review. We'll talk about it. I've really enjoyed using it for trial. I like the writing experience. I like the organization of it. Remarkable goes and releases something completely new. I had no idea. Everybody got like review units. I was like, yesterday, my YouTube was just like, Supernote has like a new thing. I was like, I don't need another new thing. I just got a new thing. No more new thing. Oh. John Doe said, so what about Donna only helping after the fact? I think the prosecution did. No, let me back up. I think the defense did a good job of pointing out, what did Donna intend before? Was there premeditation as to Donna? Did she intend that Dan Markel got killed? You can use Donna's behavior after the fact to inform what she knew, but did she intend for someone to carry out this murder before it happened? Just knowing after the fact is not the way they charged it. So just helping after the fact does not get you to first-degree murder on these jury instructions. So, we'll see. Stupidity Ensues says, I believe Wendy will be next. We'll see. I don't know. But I don't know what they know. And I do think the prosecution has been methodical in making sure that they know what they're arguing. Though the prosecution felt a bit rushed at the end of the day. A lot of you have asked, I didn't realize we had binged at what, 8? Are we at 8:52? I don't know if I put that in here yet. We might have to do it tomorrow. I might have to owe you one because I did not load it. Look, here's where we were at with our new streaming software. We were at, let's roll it out after this trial. And then we had that full day of an outage and couldn't stream at all before this trial started. And then we were like, you know what? We're just going to ride for this trial. So we were not all the way ready, but we were ready enough. So don't worry, we'll get it. We'll do it. We'll do it. I owe you a bing. We have some more stuff we need to load into the software. We were moving fast to move in while we were still in beta testing, which is always nerve-wracking, but it's fine. Move your head. We binged. Thank you, chat. Here's the thing about live streaming on the YouTubes is we have tons and tons and tons and tons and tons and tons of viewers. And a lot of y'all are just like, it's fine. You're going to let me know in the app. We have lots of you in the app. We're going to let you know in the app when something happens. And you're going to see that I'm live on YouTube. So I love that y'all subscribe because it lets me tell Griffin, look, I'm a real YouTuber, and he still teases me about it. But yes, we are just like cruising towards 1 million, aren't we? Streaming is dynamic. Sherry said, I'm concerned that that will be the thing that gets Donna not guilty. The part about her not having evidence of proof before the act. It's up to the jury for sure. Yeah. And that is one of the things the prosecution needed to point out in their closing. And I think they said, look, all of these things show who is the most invested, who wants this problem solved. The email that I'm surprised that the prosecution didn't bring up more was Donna telling Wendy, and maybe it's because they have plans for Wendy. I don't know what their plans are, but Donna telling Wendy, look at what this has cost us. You get on side, get on side. Get it together. Get it together, Wendy. We're not taking the L on this. I've invested too much. Your father's been through too much. We've lost money in our business. We've done everything for you. Get it together. You can't stop fighting. You get in there and give the performance of a lifetime so we get the result that we're in this for. Do it. Get your butt up there. Give the performance. You don't get to back out now. That email was before all of this. So those emails in the divorce were telling, but they did not say, well, we need to take him out. They didn't say that. So it's really going to depend on how the jury sees this and how they see Donna in the courtroom and those calls. Ninja Catherine said, you just asked if you were on the jury, would you feel like she's yelling at you? I am in my own home and I feel like she's yelling at me. There is sometimes a fine line between more energy, more passion, more energy, more passion, and I didn't do anything, counsel. Jeez, stop. Oh my God, stop, please stop. Oh my God, why is she yelling at me? And it depends where each attorney is coming from, and it depends on where the jury is coming from. But I was a bit put off by defense saying, don't y'all fall asleep, and then proceeding to just yell in the direction of the jury. I think she was trying to illustrate incredulity. But then she got real soft with her voice, didn't she? Donna didn't do that. What did Wendy do? The fist banging and all of it was much. Just much. Orbiter said, EDB, have you ever been involved in a case in which the verdict agreed with the evidence but morally felt it should have gone differently? No. There were, but then again, as a prosecutor, I was used to distinguishing that when I'm just like, I know you did what you did. You know you did what you did. I do not have the evidence to prove that you did what you did, so we're not even going down that road. So I was very used to distinguishing, like, what I might think is true vis-a-vis what I ethically think can be proven. And you get, or at least for me, separating those two things out was not hard for me to do. There's times it's frustrating. There's times it's really hard to explain it to victims that are involved. That, no, I 100% believe you, but this is where we're at. That was difficult. But no, the thing about being a prosecutor is you have discretion and you can say, I'm not doing this. I'm not going forward with this case. This is not the right result. And there's times, I mean, when jurors came back with verdicts, I understood where they got there. There was a hung jury I did not love, but I understood why it was a hung jury. I'm like, I mean, I get it. I don't agree with you, but I get it. So there, stuff like that. But no, I didn't feel like, I mean, if the verdict agrees with the evidence, I'm not putting on a case if I don't think that it can be proven beyond a reasonable doubt. I had friends' cases who I was like, I don't even know how your jury got to that conclusion. But those weren't my cases, so it's not really mine to get involved with. But there were times I'm like, they did what? But when you talk to jurors in jury selection, you can kind of tell where the vibes are. And so you can see. But if a jury hangs and you don't agree with that, you're like, all right, well, we'll just try this again. Because it should be tried again. But no. Estimate on the verdict. We are taking a poll actively. Let's see what the poll says. 43% of you are at 6 hours or less, which is going to be sometime earlier in the day tomorrow? Yeah. I don't know. When you have a heavy case and a lot of circumstantial evidence, a jury is going to want to talk to each other. So it's easier, I think, when the defendant testifies to come back with a quick verdict. That's how I see it. Rosalind, good to see you. Said thank you for chaperoning us to Tallahassee. I mean, it's been, though it feels like we've been on a roller coaster, the lawyers were doing their jobs. There were definitely times when I was like, defense, really? But also, the grace I extend for the defense, maybe not verbally enough, is that they are also trying to manage their client. The prosecution doesn't have to do that. So the defense gets to lawyer, but then they also have to manage Donna with them. So they have to bring her along with all of that and keep her in the loop and explain and consult. They don't get to just go. And so we saw a lot of that. Plus, preparing for trial when your client's in custody is different than what we've seen, like particularly in the Karen Reed case. Karen Reed could spend evenings talking to her lawyers in a conference room while they're eating whatever for dinner. She could sit there and brainstorm with them. You can't do that after a full day of trial when your client is going back to lockup and you can't necessarily get to lockup. You don't get to do all of that. So I get it. There were times it was real frustrating, but also they need to explain to their client what's going on. So, let's see. Did we figure out why the reporter was making a face? No, I was just surprised by it. The reporter's face was facing. Let's see. Was it approaching impropriety that the defense got close to saying that it's okay to hang the jury? She definitely insinuated it. She definitely was arguing more towards a hung jury than a not guilty, I think. She was like, one person, just stand your ground. Because if you do, then there's another procedure for that. It was getting close. The prosecution did not object. There were a few things that were probably objectionable. The prosecution was just like, nope. Which also takes restraint when you're in court. Lawyers are a competitive bunch, generally. And sometimes you can get so in trial mode that the discernment of pausing and being like, I'm not objecting, I'm going to let them run. Sometimes you hear the thing that's wrong and you're just like, the objection is just so right there. But that's a strategic. Choosing not to object is a strategic choice. And for the prosecution, it can feel heavy-handed if you are constantly objecting to the defense, if it is a thing that they think doesn't matter. So we will see. Wishfully, said my husband doesn't even like me to call him because he stresses out and instantly thinks there is an accident or something. Yes, exactly. It's like, what is wrong? It is during the workday. What is wrong? What is happening? What is wrong? It's what is wrong? So the court reporter was definitely facing. If I were Donna Adelson, I would use the live feed video to claim the court reporter's reaction negatively influenced the jury. We might see the defense bring it up at some point. The court reporter was there. The times that we caught it, I'm like, court reporter's face is facing. From where the jury is sitting, I don't know how much they can see because they're going to get the profile view, but she wasn't looking at them. But yeah, as defense, you bring up all of it. So we will see. Let's see. Technically out or technical out said I'm Piney Woods on the second account. YouTube and the accounts. Yes. They live for your coverage. We yelled and guffawed simultaneously. Defense counsel was not likable and did a slipshod job, in my opinion. This would have been a case where if defense had said, look, you might not like every argument we make in opening, I think it would have gone a long way because there were good points in defense's closing. Better points than she made in her opening. But the way they were delivered might shut some jurors down, especially if jurors have, there are jurors that are just, once you start yelling at them, it's going to put them into like fight or flight. And they're going to be like, and they are not going to be able to discern. You have to be mindful of how other people learn and listen. But I think it would have gone a long way if the defense had said at the beginning, we are doing our job, and there might be arguments that we make that you don't like. There might be hard questions to ask witnesses, and that is part of our job. And honestly, if I'm a defense attorney, I'm stealing Yannetti and Alessi's line every single time. I mean, if you have a defense. We just ask that you keep an open mind. Listen to all the evidence. Wait for us. We have witnesses too. Keep an open mind until we get to the end of this case. Wait for us. Because we think the evidence will show at the end of this case that there's not evidence to show that my client did this. There's not evidence that connects my client directly to this. Just wait. There will be things that might make you not like my client that she says. You're going to see those. But just wait for us to talk about it. A lot of you are pointing out Poot said something similar. He did. He said, y'all aren't going to like me, but I'm doing my job. Don't hold it against my client if you don't like me. Poot absolutely did. And I think it can go a long way. You're not going to like every argument we make. You're not going to like the way we question some witnesses. That's our job. That's okay. Don't hold it against Donna because Donna didn't know. I agree with you. KM in the chat said the closing was much better than the opening. I think much better points were made in the closing. The yelling is hard. The yelling is hard for me. It really is. I do not like feeling like I am the one being screamed at. And I'm like, counsel, you're losing your points under all the yelling. But some jurors might not be put off by that the way that I am. Some will be, some won't be. RS, this is already on the docket. RS said, can you look at Eminem's trademark battle with 2 of the Real Housewives? It's in my docket. Also said stalker got 17 years for breaking into his home and found him. Yikes. Ex-employee arrested. That's a lot of Eminem stuff. Ex-employee arrested for selling his songs. That I saw. Details are wild. Interesting to discuss. Eminem, there's a lot on the docket. This is on the docket. I'm sure there have been lots of comments that my brain has filtered out. It's like, what's next? I have some travel coming up. Don't worry. We will get to what's next. We will look at Cardi B's trial. We will look back at some of Charlie Adelson stuff. We might need a little distance from Charlie Adelson for just like a minute, and then we'll look back. But don't worry. We will look at it. So we've got some stuff on the docket we need to catch up on because there's stuff going on in other cases. Michelle said, thank you for telling us to watch her face. I would have missed it. It caught my attention. And I figured if it caught my attention, it didn't just catch mine alone. Moo Boy Moo said, if the jury comes back, will you go see 9 Inch Nails? That's a show I like to see maybe one day. Oh, I need to talk to Dr. B about it. Because they are coming to Nashville. Well, either way, it won't be while the jury's out because they won't be playing while the jury's out. So it'll be fine. John Doe said it was a mistake not to charge Donna as a conspirator for covering for Charlie. I don't know. I guess we'll see. I would need to do a little research in Florida because I'm curious if they could have gone after the conspiracy after the fact only, but I wonder if the sentencing for co-conspirator after the fact is substantially less. Because if the prosecution's looking at co-conspirator after the fact, like accomplice after the fact or aider and abettor after the fact, and the sentencing is substantially less, I can see the prosecutors. I do not doubt that the prosecutors believe their case. And I can see the prosecutors being like, no. Look at those texts. Look at what she said. Look at everything leading up to it. Look at how she is pushing and pushing and doing this and that. No, we're not going for it, but we'll see. I mean, the prosecution also didn't fight today when the defense said, can we get rid of the lesser includeds? Because second degree carries life. The prosecution said, that's fine with us. They're confident in their case. And they do not seem to think that Donna didn't know and that Donna's kids just pulled her all into this after the fact and went, oh God, Mom, we fucked up on this one. The prosecution is like, no. Donna was the one driving this forward. Music to my soul, good to see you in the chat, said Emily, today's the anniversary of my mom's passing. I'm sorry, it's definitely a hard day, but getting to enjoy your stream and chat with the Lawnards here made it a little easier. Thank you. You are welcome. May her memory be a blessing. Look, the whole defense that Donna's just a mom and a grandma, it's kind of offensive to all the good moms and grandmas because no matter what you think Donna did with regard to what she's been charged with, the emails, the emotional manipulation, the twisting Wendy inside out about certain things. It's really uncomfortable to listen to the calls, to look at the emails, and then she's not doing anything for her brother. She sends prayer hands. Fuck you and your fucking prayer hands. Just bury me in this dress. It's just like, the manipulation. It's real difficult to watch. And Jessica H. said, EDB, love your brain. Thank you. Love watching trials with you. I love watching trials with you. Do you have an opinion on whether or not Wendy's indictment may be coming after watching this trial? Sorry if you've already answered. Jessica H., no worries. There is more I want to know about what Wendy did or didn't do. Because what I see is that there is a lot of texts that indicate that, like, we've protected your sister from everything. So if you're Wendy's defense attorneys, you're immediately leaning into, Wendy didn't ask her family to do this. Wendy didn't even want to move. Wendy was afraid of her mom. That's the defense arguments, right? Wendy was afraid of her mom. Wendy didn't want to back down out of this motion because she wanted to save face with her mom. She was emotionally manipulated. She was never able to stand on her own 2 feet. She didn't know how to tell her mother no, but this isn't what she wanted. She actually liked her job. She wanted to stay. She was like, maybe it won't be that bad. But my mom is just like, do this, do this, do this. So that's the defense argument. The prosecution, based on what we saw just in this trial, would be like, but Jeff, that made me jump. I think that's Dr. B coming into the office. But Jeff. But again, I've only seen of Jeff what's in this case. So I don't know what he said in Charlie's case. I don't know if there's more. I don't know if that is a one witness to, make this entire case. I don't know what else they know about Wendy. They definitely keep calling her an unindicted co-conspirator. The timing of Wendy not buying the house is real interesting, right? So we'll see. We'll see what they do. I want to know more. So I just don't know enough to give an answer. Like, I hate being the most annoying lawyer ever and just be like, it depends. I know that if they don't have any more, I would be shocked. I think there is much more there. Wedge said, I spit out my coffee when the defense told the jury to take this seriously. Excuse me. They don't think the jury already did? Yeah, she was like, this isn't cute. And I think she was poking at the prosecution's powdered donut example, but that's not to the jury. It's like, y'all, we're taking this seriously. And the prosecutor's over here talking about some garden party and donuts. Are they taking it seriously? But then again, the defense's argument was centered around Donna didn't know, and we're here because Donna said mean words in emails. So that's where we're at. All right, law nerds. I don't know about you. I'm exhausted. We've been streaming for over 8 hours. The jury is out. I don't know if the jury's going to come back today. The poll, 42% of you, with over 15,000 votes, 42% of you said 6 hours or less, which puts us at tomorrow. So if we get word that there is something going on with the jury, we will stream again. We'll just fire this bad boy up. We'll send out an app notification. We'll let you know. If the jury goes home for the day, the second we hear that the jury goes home for the day, I will send you an app notification. I will let you know the jury's done for the day so you can exhale and grab a drink and a bath. Emily, are you just telling us your plans for the night? Yes. And then I have to decide if I want to go get donuts because we've talked so much about donuts. The jury has to be tired. They also might just be done. But Florida can let the jurors stay pretty late. So turn your notifications on the Law Nerd app. If the jury goes home for today, I'll let you know. If the jury has a question, I'll let you know. If we need to stream and talk about it, we will. If I can just send it in an app notification, I will. I'm sure everyone's tired. Go get some food. The jury's only been out like an hour. They need a minute. I need a minute. You need a minute. We all need a minute. And then if they come back tomorrow, we'll stream tomorrow. I will keep you in the loop in the Lawnerd app. I will post in YouTube in the comments, Emily, in the post the best that I can. Those don't always notify. So the app is the best way. Rebecca says, will you be streaming tomorrow? If we have a verdict, I will. I'm gonna see where we're at in the morning. Let's see where we're at the end of the day. But I'll keep you posted. So when we know something about the jury, we will let you know. If we need to stream, we will fire up a stream. But they're going to take, I don't know if they're going to take their time tonight, if they're going to do it tomorrow. We'll see. Either way. Tina said, wait, I haven't got the app yet. App Store? Yes. LawnerdApp.com or the App Store. I will see you guys soon. All of you are like, I'm going to go make banana bread. I know, I am hungry. I am ready to go. We have the app calibrated and ready for notifications. I mean, app don't fail me now. We will let you know, and you will see us go live on the channel if we need to go live, but we will keep an eye on it. I don't know what they're going to do tonight. It's not unreasonable for them to sleep on it and come back tomorrow. It's a big decision. Defendant didn't testify. I wouldn't be stressed if the jury doesn't come back tonight. If we get to the end of tomorrow before a weekend, we'll have a different conversations perhaps. MJ said, will you let us know when they go home? I absolutely will. I will let you know when the jury is done for the day. Drink bath. Then you can take a drink, get a bath, do the things. Lawnerds, you're the best. Team Baker, thank you. To everyone who has been over on the Emily Show channel that has been living for our case briefs, thank you, thank you, thank you. Our team has done incredible work making sure the case briefs get out. For those of you that are like, I literally couldn't listen to Charlie Adelson's voice anymore, thank you for the summaries. You are welcome. So I will keep you posted. Bobby Ness, will you let us know what donuts you end up getting? Oh, from now until they are no longer in store, Dunkin' Pumpkin. 100%. If I'm at the airport, Voodoo Donuts, chocolate old fashioned. But Dunkin' Pumpkin, y'all, September 1st, I'm like, happy Halloween, everybody. I am a basic ass pumpkin loving. Get me a pumpkin cream cold brew. Get me a pumpkin donut. Get me a pumpkin spice. Literally everything. So, like, it is September. And then October. And then November. And then December. We're going brr. It's cold in here. I said there must be some clovers. I mean, to be fair. In the atmosphere. I'm ready. I'm ready for fall, people. I am ready for fall. Get me some boots and a sweater and some leaves falling. Fall is my favorite. I am so ready for fall. Please let it be cold. And all of you are like, Emily, football banned. It is band season again. And band season where I'm not feeling like I am about to die of humidity. It's cold band season. I'm ready. I'm ready. All right, Lawnerds. I'm going to keep an eye on this. I will let you know. I'm going to get some food. We'll see what this jury's going to do. But I bet they're ready to chat. Okay. Has the Duncan Spider returned? We're going to keep a watch for the Duncan Spider, but not yet. I've not seen the return of Spidey. I think Spidey's an HR issue, but we're going to have to wait and see. Lawnerds, you're the best. Thank you for joining me. Thank you for making this the number one channel to watch live trials. It is so good to see you. Lawnerds, thank you for your patience with the one person a day who is required to come in and be like, why is she talking? Thank you for reminding them that we do not do trial by interpretive dance. I appreciate you. Every trial. There's talking. There's talking. Apparently, there's all the talking from Donna too. I'm still not over that. I can't. When we wrap up after the most extended Bimbusk goodbye ever, immediately going to text Judge Abby and be like, this defense attorney's closing. Donna can't help herself but just run her mouth. That was okay. Lawnerds, we're on verdict watch. Will I see you tonight? Will I see you tomorrow? I don't know. 42% of you think I'll see you tomorrow. Well, it's more than that because 42% of you said 6 hours or less. 17% of you said 12 hours or less. 6% of you said 16 hours or more. 6% of you were like, somebody's got questions. 35% of you said 3 hours or less. So, and congratulations to everyone that won the poll that the defense scooted. They boot, scoot, and boogied right around that script. That script, man. Do you think the jury wants to look at it immediately? Like, if you're the jury, are you just looking at Donna's handwriting? Like, what did Donna say? You're looking at that script immediately. Because why are you writing that script, Donna, if you didn't know? If Donna didn't know, why are we looking at the script? I know. I don't know either. It's a real good question. I'll see you guys when we need to chat next. Who knows when that will be? Stay tuned on the app. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.